on submission.
Yes. Huh?
On that day, respondent sought time, but interim order was not extended.
So what to do? For that you will make a mention again today. Are you not supposed to do on that day? Well, then why should we take up? No, just casually you cannot because the court is granting. Yes.
Being spoken to minutes on the aspect of not interest, which is not modified by this honorable court from 9% to 6%. That is not carried out in the operative.
Reflected in the order.
Please note,
That's not reflected in the order.
it's not reflected.
Yes.
And minutes, I move two fresh matters minutes for stay on Friday. Two fresh
Why insurance company is so busy, not even able to move till the last day? Yes.
matters.
Your Lordship, pertaining to family court matter, attachment of the wife's property by the court, it belongs to the wife actually, for, he has filed a suit for attachment before judgment.
When was the order
Recovery
passed?
and the memo was moved on
When was the order passed?
last month, Your Lordship. And we filed the petition because another matter, contempt he has filed.
No, even after last month you have filed.
Yes.
Till now you didn't have the time to move the court.
I filed the memo was already filed, Your Lordship.
When was it?
20, on 26th, and the date was given today, Your Lordship, 29th.
Why it is
They are
not-
not officers, because
You have not compared with the office objectives.
no,
till
there
now.
is no officer at all, officer, because earlier by mistake MFA has been filed. The court has of the view that it is not maintainable because family court matter. I filed a writ petition, and that MFA also permitted to be withdrawn. That also order was passed. So problem is that, Your Lordship, the wife has borrowed loan and
Yes,
today 2:30,
No.
please.
Friday.
Because second, I want to be in station, Your Lordship. Kindly request, humble request. Kindly accommodate, even end of the list.
Don't
No,
you see
short,
that,
even
then
copies,
Then it is your client's problem. If you're not there, let your client go to.
kindly accommodate.
No, no.
Anyways,
Friday it will come.
Please,
If you
my
want to come,
my
you come
colleague,
and argue.
please.
others. Yes.
My lord, the family court of Tumkur has issued a warrant, my lord, for non-payment of maintenance amount, my lord. Last date of
When
hearing,
is that order? When is that petition?
my lord, on 17, I have paid certain amount, my lord, warrant has been recalled. Again, the court has directed me to pay the amount on 3rd, my lord. If otherwise, I am going to send to the prison, my lord. Every time I am making to sit in the family court till evening, my lord.
If you
Small
don't
amount,
pay the amount, what the court will do?
My lord.
Why would this court
no,
interfere in
my
that?
lord, my lord, half of the amount I have paid, my lord. Half of the amount.
Execution is not for half of the amount. Execution is for payment of the amount.
No, payment of amount, my lord, into 125 CRPC, my lord.
So
125 CRPC, I have paid 50% amount, my lord. Yet 50% to be paid. This small amount, my lord, it is not so big amount, my lord. But my client, it is very small, big amount, my lord. Maybe taken in the afternoon, my lord.
will not be taken.
It is my Friday, my lord. My client request me. Other warrant is issued, my lord. 3 times warrant has been issued, my lord.
When is that writ petition filed? That's what I'm asking you.
Yesterday, my lord. Kindly consider my.
Friday. Yes.
Lord, the respondent has initiated execution proceedings, my lord, and
First,
attachment
before
warrant-
making a mention, tell the court writ petition of which year, impugned order of which year. Then you can tell the
MFA,
urgency.
my lord, it is the year of 2025, my lord. It is appeal of the KSRTC, my lord.
Hmm.
It is, attachment warrant has been issued, my lord. We have filed the appeal on.
With how much delay?
My
With
lord,
how much delay?
6 months, my lord.
Then why should the court grant you that right?
Lord, attachment warrant has been issued, my lord.
So
Kindly have it on file.
let it be recorded, let the warrant be executed so that KSRTC will know that they have to file appeals on time.
My lord, warrant has been issued 1 month.
That's what I'm saying. Till warrants are issued, you will not file appeal and an order is passed. And the court at the flagrant has to interfere with all this. No. Yes.
Lordship, this is a fresh matter. We filed it on 8th. The impugned judgment was in February. There was a Lordship, there was a OI suit along with the criminal miscellaneous. The lower court, what it has done, they have passed an order in the both, and they passed the order stating to give the maintenance of 15,000. Along with that, in OI suit, they have passed a decree to pay alimony of 20 lakhs rupees, Lordship. On 8th, we filed an appeal before the court, but still it is not listed. And MFA what is listed and it has been stayed, Your Lordship. And it may be listed on tomorrow.
Yes.
Memo is being filed for the second time. I had already moved it on 22nd. It's a CP matter, transfer of keys. Kindly can
Stay
you
is
move?
there.
No, we are asking for stay.
Fresh matter.
Fresh matter.
It will be listed on Friday.
Confirmation, my lord. Same, yesterday also we moved some memos for stage, my lord, actually for our execution attachment has been issued by the respondents, my lord, already. So we are already.
What they can do, date given matters itself for 80 of
ma'am.
other bench.
Yes, my lord. So
What to do?
kindly on Friday, my lord, at least kindly, my lord.
Look at it, why it is not numbered or why it is not listed.
Your Honor, writ was disposed on Friday, 25th court, with directions for family court. Family court is asking for a copy of our order for it to follow the directions. So I'm essentially, with your kind permission, would like to move memo for hand delivery of the orders so that I can deliver the orders to family court.
They have the urgency. What is your urgency?
Your Honor,
Others have the urgency, isn't it?
Your Honor, you have given direction for family court to execute the order on 2nd May. So unless that order is before the family court on
It's already uploaded order. Look at the order. Order is already uploaded yesterday.
I just checked it.
It is uploaded. It is already signed by
Oh,
me
is it?
yesterday.
Okay.
Yes,
I'll follow.
yes.
Your lordships, list to serial number 10, your lordships. And for the,
Adjournment. Page, list number 1, page number 11, list number 1, page number 11, 46 to 49, 12, 50 to 55, 13, 56 to 64, 14, 65 to 73, 15, 74 to 79, 16, cell number 80,
My lord,
number 2,
80 is fine.
80.
No, your lordship, I prefer clement in this case. Number of time come before the honorable court. Withdrawal of the amount is some either. Permitted withdrawal of the amount.
Senior out of station only there.
State apparent the same
Withdrawal of
submission.
amount, senior
Please, your
presence is
lordship.
not required. We will see.
Please.
If you are not on liability or on some other things, we will grant them or else will pass. But that senior presence is not required. Yes.
Number 2, page number 8, cell number 27 to 34, page number 9, 36, page number 10, 37, page number 12, 39, page number 12, 39 to 44,
Serial number 44.
44.
It's a connected matter. 44 and 44. As for the claimant, other side I have been informed.
Yes, after vacation. You are for the petitioner. Appellant. Respondent has filed for release of the amount. Yesterday. No, yesterday some calculation is made.
No, my lords, I have asked the other side, my lords. She said I have not given anything. Kindly post it off.
No, she was there. RTC, they were there. What are 44 and 45 today's list?
I have instructions to submit. By 2:30 we will make calculations. Some files are not traceable, but they will see the MBC orders. And they
Just
will-
wait.
But
Yeah.
2:30
If
will
it
not
has
be
to be
done.
adjourned, we will see.
Whenever KSRTC is there, submissions at 2:30.
Yes.
your lordship, serial number 10, your lordships.
Then in which list?
List to serial number 10. And for the petitioner, the matter was listed yesterday. The senior counsel could not appear before your lordship because she was on her legs in another court hall. It's listed today. I've also informed the opposite counsel.
This is the matter which yesterday was passed over. So I'm.
Serial counsel will be present today, my lordship. If it can be taken up by 1 p.m. or.
But you will ask now. You will make a mention and say that senior counsel will come. You can wait. Junior counsels are there for that. You have to wait. When the matter is called, then you can submit.
Please, my lords.
That you can inform the other side counsel.
I've
not to the-
already
They
informed, my lords.
They asked me that they are going to make a mention to request the court to take it up at 10:30 itself. So please be here. So I am also here. But now
Why
he's
will the
saying
court
1
take?
o'clock. No,
Why will
it is-
the, no,
exactly,
why
I
will the
said-
court take a matter at 10:30?
Exactly, I said
And
it's
even
in the list.
at least the junior advocate should know, you can't ask for a passover or make a time that take it up at
Yes.
1 o'clock by mentioning it.
We have to wait.
Call the list.
List number 1, parted matter, cell number 1, Pramodar.
The dead case, my lord.
This is when lump sum 120.
120.
Lump sum
120.
120. it is submitted that the RTC is ready to pay an amount of rupees 1,20,000, a lump sum amount in addition to what has been awarded by the tribunal, and a joint memo will be filed today before the Lok Adalat, list before the Lok Adalat. 2.
Serial number 2, K. Prasanna Shetty.
In this matter, there is one more insurance appeal in this matter, my lords. Kindly, it may be connected, my lords.
What is the
Appeal number
number?
6877 of 2023.
Admit post of final hearing, TCR, delete from part third after vacation. Give them, write the number and give. Yes, next.
Serial number 3, for orders, Vishwanath K. Furnishing of
Pradeep, what is this?
upside.
There is a company appeal, my lord, 3372 of 23, regarding liability.
To
Has
So
to be-
questioning the liability.
Please, my lord. Has to post along.
In 3, the process shall be paid, the needful shall be done within a week, or else default order. And it is submitted that there is a connected appeal. Write it and give list along with that.
Serial number 4,
Yes, memo for acceptance of paper publication. Accepted. Yes, notice to so and so, R3 is self-sufficient. Next,
serial
in the
number
name of R3 in the cause list. Next 5.
5. Serial number 5, Raju S. Furnishing of for the first state.
A week's time
Serial number
for process to the R1.
Serial number
6.
6, memo for dispensation of.
Memo is for seeking dispensation of notice to R1 dispense with at the risk of appellant. You appear for R2. Mr. B. Pradeep is directed to take notice for R2, and the counsel for the appellant shall serve the copy of the appeal memo on the counsel. Admit post for final hearing.
Serial number 7,
Call for the DCR. 7.
I appear for appointment, pay for a week's time to take steps.
1 week.
1 week time.
Second,
Take steps.
no, this liability is on whom?
Claim,
Owners of the
claim petition is dismissed.
claim petition dismissed. For steps, a week's time, default order.
Serial number 8,
Await service of notice, list after service. Next line,
9,
this also same.
await.
10,
Serial number 10, memo.
memo
for
is filed seeking dispensation of notice to R1,
And
dispense with, R1 and R3 dispense with. Your appeal is also there? Admit post for final hearing.
But his counterpart is not agreeing that, you know, this is the amount we have seen, what should we pass it in this? Do this. Because of interest. Payments upon.
Judicial
The
adder.
event is not agreeing.
Judicial adder is
10 and take out the next mark.
55 mil.
This is MVC number? MFA,
MSc number.
there are 2 calculations. No, before me it is 6496 arising out of 7? 7444. Agreed with the orders passed, award passed in MVC number 7444 of 2018, dated 18th July 2023. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakh for the injuries sustained by the claimant in the accident. The tribunal, by order impugned, had granted compensation as per the table given below. At page number, a lump sum amount is granted in this.
Please, madam.
Tribunal had granted an amount of rupees 5,000.
Second
5,000.
case, second case is 5,000.
Granted compensation of an amount of rupees 5,000. Agreed thereby, the claimant is before this court. Learned counsel appearing for the claimant submits that as per the wound certificate, he had sustained hematoma at right temple, laceration of left parietal region, left posterior hip dislocation, and the injuries are grievous in nature. It's a case of death.
He has died due to COVID. So, incidental
And
charges
Exhibit P20, death summary issued by the hospital reveals that the deceased was admitted on 12/6/2021, but he died on the same day due to severe COVID-19 pneumonia with ARDS. The tribunal has observed that the LRs did not place any disability certificate issued by the competent authority to support their claim to establish that the deceased suffered from physical disability, and they are not entitled to get any compensation on the ground of disability. They have spent about an amount, according to the claimants, they have spent an amount of rupees 1 lakh towards the medical expenses and rupees 50,000 towards food, conveyance and nourishment and other expenses. And the court also observes that they have not produced anything in this regard. Hence, the court had granted an amount of rupees 5,000 towards conveyance, transportation, nourishment and other incidental expenses. In total, a compensation of 5,000 is granted. Then counsel appearing for the claimant submits that when the claimant had sustained injuries, grievous injuries, and later he succumbed to the same, and the court ought to have granted the compensation. Then counsel appearing for the respondent insurance company submits that the court had rightly considered, and the fact that he died because of corona, but not due to the accidental injuries, and the court had rightly granted compensation when there is no evidence on record. Next, having got the counsels on either side, peruse the material on record. As rightly held by the tribunal, the claimants have failed to adduce the cogent evidence in support of their case, and they have and the evidence also shows that he had died because of during the pandemic. Considering all this, balancing the interest of both parties, this court deems it appropriate to. It is a global compensation.
Global, 30,000.
This court deems it appropriate to grant global compensation of an amount of rupees 30,000. Accordingly, the appeal is partly allowed. Now, coming to MFA number 6452. Serial number
6452.
Tell her the number. It is here.
6496.
Serial agreed with the award passed in MVC number 7443 of 2018. The claimant is before this court seeking enhancement. The tribunal has granted the compensation as per the table given below at para number 31, page number 32, or internal page 22. The tribunal had granted an amount of rupees 4,58,439. Then counsel submits that the tribunal had awarded, when he had sustained the grievous injuries, court had granted only an amount of rupees 15,000. Further, for the loss of immunity is also reasonable amount is not granted. Then under the head of loss of earning during the later period, court had considered the income of
12,500.
no court is not considered. No amount is
12,500. Not granted loss of income during later.
Not granted.
Loss of income is granted.
The court had not granted loss of income during the later period. This is also lump sum.
Please, Milord, I have calculated interest also. 98,000 would be the interest.
And it is submitted that the amount that is granted by the tribunal is on the lower side. Then counsel appearing for the respondent insurance company submits that the tribunal has rightly considered and granted the compensation. and there are no grounds to interfere. Having heard the counsels on either side, for a material on record, considering the injury sustained by the claimant, and also considering the facts that no amount is granted on the head of future remedies and loss of income for the later period, this court is inclined to grant an amount of rupees 2,25,000 globally against the awarded amount, in addition to the awarded amount of 4,58,439.
Amount may be released, madam.
That
Amount
will be there, that will be there in. Yes, next.
obliged, madam.
Cell number
Take
11.
these two calculations. Serial number? Can be disposed of. Where is the counsel? 8. Nagaraja is. It is already, it is adjourned. He was not there. We will have it on Friday if it can be disposed. 8 on 8, the serial number 8 on Friday. Yes.
Number 11, Shriram General Law.
Take notice.
Disposed of?
Take notice.
11, sir.
It can be
Madam,
disposed.
madam, we can dispose.
Allah, take notice. Next Friday. No.
When you are getting, just wait and see what is happening.
Yes.
Then if you want, you can ask for adjournment.
Right.
But date of accident, 19 date of accident. Income ondena.
Date of accident is 17/12/2019.
19. EFP. Income was taken by the court below is 10,000.
Pain and suffering, 10,000 is awarded. What is what are the injuries? Let us see.
Injuries are concerned. He was inpatient for 20. Only clavicle.
After he was shifted to Sparsh Hospital, Hassan, treatment for 20 days.
Clavicle fracture.
Surgery for a head injury. Clavicle fracture. 1 lakh.
Doctor has opined that injury grievous to the rest of it simple in nature. One grievous injury.
So, pain and suffering is entitled for 40,000. But there is a head injury also.
But no doctor was examined. No doctor was examined.
No, let us
So
look
far
at-
as head injury is concerned, no doctor has been examined.
The doctor has opined that injury number 2 is grievous in nature and rest of the injuries are simple in nature. So we'll grant 50,000. Then medical expenses,
You stated Madila.
1,65,000. Loss of future income, what is the disability?
Doctors, court has taken 15%.
What is the evidence of the doctor?
30 to 4.
Patient,
Doctor evidence
the medical
is,
document produced by the petitioner
40 to 70% to the limb.
as lost future happens. Where do you get it? Paragraph number?
Page number, in page number 16, page number 8 of the judgment, middle, second, this thing. During the course of cross-examining, he stated that injured has not furnished a document with regarding to the Amma Eye Hospital. He has admitted only the can only assess about the disability with regard to the loss of memory. He has admitted he has shown disability 40 to 70%, not specifically stated the percentage of disability. Therefore, court has taken
both the injuries were grievous in nature. Paragraph number, no, page number 16.
Please.
End of the para, please read the doctor, PW3.
As deposed, the evidence of petitioner was admitted hospital so and so. Petitioner sustained the injury nature swelling tenderness the right shoulder, that is clavicle fracture, moderate head injury, both are. That's what the head injury is a grievous injury, but he has not examined in support of the doctor who has examined.
Oh, he said so, doctor said so, both injuries were grievous in nature.
It is.
So we will have 60 for that. Then, please continue reading.
Please. Immunity on the lesser side.
9.16 in respect of right upper limb.
Please. What has taken 15% to the whole body that we can take and
It was rightly taken.
income has to be increased.
should be taken as 2000.
19 accident, 10,000
Court
is
has
taken,
taken 10, we will take 14.
please.
What is the multiplier?
15 roughly.
14,000 into 12 into 15 into court had taken
15% is about 15%, 15 multiplier, 37 years is.
what you can do, what we do is, we'll make the calculation. You look at it,
No,
we'll
you
pass
can-
orders in the afternoon.
He will
So
agree.
you don't have to
No, no,
worry.
he will agree, my lord, yes.
Huh?
Very difficult discussion.
15
Usually he
into-
will discuss prior to the matter was reached, but he has not. Act.
It's coming to 3,78,000.
Please, my lord. He was in the hospital for 12 days.
20 days. If you look at,
Days?
he was in a hospital for 20
Please,
days.
please.
Pain and suffering, you will see that.
Please.
So it is
Laid up period.
transport, nourishment. It comes to 20,000. Then loss of income during laid up period.
10,000 is grand 1 month. So 3 months it has.
Laid up period, that is 14,000 into 3. It's coming to 42,000.
Please.
Then loss of amenities, how much is granted?
10,000 is.
Another 20 we will grant,
Please.
30,000.
Medical bills 165.
It has to be judicial order or it can be in a Lok Adalat.
It can be. Anyhow, we are ready, my lord, no problem.
So we'll calculate.
Next.
It comes to 6,95,000. What has been awarded is 4,65,000. What we'll do is, insurance company is ready to pay 6,95,000 in addition to what has been
As against the.
as against the award of 4,65,000, it's 6% interest.
Please.
It is submitted that the insurance company is ready to pay so and so for filing joint memo. List this matter before the Lok Adalat at 5:30 today. In the meantime, you can verify. Yes, next. Yes.
6/9, it is calculated, my lord.
With the HD.
Last date of
Which
judicial
is
order
order?
passed because they have not come for.
It's coming to 11,05,000.
Please.
Agreed with the award passed in MVC number, which is the MVC?
844, my lord.
844.
4.
Agreed with the award passed in MVC number 844 of 2020 dated 18/4/2024. The claimant is before this court seeking enhancement of the compensation. Where is the table?
24 para.
The tribunal has granted the compensation of an amount of rupees 7,87,626. Even on the last occasion also no representation. When this matter came up on the last occasion, there was no representation on behalf of the appellant. Even today also, there is no representation. Heard the learned counsel. But it's coming up non-comprehensive office objections.
That is a problem.
You know the advocate?
I know the advocate, but she's kindly pass out the matter. Let us.
Informer.
We will take chance.
Yes, pass out.
Bill number 13.
Waiting for the
But,
Manish B. Baldare.
In this case, we have settled the matter for 95,000. Subsequent
95,000.
95,000 in addition to what has been granted. Subsequently, we came to know that my lord, the insurance company has filed the miscellaneous petition before the MSCT regarding
Review the order.
age difference is concerned. Therefore, this matter may be urgent for another 2-3 weeks. My lord, we will
13, this is matter after vacation.
Bill number 14. Rajiv B.
What about this?
That regarding that maintainability, my lord, I have to relay it upon.
You that? No, Mrs. Shivanagoda, all those matters where they were settled, but they have not come up with a joint memo. Where are those matters?
those cases posted today itself. In the
Only
second
today's
list.
cases are those?
Today.
No other cases? No, if there are, you said there are some other cases. That's what I'm saying. All those cases, when the other side is not confirmed, and all those, you give those, that list. If you give the list, today evening itself will say, post before the court, and on Friday, I'll pass orders.
Please.
Instead of when you've all done the exercise, so please do it and give it to the Mr. What is his name? Raghu. Yes,
Para 9 minutes.
para number 9.
9 minutes. It is the implication from the language applied in section 173 of Motor Vehicles Act, and that when an aggrieved person admits the liability, he cannot question the award if the amount in dispute to the less than 10,000. In the other words,
It is implicit from language employed in section 173. When an aggrieved person admits the liability.
admits the liability. If question the quantum, my lord, not
On
maintainable.
a question of quantum, you
Quantum
cannot
not
file an appeal.
Please.
If it is on the liability itself, even whatever is the
Even
amount, one can
1,000
count.
rupees also we can put it.
So according to you, because you're on liability,
Liability.
still, though it is below 10,000, still you can maintain an appeal.
Regarding that, this another case is passed as in another case. Similar setup. If just for reference. Just for a reference, that's it.
The office has taken an objection with regard to the maintainability of the appeal, since the value of the appeal is below rupees 1 lakh in the light of section 173 of the Motor Vehicles Act. Learned counsel for the appellant insurance company had relied on the judgment of this court in case of Divisional Manager National Insurance Company Limited, Hubli versus Suresh Subroy Sheth and others, reported in AR 2009, Karnataka 3. It is submitted that, basing on said judgment, it is submitted that as per the language employed in section 173 of the Act, when an aggrieved person admits a liability, he cannot question the award if the amount in dispute is less than 10,000. And in other words, that only when the quantum of compensation is questioned, the liability being admitted, there would be a bar for filing an appeal. Learned counsel submits that here the insurance company is questioning the liability on what ground?
The risk of one is not covered. He himself is the owner. Right?
Liability of the insurance company as a risk of the owner is not covered as per the insurance policy. It is submitted that as such there is no bar under section 173(1) of the Motor Vehicles Act. Considering the submission of the learned counsel with the petition in the light of the order passed by this coordinate bench of this court, referred supra, the office objections are overruled.
Let's stay regarding stay.
What is the amount granted?
42,000.
There shall be stay of all further proceedings.
694.
On the condition of deposit 50% of the amount.
Already deposited 50%.
Yes. There shall be stay of all further proceedings. Statutory deposit to be checked later. Yes, 15.
Bill number 15.
15 and 16. Same. You are on what? Same on the maintainability. Yes, same order in 15 and 16.
Bill number 17.
Certificate copy has been produced in the main case, my lord. So it may be over. Total 4 connected matters are there.
No, it is about
1920 of 2025. Other matters, my lord.
Maintainability of the appeal, since value of the appeal is below, even this also maintainability is there. I think it's not there.
No, my lord.
Which file you, huh? 1920, we are looking at,
It's
huh?
also 50,000. Award amount is 50,000.
50,000.
Check issue towards premium flat once. That once.
Counsel for the appellant, maintainability of the appeal, challenging the government's liability and appeal. With regard to office objection, legible, typed copy of judgment to be filed. Legible copy of the judgment be filed. Photo. Where is that? Where is that copy of the judgment?
The connected. Furnish the details. That's the connected. Original certificate copy has been produced in that.
No. What is the difficulty in finding the legible copy in this?
Photocopy of the same.
That's what, where it is, I'm asking.
The judgment. They are saying that, my lord, it is not legible.
If you see, half of the portion in every page, half of the lines are like, you can't even see it. The Xerox is like that. Every page is like that. File a legible copy. Yes, office objection with regard to the legible copy is upheld, and the petitioner shall comply with the office objection.
Serial number 18.
For timing, my lord.
My lord, I am for the appellant, my lord. This appeal is by the insurance company challenging the negligence, liability, and quantum of compensation. My lord, our vehicle was parked on the road. The auto came and dashed against our vehicle from behind. And my lord, the police have filed a charge sheet against both the vehicle.
Your matter is not called. I am still in the matter before you.
My lord, serial number 18, my lord, called.
Just please wait.
I'm sorry.
What you're saying. No, that's there notice. That's there in that. Your submission is accepted. As far as this is concerned, office objection, counsel submission with regard to non-filing of legible copy. Then 17, with regard to the maintainability issue in the light of the judgment and in the light of the language employed in section 173(1), office objections are overruled. Yes. A notice to the respondents. Yes, Mr. Vijay Kumar.
My lord, this appeal is by the insurance company challenging negligence, liability, and quantum of compensation.
Non-filing of acknowledgement for having served a copy on the caveator.
My lord, for the first time I came to know only now, my lord. I am ready to serve today only. I am ready to serve. My lord, I have sought for stay, my lord. Connected matter, your lordship has served. My lord, in the connected matter, my lord, MFA 2836/25, your lordship has granted stay on 21/4/2025.
Mr. Vijay Kumar, from now onwards, will not allow you to appear on online. You have to come physically because you're one counsel. You are not following the court at all. I'm saying it will come on Friday. When a caveator is there, whatever is the reason, you have to serve the papers.
Hello, even
Friday.
if he is before the court, I will make
We will
arrangement to
see.
serve.
We will see. Friday.
Please.
Serial number 20.
Yes, 19.
Serial number
My lord,
20.
my lord, serial number 20, my lord. Again, there is a question of maintainability. Right now, my learned friend has argued, relying upon the judgment of 2009 Karnataka.
Let us see. On what ground you are before the court? Let us see. Give the file.
There are three connected matters, my lord. There are three connected matters, and your lordship has already granted stay yesterday in MFA 2984/25. And another matter, my lord, it is at serial number 64. Totally three matters, my lord. The accident between the Tata Sumo and the motorcycle. Three persons were traveling in a motorcycle. They came and dashed against our vehicle, and we have challenged all the three cases. And this accident is of the year 2019. My lord, the amended act came into force only from 1/4/2022. My lord, that this present this thing is not maintainable because the award amount is 25,000. In the earlier act, only 10,000.
Reduce the full volume. Complete volume. Reduce.
This matter and serial number 64 is connected, my lord. And your lordship has already granted stay in MFA 2984/25. In all the three matters, you have questioned the negligence, liability, and quantum of compensation. I have clearly narrated in para, my lord. Your lordship may kindly see in para 18 of my appeal memo. Para 18 of my appeal memo.
office has raised an objection with regard to the maintainability. That is the same, this thing. Then IA number 1 of 2025 is filed for dispensation, protection of the certified copy of the judgment, dispensed with for the present. Then IA number 2 of 25 is filed seeking stay on the condition of 50%, 25% to be withdrawn by furnishing the security.
But we have already deposited 55,
Yes,
50% of the award amount.
Cell number
Definitely
20,
noted.
Manjula Tejasvi, non-compliance of
A week's time, default order.
Cell number 21, Pradeep B. Regarding
This is also, my lord, the risk of one is not covered. He himself is the owner, my lord. You cannot identify him, lordship. You cannot indemnify him. He himself is the owner. My lordship has already passed a judgment in this regard. 165, a third party alone is maintained the claim petition. The owner itself is the owner, is not maintained the claim petition against their own insurer.
It's an appeal filed by the owner of the
Owner
vehicle
of-
against the insurer for
Injuries, my lord.
the injuries.
This, 97,498 has
The
been.
policy is a third party. Then why they say this maintainability of the appeal against?
Below 1 lakh, that's why.
It's only about that 1 lakh.
Okay.
The office the objections with regard to maintainability is over. Yes, next.
Stay, my lordship.
Stay subject to the condition of depositing half of the amount. In this no release order.
Cell
Yes.
number 22,
Yes, 22.
Latif B.
Appearing for petitioner, my lordship. This application.
Time for complaints of the office objections.
Cell number 23, OPN.
This also a week's time.
Cell number 24, Ravindra.
Why all these memos are moved? Why what for?
Let's hear.
22, 23.
Serve the copy to them.
2024 matter without even complying with the office objections.
Yeah.
Memo is
Complaint.
moved. Huh?
Complaint.
I am referring to 23. 24.
24, Ravindra P.
Serve the copy.
M.
Where is the other side? Non-filing of acknowledgement. Copy to the caveator.
M. Karun.
Serve the copy in the month of December itself.
Then have you filed the acknowledgement before the registry?
Yes, ma'am.
Okay, then why this objection is there?
Yeah, only to the respondent I filed. The caveator is the counsel.
No. Are you not supposed to file it before the section? That's how it is listed.
Yes, ma'am. Only the acknowledgement which has been sent it to them, I have filed it, not the unclaimed post. So I am filing it now.
What is that? No, there is a council. You have to serve to the council.
Council
That's
have
how
served, my lord. On 17/12, I have served upon them.
This unclaimed.
Yes, my lord.
You will serve it through post. You will serve it through post. Why the advocate has no, he's not a practicing advocate here.
Served it.
No. He's an advocate. What is this unclaimed business? You can serve it to the council.
For the respondent, he is being unclaimed. But for the advocate.
Council is there and there is a caveator. You will give it to the council, not to the party.
Last page of that postal receipt, I placed to the council also. Is last page.
Council has accepted. Where is it?
17/12.
That is what is relevant to how the court is concerned with the party.
Last page.
Where is that served? Where is his signature? Where is that served one?
On 17/12, he has accepted it.
Look at it.
That's here. Last week, there was attachment. All the properties of my movables were taken.
17
from my-
the acknowledgement field.
There is a certain observation made by this.
17.
Mixture G.
Caveator advocate accept ಆಗಿರೋದಕ್ಕೆ endorsement ಎಲ್ಲಿದೆ madam ಕೇಳ್ತಿದ್ದಾರೆ. Postal through post only you have sent to.
Why the council is not practicing it? That's what I'm asking you. Why to send the papers to post?
Here, for the acknowledgement purpose, we will send it over.
So all the notices on the councils also served through post here.
If at all, if it doesn't come here, we will send it over.
When is the order passed by this court?
That's here. Certain observations made by this Annexure G. Page 97.
By this court?
By this court.
Where is that order? Dated?
Going into the merits of this matter.
I'm not able to understand.
Mic use ಮಾಡಿ sir. Annexure ಯಾವುದು ಹೇಳಿ?
Annexure G.
Yes.
Page 97, my lords.
Yes.
Last para. This court has made categorical observation and direction. Within 6 months, it has to be disposed. Subsequently, he files application or after application before the family court.
What is this petition about?
This is about interim maintenance, challenging the interim maintenance, wherein already they have sought interim maintenance in criminal miss. Also, they have filed in IA number 5 of main petition.
How is it relevant now, this 97 order?
Let's hear. There are certain direction within 6 months of.
No, you're not on that point. You have come before the court question.
Yes, my lords. Yes, my lords.
So how is it relevant, that order?
Let's
Please
hear.
come to the order impugned.
Let's page Annexure A.
Yes. What is the amount granted?
Amount granted is 35,000 to the wife, or to the daughter, 5,000 to the wife. Wife is also working in.
What is your income?
My income is 30,000. 30,000. Annexure B.
If your income is 30,000, why would the court grant 35,000?
35,000. That is the
Let us
reason.
see, there must be a reason.
There is certain observation. I'll show.
Let us read
Page
para
number
number 12.
22.
Para number 12, please read.
Para number 12, my lords.
Yes. No, come to para number 11.
11.
No, from 10 also.
10 also.
10.
That is what.
Read.
Well, there are bank statements wherein, as per the said bank statement on so and so dates, a sum of 99,000, 5 lakh, 2.5 lakh, 50,000, 5 lakh. So these are respectively were credited to the account of the petitioner. If really the petitioner is getting commission of so and so per month, why the aforesaid huge amount were credited to his account? Well, it's observation based upon the bank statement. They've come to the conclusion. In his affidavit of disclosure, assets and liabilities, petitioner has sworn to the fact that he is paying income tax and producing IT returns. As per the aforesaid bank statement of petitioner so and so, a sum of 13,730 rupees was refunded to the petitioner from income tax department. So and so vehemently argued that petitioner has not produced his income tax in, but he has produced income tax return of his nephew. Well, I also place the income tax also. That is in page.
What about the maintenance you're paying in criminal miscellaneous?
Well, I already paid 3 lakhs. As of now, I paid 3 lakhs amount.
What was the amount granted there?
10,000 per month.
To the daughter?
To the daughter. And
that also you're not paying?
That I paid 3 lakhs.
Then why the attachment?
Well,
you said some attachment before.
In that, that is pending, Malats. Here in this IA number 5, I have not paid any money because due to the fact that this order was passed in the month of October.
So what is the urgency now? Already attachment
Malats,
is over.
here attachment, because they have completely taken away my property. I don't have a table to sit in my house. Everything they have taken away. And this order was passed in the month of October. November, I've been dismissed from my work. Due to the fact that I need to appear before the family court every week, I couldn't go to the workplace at all. Due to that fact.
And you will wait till attachment is
My lords,
attachment
here there is no
executed.
notice of execution of anything. Without any notice of execution of 37/25,
It's
they
all what you
completely,
say. Courts will not do something like that. Without
lords,
notice,
here-
they will not do anything.
really, my lords, here
You
I
say
myself,
you have no
I've-
notice. Whether you have notice or not, the court,
My lords may,
the process will show.
my lords may direct the TCR also. If at all, if I have taken any notice of such kind, there was nothing, no notice at all. They came on 22nd. I appeared before this court in the evening
What was the
also.
order?
22nd, they come and take away my
The
property.
order passed by
Order
the
passed was
15/1.
15/10/2024. This order, my lords. This order. Execution they filed in the
15/10.
15/10/24 was the order passed by.
So what are you doing from?
My lords, I filed this writ petition in the month of November itself. Writ petition, I filed appeal on the very same fact. I filed this appeal.
You know, when an order is passed in the month of September.
October 2024, they filed the execution in the month of February 25.
You didn't obtain any orders in this.
My lords, I didn't obtain the orders due to the fact,
Why? And by order, then the court will
due
execute
to the
the
fact
order.
that, there was
What
no,
notice immediately is the order? Order is passed. It is not after 2 years you will get a notice. It is immediately execution. Why will the notice be ordered?
let's hear. Let's hear due to the fact that after this
So no
order
notice
passed,
is required.
after
Court rightly
this,
did it.
after this order passed, I was terminated from my employment. I don't have any money
There
till
is a
now.
procedure contemplated to how do the order of the appellate, the trial court will be set aside or suspended.
Please.
You can't assume saying that I have stopped that, I've stopped this, so the order will not be executed. So anyhow, whatever has to be done is already done. We'll pass a final order after vacation.
My lords, here one submission, my lords. The respondents approbates and reprobates. She says in the email everything that I don't want anything. She leaves in the year 2005 and she does not come back to me, and she goes to the Goa and
Anyhow,
sit there.
the purpose of stay is to stop something. There is nothing
That's-
to stop now. Already everything is executed.
My lords, here partially they have executed.
You just know you said everything is over.
My lords, here they have taken complete movables of my property. That movables cost around 6 to 8 lakhs. But they say that, it's the value of that property is 1.8 lakhs. Another 1.2 lakhs has to be paid by this, and they'll issue.
Stop it.
That's here I don't have an employment. I need some time so that I'll pay back. If at all, if the court directs there is substantial money, I'll pay it back. That is what my stand is.
What remains? What remains to be
Let's
stayed
hear-
that you tell the court?
My lord's income, I'm earning 30,000. How can it? How can the?
What remains to be stayed? What you are saying is on the merits of the matter. For an interim order, just before the vacation, what is an SCT now? It will be heard finally
Here.
and a final order will be passed. This tactics of moving the matters
Let's-
before the
I'll
vacation
take
will
your
not work
lordship's
out in all
code.
the cases.
My lords,
This
your
is matter
lordship's
immediately
order,
after
your
vacation.
lordship's order may be seen one time, so that what
If
is.
you come before the court with such a relief about an expeditious disposal, it's a different aspect. You cannot have everything in one case. List this matter immediately after vacation, give a date.
Let's see.
List on 11th of June.
11th of June. Cell number
Let's
25.
there is certain orders may be passed so that no coercive action may be
Already
taken against-
coercive steps are over, nothing to be done now.
Maybe further
Whatever you have
also.
to pay, then we will decide the matter.
Maybe further any coercive action.
Already
Because
no-
I'll if at
no
all if
further.
the court directs, I'll pay some amount so that that may be released and then it can.
Why
be-
you pay there only they'll stop? Why should there be a direction from this court? Will not stall any of the proceedings, let all go on. If you succeed in the appeal, then you get it back.
Why? Because my lords, there was observation and direction. Within 6 months, it has to be disposed. April 18, 2024 was the order. After 1 year also
I'm
there was.
asking you, did you come to the court for a speedy disposal? No. You are before the court on an order. If you want a speedy disposal, come before the court. We'll call for it. What has happened and why the matter is not disposed of.
Please.
Yes,
Please.
after vacation, next week.
Cell number 25. Arun Govind Raj for petitioner.
For the petitioner,
No, like that.
Lord, father's petition challenging an order of visitation of the family court granted where overnight custody
What
was.
is this non-filing of the report? What is that report?
Lord, initially, Lord, His Lordship had directed both parties to settle the matter and file a joint memo. That never happened. Lord, matter was supposed to be listed
So
on
what
7th.
is it?
I have moved the memo,
No,
Lord.
let us see the order of the court.
Yes.
What was passed by Justice Arun. During the interim custody of the child, the mother shall be permitted to speak to the child.
25th of March, Lord. The
Overnight
child
custody is given.
Yes, I've had overnight custody now for more than 3 months.
6 p.m. to 7 p.m. for a period of 20 minutes, facilitated by an audio video call. Mother and the mother has access by way of, so that there is some communication between the mother and child and vice versa.
Lord, I've had overnight access since January. And even the spring break, which was there in the first week of April, my Lord, I had half the spring break, I had access for 4 nights. Now the child has vacations, my Lord, school vacations coming up from 16th of May. Therefore, my Lord, the matter was to be listed on 17th, and therefore I requested my Lord to make some arrangement for the vacation, and today's date was given. But the child is absolutely comfortable with the father.
The age of the child?
3.5-year-old girl child.
My Lord, my only submission, my Lord, when there is an interim order from the trial court, he is seeking for permanent custody of the child. That cannot be permitted, my Lord. Anyways, my Lord, it may be taken up after vacation. Detailed objections I'll file. Unless then, no.
What is the order of the family court?
My Lord, an application for visitation was filed along with.
Let's see that.
Yes.
Where is that order?
But annexure M.
Page number?
Page number 78. Married.
Operative portion.
Operative portion.
Yes.
But operative portion starts at page number
89.
89. IA number 6 filed with the petitioner under section 12 of the Guardians and Wards Act, read with section 151 of CPC is hereby allowed, partly allowed. Petitioner is permitted to pick the child, Miss Avika, from the school after the school hours and have custody of the child till 4 p.m. on all school days from Monday to Thursday, and to have custody of the child after school hours till 6 p.m. on Friday, and all other days if the school remains closed on the next day. Petitioner is permitted to have the custody of Miss Avika during festivals between 10 a.m. and 2 p.m. And the petitioner is permitted to have custody of the child during school vacation period from 10 a.m. to 4 p.m. during 50% of the school vacation period. Petitioner shall pick the child from the place of residence of the child and drop the child to the same place after exercising visitation
This is
rights.
such a recent order passed by the court. Why are you before this court?
No, I'm only overnights was not given. My lord, I waived. The child may not. My lords may even ask the respondents' counsel. The child, every time I drop her back, because I live in a joint family with my parents, grandmother, the entire about 50 people live in the apartment complex where we live. The child refuses to go to the mother every single day. I'm only seeking overnight. No, I have 50%. I want to overnight.
My lord.
1 minute.
Yes.
I'll ask you. So what is the age of the girl you said?
3.5 years old.
3.5 years.
Yes.
So when the parties separated?
2023.
23. So she was like 2 years old then?
Yes. I've had visitation throughout. Though we were separated.
No, already the visitation that is granted is I think I have never seen a order of the family court granting this much of visitation to any of the parent. And already, it's a balanced order.
May I
Why
make
do you
this
want
submit?
it?
Well, now by an interim order passed by his lordship in January, I also have Saturday to Sunday. My lord, I have overnight. The child has been coming overnight every weekend and spending Saturday to Sunday with me.
This order is to the order of the other bench is till what date?
It continues. My lord.
Then let it be.
No, vacation is coming up. I'm only requesting my lord for vacation because even the previous vacation, your lordship may kind
You have 50% of the vacation as per the order of the
10 to 4 I have. My lord.
10 to 4 you have.
Overnight, I can take the child out of town. She can, the entire family travels together. But vis-a-vis, the respondent lives alone with her mother. She works, admittedly works. She is not in the position to take the child anywhere during vacation. I'm not asking for the entire vacation. I'm asking for 50%, where I'm allowed to take my child out of town. I've produced photographs, I've placed photographs on record. Your Lordship will kindly see the time that the child has with me.
All the while I was thinking that the family courts are not granting proper custody. That's why everybody is coming to the High Court. But it is something, whatever the family courts grant, still.
But only for
what is
overnight.
But if you see,
it's only that part has been challenged.
For a 3.5 years old girl,
Yes.
what is already the arrangement of the family court is a well-considered one.
But we have been having overnights. The mother will vouch for this fact that the child loves coming to my house and spending time with me and my family.
No,
Absolutely no difficulty.
No, absolutely no, madam. Mother is standing here. She says nothing like that. She's not at all happy with the child going to the father. She's hardly 3.5 years, and she's not in the welfare of the child. She says that it is not sound enough to send the child to the father.
What is it?
If I may be allowed, so my daughter's just 3.5. She from 12. She wakes up at 6 in the morning. She goes to school. She's in the school till 12:30. She's being picked up by the petitioner, that's the father, and she's coming home at 4. She's not getting any sleep in between. She's not getting any rest. She comes home exhausted, hungry. That's when she's throwing pangs and she's having tantrums because the child is sleep deprived. You can ask any mother in this room present, how important for a child is it to sleep during the day after the school is done. So when she's coming home, she's exhausted completely because she's playing there with her father. And I've always allowed and accommodated him and his family even to come home and visit even after I was brutally thrown out of the house during the marriage. I have been more than accommodating. I have been always trying to reconcile and make this relationship work, but it is not coming to that ground. And yes, I respect his decision that he does not want to stay with me. I can't force him to. But in the welfare of child, even now she's going during the weekends, and now she's been fed junk food throughout the day there. She's eating Maggie, pasta, chocolates, sugar, XYZ amount of sugar, which is very unhealthy again. And that is again another reason of the child having pangs. There are scientifically proven studies which show that, how a child reacts with sugar in their body. I can bring it in the next hearing if you want me to. But even during the weekend, she's just going there, she's playing, and she's coming back. The previous order was even taken to take the child to the holiday home in Kunur. She was never taken out of the town. She was in the residence very much. And even now, I'm never allowed to speak to the child during she is in his custody. And now my child was sick for the last 4-5 days. And the doctor has clearly told her not to eat any junk food at all. I request this court to please revise the order for me and the welfare of the child, as she's just 3.5-year-old child, please.
So page 123, Your Lordship may kindly see copy of the writ petition, page 123. The child was not being sent to school for 4 months to prevent me from having access. This is the school attendance register, page 123 and 124. August 6th, 7th, 13th, 20th, 21st, 22nd, 23rd, 26th, 27th, 28th, 29th, 30th, absent. September 2nd, 3rd, 4th, 5th, 6th, 9th, 16th, 17th, 18th, 19th, 20th, 30th, absent. October, along with the memo filed on 25th of March, I have produced the other attendance register of the child.
Why the girl didn't go to school for so many days?
What sending?
Please, Lord.
Look at page number
123.
123 of the writ papers.
My lord, I'm sorry, I'm not carrying my file.
Show it to me. Profile.
There's one more memo on 25th of March I filed. Again, absence from December onwards.
Page number 123.
1, 2, 3.
Open a minute.
1, 2, 3. Show me this one. Order passed by him. Is it? Yeah. What is that? What body have to show? Child will not go to school without you.
And then even though she was not going to school, he was coming home and picking her up for visiting.
My lord, even if the child is not going to the school, he was allowed access.
No, why she's not going? That's what I asked.
Why would not?
Because first thing,
Tell him.
okay, the school is far away. The school is 8 kilometers away from my house. I have no mode of transportation. After that, the court had ordered him to pay for the taxi. Then she started going to school again. And he had promised before putting her in the school. I told him it is a faraway school. There is the same branch. There is the same school which is located very 1.2 kilometers from my house, but he denied.
May I, with
Just
the Lordship's
because him
permission,
to
make one
have
submission?
access- Just because him to have
For the
access.
mother to drop the child to school every day, taxi fare is being, his Lordship's order, taxi fare is being paid every day. There is no application for maintenance filed. 30,000 rupees, my lord, I have voluntarily agreed to pay to the mother. Educational expenses, I'm taking care of the complete educational expenses. Transportation, I'm paying to the mother to drop the child to school, because his lordship felt that this kind of attendance for a child who does not have a routine is not in her interest. And the reason given was that I don't have any transportation, I don't have any way to travel to the school. Offered, my lord, voluntarily that she will.
Because of this, she's not taking him to school.
Not taking. Not. I have messages where the mother sends, child is crying, only if you come and pick up the child, the father, she will go to school, otherwise she will not go, therefore I'm not sending her today. I have placed those messages on record. Her message, my lord.
Where is that?
My lord, I'm sorry, my lord. We have the messages. The mother sends these messages to the father. You come and pick her up, otherwise she will not go to school. It is because of these reasons, my lord, that I've been granted the kind of access I have been given.
Because he says going in an auto is an embarrassment. Using public transport is an embarrassment.
My lord, one submission, my lord. To this particular issue, what I would like to submit, my lord, is that according to the petitioner, the child going by public transport or going by an auto is not permissible. Now the respondent is not a working lady.
And he's been giving that 30.
She cannot afford a car, a luxury car, and send the child in a car to the school. There are so many factors, my lord. She is also mother. She has not done it intentionally, anything like that. And what 27,000 rupees? Now they are paying that 27,000 rupees, 30,000 rupees.
2 months.
Since 2 months, my lord. My only submission, my lord, I may be allowed to file my detailed version of objections.
When did you appear before the court? When was the wakalat filed?
Objections to main petition was filed on 31st of January 2025. No, I'm sorry. I have also filed a memo on 21st of January where the mother tells the father, child is refusing to go to school until you come and pick her up. You pick her up and take her to school. 21st of January memo.
Because he said that going in a car is the best thing to do. And every kid in their school comes in the fanciest, most cars. And he says going in an auto is an embarrassment. I have those proofs also. I'll provide it in the next hearing when accommodated.
My lord, the child is hardly 3.5 years, my lord. And she badly requires the company of the mother. Anyways, there is in place, interim order is in place. So going beyond that interim order is seeking relief, my lord. So my humble submission is that my objections may be filed and detailed objections may be heard. The interim order is in place, my lord. It is accessible to the child.
21st January memo, my lord, I have filed on 21/1. When the child is unwell, mother calls the father to bring food from his house to her. But page, memo dated 21/1/2025. Lord, the chat is dated 14th of February.
So you're having something in addition to what has already been granted by the.
Yes, yes. I do.
Let it continue.
But 25th of March, my lord, I was granted 50% of the spring break vacation that the child had in school.
That's within the set duration.
Yes, no, only for that duration. But now the vacation starts from 16th of May until 14th of July. 2 months, my lord, the child has vacations.
But, she's just 3.5 years old, and you can't take her long durations outside the place. And she requires to have the company of the mother also. Already, what the arrangement that is made by this court and the trial court is, I think, as I'm telling you, I've never seen in any other case. So you can't bargain more than
may I make
whatever the circumstances.
May I make one request, Lord? May I make only one request? Lord, my request, Lord, there are certain facts which I can't place on record before your lordship that were conveyed, my lord, to your lordship's precisely in an in-chamber hearing. My lord, I'm willing to, my lord, place those facts before your lordship in an in-camera hearing if your lordship has a time. I understand, my lord, we only have 2 days. My lord, that material, my lord, will change the course of the entire case. I have, my lord, that evidence which would shock the conscience of the court. Therefore, my lord, I have filed an application for permanent custody in a writ petition where I have sought only visitation, because facts are such that the child is living in an environment which is absolutely unsuitable for any child. I'm not talking only about the physical environment. If your lordship has it, my lord, in camera, I will be able to place that material, my lord. I have that material with me.
But anyway, this is continuing, that can be taken care of after vacation also.
Lord,
the month, what's going to happen?
My lord, the law, my lord, your lordship may verify this from the mother's side. Lord, I have messages here. Every time I drop the child, she does not want to go back to the mother's house every single day, though I have visitation every single day. But this is I understand the child's age and sex, my lord. But the Honorable Supreme Court also says, in fit cases, my lord, mother is to be the best.
Oh, you're having the best, the best time with the child. You're having the best time. You have what is the order of the court?
50% of the vacations 10 to 4.
And apart from that.
But school days,
Page number?
Monday to Thursday, page number.
What else you want?
89.
The petition is permitted to pick up the child from the school after the school hours and to have the custody of the child till 4 p.m. on all school days.
Yes.
So every day you are having. So Monday to Thursday.
Yes.
And to have the custody of the child after school hours till 6 p.m. on every Friday and on other days.
Yes.
And this court had taken care of your overnight custody also.
Yes. But all a request.
What now? Some order needs to be passed.
Vacation
on the merits of it.
I'm only requesting for vacation, my lord.
The vacation also you're having the overnight custody.
I don't have, my lord.
This is what is passed by the court.
My lord, only for Saturday, Sunday. That's all. Not for the entire week. Only for that spring break, my lord, was in April 1st week. Lord, for the summer vacation, right now the family court's order is in place. The modification made by his lordship.
The family court's order is 50% of the summer vacation.
10 to 4. 10 in the morning I have to pick up. Can you please? At 10 in the morning I have to pick up the child, and 4 o'clock I have to drop her back. That is the order.
So all days, 50%.
50% of the vacation.
Yes.
But
and apart from that, as per the order passed by this court, you are having visitation on Saturday and overnight custody on Saturday and Sunday. Then when will the mother spend time with the child?
No school. From May 14, there is no school at all. Therefore, I will not have the daily access. I will have 50% of the vacation. I will not have the other daily access. That will.
So other daily accesses you're having the weekend custody.
Only on weekend. Therefore,
Saturday and Sunday.
All I'm requesting is during the vacation, if I want to take the child out of 10 to 4 I have to pick her up at 10 and drop her back at 4. She's extremely comfortable, at my place. I live with my parents. I live with an extended family of more than 50 people.
What about the mother? That I'm asking.
The remaining 50% the mother has custody.
And then no, in that 50% only you're asking now.
I'm asking for in my 50% the 10 to 4 for your lordships to modify the order permitting me to have overnight. Instead of 10 to 4, my lord, and drop her back at 4 o'clock every evening, I will pick her up for the first 50% of the vacation and drop her back at the end of the 50% of the vacation. And if I'm in town, the mother can have her during the weekends. That's all I'm
saying. You'll have the complete custody of the girl.
50%.
50% of the.
Or, my lord, your lordship may grant me 15 days, my lord.
No overnight custody at this stage for 15 days.
Or weekly, one week with the mother, 1 week with me, even alternate, because child has already been with me for 5 nights during the spring
We
break.
can't rule out, in the circumstances where the financial condition of the mother and the father compared to it, he is in a better position. So child will definitely have the comfort more with the father. And if this kind of order is passed, definitely that will have an impact on the child.
May I make one request, I will not claim around 50%. 1 week with me, 1 week with the mother during vacation time. At least I can take her to Mysore, places of interest to the child, Bandipur.
Have the balance. Let that morning to evening go on. After evening, let the daughter be with the father, mother, so that it will be balanced. And he cannot, she is not some property that where he has to, fight for it. He is having enough that, please wait. He has the company of the child. Like, in none of the cases this is happening. Let him be happy with it. And let him not, already this court has granted something which is more than what is granted by the tribunal, the family court.
May I make only request, 5 minutes at 5 p.m. if your lordship finds it, only for 5 minutes. No arguments on merits, in chambers, only for 5 minutes, not more than that. Not even 5 minutes, 2 minutes is all I request of your lordships. Ultimately, we're looking at child's welfare. Whether it's the child's welfare to be in the environment she's in, if your lordship can kindly indulge me and provide 2 minutes at 5 p.m. Only 2 minutes. Thereafter, I'm in your lordship's hands.
No, I have a local adalats today.
On
2:30.
2:30. Obliged.
Yes.
Much obliged.
Both the parties.
Please, my lord. Please, my lord.
Yes. 26.
I am for the petitioner in this case. I am ready to comply the office objection in the next day, very next working day. Kindly read the matter on 3rd of May.
What is that?
I am ready to comply the office objection. Very simple.
You could have done it by this time, and without doing it, why did you move the memo?
Please, I will ready to office.
So for office complaints or complaints of office objections, one memo.
Very next
It will come again. You will comply it again. One more time, it has to be listed. You should have complied with the office objections by this time.
Please, very next working day I will
Objections are
comply the office
list
objection.
this matter on Friday and instruct them repeated memos when once already one memo is taken. If any order is passed and again another memo is given without let them bring it to the notice of the court and don't list the matters like this. Yes. 27.
Serial number 27.
Much obliged.
Yes.
7. Arun Govindraj.
Your ladyship, I am for the respondent in the matter.
Father.
This matter had come up last week. The lordship permitted the father to have access to the children every day. But he's been exercising the access. The only thing, my lord, is on the last occasion, my learned friend submitted that he's not in the position to pay the school fee. Only 1,75,000 rupees he can pay for now. The lordship directed 2.5 lakhs to be paid. Not the arrears of school fee is 17 lakhs, but he has not paid. Until the day we separated, my lord, the petitioner, the respondent, he has paid every single school fee, my lord. He has an export business.
The amount of rupees 1,75,000 shall be paid by the father.
That he has deposited.
Your ladyship, that has been paid. That has
Basing
been
on
paid.
what transpires in what happened to the
Visitation is going on well. The only difficulty is this daughter has school going on 9th standard, my lord. Her exams are coming up.
Your ladyship, may I submit?
1 minute, you wait. You're for the respondent?
For the respondent.
Yes.
Daughter's exams start on 26th May, end on 6th of June.
What is exams in May?
Final exams, no? The international school. Both children are in international school.
So 26th May and it will complete on?
6th June. Son has vacations going on already. He studies in a different school. He has. His school starts on 26th of May.
Daughter and the son.
Daughter and son. Daughter is 15 years old, son is 12.
Son, he is already on vacation.
He's already on vacation.
His vacation is still?
26th of June.
He's in which class?
26th of May, sorry, 26th of May.
He's in which class?
He's going to 7th standard.
Yes, what do you say?
Your ladyship, I have availed the visitation for the 5 days. However, on the 26th and 27th, the visitation had to be rescheduled on the request of the respondent. For 25th and 26th, for those 3 hours, I have availed visitation. The visitation had to be compensated for 6 hours. 3 hours have already been availed by me on Sunday. 3 hours are to be availed by me today for the compensatory
In
visit.
these kind of matters, are you not supposed to come to the court?
Your
Already
Ladyship,
it is very difficult to hear these matters and you appear through online. Your client is here.
Your Ladyship, the local counsel is also present in the court. I am based in Delhi, hence I am appearing on virtually. The matter was kept for compliance. Hence I am appearing virtually. I'll be there in court for the next hearing.
Yes. What about the remaining amount?
Your Ladyship, the remaining amount will be paid by us in the as directed by this honorable court. 1,75,000 is already paid. The remaining amount out of 2.5 is left that we will pay as this honorable court directs. The arrangement for summer vacation also has to be considered and made by this honorable court as per the last order of 22nd April.
What was the school fees of your children while all of you were together?
For my leadership, the son is on a 100% scholarship.
Hmm.
Not even a penny has been paid by me. And this information she has hidden in all the pleadings. Be it her school activities or sport activities. He's on a 100% scholarship where nothing has been paid. So the declaration that I have paid and that his
It's okay, leave it that. Then what about the daughter? How much you used to pay for her?
For daughter, I've already paid.
Not now. While you were together, what was the school
paying
fees?
together, whatever I could save and whatever was possible. So it's not that I was going out of my way to make payments to her every
So
now and
what
then.
was the fees that time?
I'll have to check now.
I have the memo with the same.
Take that.
Even the son's school fee also was being paid by the father, my lord.
Your
Page number
Ladyship,
15.
2 lakh.
Page number 15 onwards are the receipts for the son's school fee that the father has paid, where he says he's not paying any. Page 15. Lord, name is Ekalavya. 1,80,000 rupees. Well, he has full waiver of the tuition fee because he plays football for the school, but other fees to be paid. Not transportation fee, meal plan fee.
For the son, it is 1,80,500.
Yes, but for the year 2017-18, academic year 18-19, sorry.
What about the daughter?
Daughters I have produced, not here. It was about 3 lakh rupees during 16-17. As of now, it is. Six lakhs is the daughter's fee, not per annum. Both are in international schools. They've been in international.
What is the mother doing?
Nothing. Absolutely nothing. She's been a housewife. They come from a.
Your Ladyship, she is also
traditional-
employed at KPMG. As per her own affidavit of assets and liabilities.
That was for about 6 months. I've also placed a salary certificate. 23,000 rupees per month she was receiving on contract.
And what is your income?
At the moment, I'm not able to earn much.
You're not earning. What you used to earn earlier?
I was running a business. So what she did, the acts that led to this, destroyed me totally.
What was I asked
I was
you, what
running a
was your
business.
income?
I was running a business.
What was your income?
Approximately 3 to 4 lakhs a year.
3 to 4 lakhs a year. With 3 to 4 lakhs a year, you're paying this school fees to the children.
Yes, I was
3 lakhs to the daughter, 1,80,500 to the son. So around 5 lakhs per month, per annum you're paying only towards school fees.
Yes, I had taken a loan and that loan is very much visible in my assets and liabilities are available.
Mr. Gondras, as far as we let this visitation continue with the father paying the remaining amount of 2.5.
May I
How
make
much
this-
is the remaining amount?
My lord, he runs a family business, Apsara Silks, which exports, my lord, to the tune of
Your
more
Ladyship, the
than.
relevant documents are on record before.
I
the
don't know why my
local
learned friend wants to
court.
interrupt
The
me when I'm
business
making
is in
submissions.
losses for
This is the
past
difficulty
3
of
years.
appearing online. And this is the
Kindly,
problem the court is facing. The counsels who are appearing online, like if they understand how it has to be, then it's fine. Otherwise, like all these overlapping and all is a difficulty for the court.
No,
Yes.
he runs a company, family-owned company, where only his father and he are directors. Turnover is 100 crores per annum. Not they export silk all over the world. Not he's a marathon runner. He goes to New Zealand, Germany, Canada, UK to run marathons. Even as of today. Even today, my lord. An undertaking given by him before the family court, I brought your lordship's, drew your lordship's attention to the undertaking given by him that he will not only pay the educational expenses going forward, but will also reimburse all the educational expenses the mother has borne for the last 3 years. That's recorded in the order sheet. He has signed the order sheet. His counsel comes before the court and says, "Give me 2 weeks' time. I will make sure the payment is made." Therefore, before the family court.
Now that what we'll do is,
yes,
we'll make this interim arrangement of whatever amount he is going to pay. Another how much? 1,75,000 or 1,75,000 remaining amount.
Well, your lordship said directed him to pay 2.5 lakhs. 175 is deposited.
So what we do is we'll ask him to deposit the other amount, and during the summer we'll give him some visitation, and we'll also direct the trial court to dispose of your maintenance application within a month from after the court reopens. That would serve the purpose.
Okay.
So,
Your ladyship, I apologize.
Yes.
May I just submit, may the summer vacation arrangement be in addition
That's what
to
I'm
the-
saying. That's what I'm saying, that we will make arrangement. And now 1,75,000 is paid.
Yes.
So what would be the remaining amount?
75,000.
Or 1 lakh?
In terms of his undertaking.
1 lakh. Remaining 1 lakh. You pay, and we'll make the arrangement and let the trial court dispose of the maintenance case. So how the vacation shall go?
Lord, since daughter is in ninth standard now, Lord, and it's a crucial year for her. So exams, this everyday visitation is hampering her preparation for
First
exams.
we'll talk, then the son is free.
The son is free.
And
the son plays football, my lord, on a day. He's getting scholarship from the school because he plays football. He's a very talented football player. He plays.
Father will accompany him when he's going for
He
the
plays for 90 minutes a day, my lords. From 6 a.m. to 7:30, he plays for 90 minutes in a day, and this excuses
the allegation
that he plays football, so he's busy. This is not expressed by the children.
Yes,
during the
yes, Mr.
So Lord, the allegation is that the father has challenged the son's paternity. Therefore, the mother is not comfortable sending the son alone to him. The mother.
But the child is okay to spend time alone with the father. He has even spent an hour alone when the minor daughter was dropped to a class during
Page
the
34,
visitation in the last 5 days.
Page 34 of the writ petition.
The minor son was alone with the father. He has spent time. He expresses no reservation with respect to spending time with the father. This has only been done by the petitioner.
Even according to you, there was nothing wrong with the visitation.
The children together have a good time with the father. I'm not even saying that they're not having a good time. What we are concerned about is because the daughter is 15 years old, she's quite mature. When she's around, my lord, the mother has some confidence, considering the nature of allegation. My lord, not just before a criminal case is filed against the mother, saying that she has deceived him and had a child through someone else.
My lord, the allegations are against
Sorry,
the
can you
mother
please?
in the adult.
My lord, I don't understand this kind of interruption every minute in every court. Page 34, my lord, allegation, very serious allegations are made. Therefore, the mother is apprehensive.
What we do is,
yes,
let her, even if she is having exams and she's busy also, once in a week.
Yes, absolutely.
It can be done.
Absolutely.
So the weekends, both the children, between what time to what?
Lord, if he is willing to take the son for his classes, then he can 10 to 7, Lord, he can take both days.
10
to 7, Saturday and Sunday. No objection.
My lords, may overnight be considered during the summer vacation.
They have not even challenged the order, my lord.
Yes, 10 to 7. The mother is agreed with the order passed by the mother is before this court questioning the order passed by the family court dated 1/3/2024. What is the date?
1st of March 2025.
1st of March 2025. When this matter came up before the court has passed the order on the last occasion, entire order, extract as follows. Today, both the counsel submits that the visitation went on well and the father has already paid an amount of rupees 1,75,000 and he will be paying another amount of 1 lakh. By what date?
2 weeks.
Will pay another 1 lakh within 2 weeks from today. It is submitted that the girl is having exams from 26th May to 6th June. She is in a 9th standard and she has to prepare for the exams. And the mother is comfortable if both the children go for the father takes both the children, or father can exercise visitation when where both the children are together. Further, the application that is filed for maintenance by the mother is pending consideration. That is IA number.
But that's in the divorce petition, because this is G&WC, she could not file an application for maintenance here.
It is submitted that a petition is filed by the mother seeking maintenance in the
Divorce
MC. MC, that is
990 of 23.
990 of
2023.
990 of 2023. This is arising out of the G&WC. And considering the interim, making an interim arrangement for the visitation of the father, and also fixing this the amount of it would be 2,75,000 then.
Yes.
Fixing this amount of 2,75,000 as an interim arrangement towards educational expenses of the children, and directing the court to dispose of the matter, dispose of the IA that's pending for interim maintenance would be in the interest of both the parties. Hence, this court is passing the following order. Number 1, the father can pick up the daughter and son on Saturday, and except that whenever the exams are on Monday, the father cannot have the visitation on Saturday and Sunday. On all other days, till the vacation. Not only till the vacation, it's an arrangement, we'll leave it like that.
But otherwise, mother will be left to only ferry the children to classes and back. She will not get any weekend time with them.
Till the maintenance application is decided, Mr.
Not the visitation order granted by the family court now is my lord, only first and second and fourth Saturday from 10 to 6. They have not challenged it.
First, till summer this will continue. Yes. After that, let that order
go. Visitation order.
And I'll say, after the maintenance application is disposed of by the court, the father is at liberty to renew his request for any
modification
of the order.
Very.
What is that? Saturdays and Sundays. On all other Saturdays and Sundays during the vacation, the father can pick up the child. How was the arrangement? Who is going to pick up?
No, the council have been coordinating. He's picking up.
The father can pick up the children.
The respondent picks up
from the mother's place and drop them back. Next point number 2. After the vacation, the arrangement that is made by the family court will come into effect, and they have to follow the same. The family court in family court shall dispose of the IA filed in MC number
990 of 23.
990 of 23, seeking maintenance within a period of 1 month from after the court from the date the court from 2nd of June. Then after the application for interim maintenance is considered in the MC, the father is at liberty, father/mother is at liberty to seek modification of the order passed by the family court. That is the impugned order passed by the family court.
Your Ladyship, may I just submit? May I just make one submission, Your Ladyship?
Yes.
In the MC case for the interim maintenance, one of my applications, IA number 4 under order 11 rule 14 is also pending. May that also be decided within that 1 month, as
that is their writ petition, not your writ petition. Yes.
No, the mother says school fee is already due for the son and it's not paid. 15th of April was the due date, my lord. At least let him pay the first term fees for both the children.
No, again, all those, first of all, what is extended by this court in this court is beyond the scope of the
Undertaking given by him.
But this is not an executing court to
Very
enforce or execute.
Obliged.
Yes, next. Huh? Writ petition disposed of. Yes, 27.
Still number 27, 28,
Yes, 28.
28. Sukanya Baliga.
Lord,
Petitioner.
small correction in the is the compliance for office objection and production of statement of objections of the respondent. I have it ready. I'll get it done. Meanwhile, may I pray for consideration of the interim order, my lord? Because
why you not complying with the
no, what
office
happened
objections?
is on Saturday the notification.
Comply. If office objections are complied, list on Friday. Yes, 29.
No, Friday.
Still number 29.
Yes.
The Lordship, with regarding to the office objection, there's only one objection which is pending, which is regarding the marking of petition and the objection as A1 and A1. You want me to mark as A and B. That is the only that can be.
Friday.
And I'm only seeking a direction for expeditious trial, Your Lordship.
Give that. Which year is MC?
MC, Your Lordship. MC.
Which year?
2022, Your Lordship.
Which court it is?
The first additional. The issue is this: on 14th July 2023, petitioner was abducted and kept in an illegal detention center, and the WPSC was filed to recover him. A lot of threat. That is the only reason why, without going into the merits, can be declared, or notice may be issued.
No. When this court is not ultimately going to pass any order, why should there be a notice? And 2022 MC there cannot be a direction in a court where 14 matters are pending.
Yes, Your Lordship.
Given
the condition here,
how it is going to, what is the relevancy?
There is a G&WC case which is pending. There is a maintenance petition pending, Lordship. There were 2 incidences of crime and a charge sheet has been filed.
Was it brought to the notice of the court?
Lordship?
Was it brought to the notice of the trial?
Yes, Your Lordship.
Then you should ask the trial court.
But
for
the,
that.
but the,
Because it is in the domain of the trial court to understand what's happening in the court.
but they're giving out a very long date, Your Lordship, 3 months, 2 months.
Please, you make all those submissions and everything is on record. And if the court do not consider.
Maybe a
the
direction
same
may
thing,
be given,
huh?
that Lord. Maybe a direction may be given. I'll make a submission.
No direction. I'll say if anything is there,
Yes, Your Lord.
you can bring it to the notice of the court.
Yes, Your Lord.
The present writ petition is filed, seeking a direction to the first additional principal family court, Bangalore, to dispose of MC number 6890 of 2022 within 3 months. It is stated that the petitioner is facing severe forms of cruelty and anticipates threat and danger. He has marked his evidence in the trial court, and in the light of the threat and danger is anticipating, there shall be a speedy disposal of the case. It is stated that because of threat, he is unable to live a peaceful life. Where do you mention about what is this illegal detention?
Your Lordship.
Where is this illegal detention? Where did you mention?
I have filed a WPHC, that is Annexure C, page number 75. That is the order of the.
This happened in 14/7/2023.
Yes, Your Lordship. The.
It is submitted that he was illegally detained on 14/7/2023, and the petition also discloses about certain how he has been detained and the series of cases that are filed. This MC is filed in the year 2022, and there is a lot of pendency before the said court, where even matters which are 5 to 6 years older than this case are pending. If something has happened in the court or in the court and he faces any is facing threat. The petitioner ought to have brought all these things to the notice of the court, and without doing so, he has filed this petition. Even the so-called the illegal obstruction which he is referring to had happened in the year 2023, and the petition now has come before the court in 2025. In view of the pendency of cases, the huge pendency before the family court, this court is not inclined to pass an order for a speedy disposal. However, if any difficulties that are faced by the petitioner can be brought to the notice of the court, to the notice of the jurisdictional court, and the court
Expeditious.
shall pass appropriate orders. Accordingly disposed of.
Cell number 30, hearing on interlocutory applications. Cell number 30.
I am for the appellant in this case, Your Honor. I am for the appellant in this case. The
RTC
MFA
matter?
4478.
RTC?
I am for the appellant from insurance company.
Insurance company.
My Lordship, I will make one submission. MFA 4478 of 24, it has connected with the 4524. It has stayed in a division bench, Your Honor. Yesterday, the matter is posted to the 36. It may be considered the same.
You have deposited?
4478. It is connected to the 4525 of the MFA 24. The 4478 was stayed yesterday in division bench, Your Honor. Same to be allowed the application and stay the.
No, insurance company is on what ground before this court?
Insurance company, Oriental. Oriental.
On what ground you are before this court in appeal, I'm asking?
Question of liability, Your Honor.
On the ground?
On the ground that the owner has violated the permit. So far as per the route permit, the owner only carrying the passengers from the Channagiri to Davanagere. But as on the incident,
so if there is violation of conditions of permit, then what should follow?
So as on the incident, the passenger carrying from the Bhadravati to Shumoga.
So it's pay and recover will apply, take notice by will permit them to the claimants to to withdraw the amount. Any ultimately pay and recover will apply. When the owner comes, the owner will pay. Take notice.
My Lordship, and moreover, the deceased was
how much is the
riding
compensation
bike,
granted?
not for fixed.
How much is the compensation granted? Compensation. Look at the file and tell the court what is the compensation amount that is awarded.
Compensation amount granted to the 5,20,000.
So you deposit the entire amount.
Death of the minor petitioner.
Deposit the entire amount, and they will be permitted to withdraw 50% of the amount. It's only pay and recover. Once they come, we will pass pay and recover. The insurance company is before this court on the ground of on the quantum. Is before this court on the ground that the owner of the vehicle, the vehicle is they were plying the vehicle contrary to the terms and conditions, and without a permit, as such insurance company is not liable to pay the compensation. Even in those cases also, in the light of the law laid down in Rani versus so-and-so and Amritpal Singh, the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. In that view of the matter, there shall be stay of all further proceedings on the condition that 50%, 100% of the deposited amount, 50% of the amount shall be deposited.
Other two matters is pending. That amount is 22 lakhs and the 25 lakhs. Once this case was passed the order, it will affect to the another two connected.
What to do? 50% of the amount shall be deposited, and the respondents are the claimants are at liberty to withdraw the entire 50% of the amount for depositing 6 weeks.
50%.
50% and entire amount they will withdraw. Yes. Notice to respondents. Yes, on IA number 2 and the main.
Number 31.
Yes, 31.
Claimant appeal seeking enhancement.
Which is insurance company?
United Insurance. United India.
United India Insurance. Yes, Mr. Sitaram Rao. You appear for United India. Mr. You're also there as a panel advocate or you're for the room? Mr. B.C. Sitaram Rao is directed to take notice on behalf of the insurance company and the counsel for the appellant shall serve the copy of the appeal memo. IA number 1 of 25 is filed to condone the delay of 108 days. Condone, admit post of final hearing, TCR. Yes, 32.
32, Cholamandalam, Climate's appeal. Madam.
What is that? Cholamandalam. And R1 notice is required 31.
Dispense, filing a memo.
Right. Give that. In 31, a memo is filed seeking dispensation of notice to R1 dispensed with at the risk of appellant. Next is Cholamandalam.
Otherwise, I'll take out notice, Malad, then
Huh?
I'll take out the notice to the R1 Malad.
You want to take?
Please.
Then in 31, no, not to admit. No.
Information from the.
Then,
Department or not.
then even the condonation of delay also. No, IA also. No. Then notice. Notice to the respondents.
R1.
Then 32 is Cholamangala.
Cholamandalam.
Cholamandala. Mr. Pradeep is directed to take notice on behalf of the respondent insurance company. Same, the memo, what about this?
I'll take out notice.
A notice to the respondents. Respondent number 1.
Sale number 30.
Yes, 33.
33.
33 Malad, one more appeal filed by the United Insurance Malad, L. Srikant Rao. I take notice to Srikant Rao.
It is submitted. The insurance company has already filed another appeal. Mr. L. Srikant Rao.
Yes, Srikant Rao.
Srikant Rao has filed the appeal. He is directed to take notice on behalf of the insurance company.
Please.
And what about the R1?
R1, I'll take out notice.
Notice to R1. List along with so and so. Give that number.
47
Write on a paper and give to the court officer. Yes, 34.
Sale number 34.
What about this?
United.
United India. L. Srikant Rao, this also is directed to take notice. Appeal memo, say, notice to R1. Next 35.
Sale number 35. Malati.
Appellate, my lord. Insurance company appeal on quantum, your lordship.
How much is the amount?
The award amount is 32,80,745. It's a case of death, your lordship. Parents and minor sisters are the claimants before the tribunal. The tribunal has considered 1/3 deduction while deducting.
How much it comes?
It comes
as per your calculation.
My calculation is 24 lakhs, 74,74,200. And the same has been deposited along with the interest by memo.
24 lakhs.
Yes, we have already.
It is submitted that the insurance company is before this court questioning the quantum. Already an amount of rupees 24 lakhs.
24 lakhs, 74,200 along with interest.
74,200 along with the interest is deposited and
along with interest, your lordship.
Along with the interest. And what is the portion? What was the order? You that any fixed deposit and all?
Fixed deposit.
Order of the tribunal for withdrawal, I'm asking.
Withdrawal.
The tribunal has awarded has observed that amount shall be dispersed 35% each to the claimant number 1 and 2 and 30% to the claimant number 3.
Yes, yes, your lordship.
Claimant number 3 with interest. And after the deposit, disburse 60% of the amount with interest to the claimant number 1 and 2 and remaining 40% shall be deposited in their name in any nationalized bank for a period of 3 years. As per the award, the amount that is deposited by the insurance company as per the award has to be are permitted to withdraw.
Till then remain for the remaining.
Stay of all further proceedings on that condition. Notice to respondents.
Number 36. Pradeep B.
Well done. Appeal may not challenging the liability. The appellant insurance company has issued the policy standalone, my lord. The Liberty General Insurance was issued the policy to the third party. I implemented before this Honorable Court made as respond number 3,
Notice.
proposed respond number 3.
IA number 3, notice to the respondents.
Lord, I will serve the copies to Ravi Sampathi, who is appearing in Liberty General Insurance.
IA number 3, it is submitted that the notice is the IA number 3, Mr. Ravi Sampathi is directed to take notice on behalf of the respondent, on behalf of the proposed respondent number 3. Then
Issue notice to 1 and 2.
notice to 1 and 2. Yes.
IA 4
37.
not pressed.
Stay application I have not pressed. New Milad
It is
requires for
submitted
remand.
that
That's all.
the respondent, the appellant is not pressing IA number 4 of 25. Accordingly dismissed. Yes, next. Huh? That is not ordered, no? I only said notice.
Notice.
Yes, 37.
Serial number 37.
Lord, the involvement of the vehicle is question mark. It's a case of injury. 7,37,238 has been awarded. I'll deposit 50% more. Same may be fixed deposit for a period of 1 year. Wherever my lordship directed to deposit 50%, if my lordship is not directed to fixed deposit, my lord, that will be lie in the court. That's all.
Then what about withdrawal?
My lord, involvement of the vehicle is question. Requires for
The
hearing.
insurance company before this court questioned the involvement of the vehicle. And they shall bestow of all further proceedings on the condition that the deposit 50% of the amount within 8 weeks, and the said amount shall be kept in fixed deposit. Notice.
Serial number
638.
38.
38 man passenger carrying the goods vehicle. My lord.
It is submitted that the claimants are traveling in a goods vehicle as their gratuitous passengers. Insurance company is not liable to pay the compensation. Same on 50%, fixed deposit, 6 weeks. Notice.
Dispensation of production of certificate. Dispensation.
IA number 1/25 is filed in dispensation of the notice. With the production of the certified copy of the judgment, same dispense with for the present.
Serial number 30.
Yes, 39.
Manjula Tejasvi. Manjula and Tejasvi.
No representation after vacation.
Serial number 40.
My lord, this appeal is by the insurance company challenging the negligence and quantum. My lord, the award is rupees 23,73,000. My lord, we have admitted the liability to the extent of, my lord, 10 lakh, and the disputed amount is, my lord, 13 lakh and that. I am ready to deposit 50%
It's a
of the.
case of injuries.
No, it is a case of death, my lord.
See, the insurance company shall deposit an amount of rupees 10 lakhs within 6 weeks. On such condition, they shall be stay of all further proceedings. As per the disbursement and apportionment by the tribunal, the said amount can be withdrawn.
Please, my lord.
Yes. 41.
Serial number 41.
Your petitioner. In this case, I have filed IA number 3 to restore my case, Your Honor, which was
When was it dismissed?
dismissed on 24/9/2024.
And for that, there is an urgency before vacation.
No, this is the 7th.
RPFC of
This is the
23.
7th memo. What I
No,
have.
RPFC of 23, dismissed in 24, and before vacation there is urgency, and court has no other work but to recall this order. It's not right on your part, on any of the advocates, to
I
move
want
the
to,
application, the memos like this.
I want to interrupt you. Last time also, when I have moved my memos before the RG and the general, they told me the bench is in Harvard. So I have faced a problem for past 4 months, 3 months. So that is the urgency. Last week also I have filed the memos.
I think the court is here from the last 4 months.
No, here it is there.
Then,
I have even filed the memos.
no, from Dharwad I
Last 2
came.
weeks I am filing.
No, from Dharwad to Bangalore it is 4 months. When did you move it? If any memo is moved before this court, it will be immediately listed. Don't tell me that you have moved the memo and it is not listed.
No, last week I have 2 memos I have filed. Day before yesterday also I have filed 1 memo.
Why this order to be recalled?
I have a very good grounds in this case, Your Honor, to set
So
aside the
why you
impugned
have not
order.
appeared before the court? On 12/7/2024, 1/8/2024 and 2/9/2024, as there is no representation on behalf of both the parties, the matter was directed to be listed.
Lordship.
So how many invitations are required for you to come to the court?
One thing, Lordship. Actually, this was prosecuted by the previous counsel, one Mr. Chandrasekhar.
Because we are not concerned with the previous counsel,
No,
we are
what,
concerned with the
what has
client.
happened here, once I have filed the wakala, the SMS should have been given to me.
It will be dismissed, it will be recalled on condition What is the amount that is, you're for the husband or the wife?
Husband.
How much was awarded?
10,000 per month.
How much you are paying?
Regularly, I'm paying before the trial court. Regularly.
And another
I will produce
10,000,
the order sheet.
another 10,000 extra as cost you pay, then we will recall
But
this
she,
order.
she has placed ex parte. Even though she is aware of that, we have filed the RPFC before the Honorable High
You
Court
don't,
of
you don't have the
Karnataka.
luxury of, this litigation like this. You pay the cost, I'll recall the order, or else I'll not recall.
Lordship, she has placed ex parte. She is not appearing before the court.
You are here. You are here before the court. And 3 times.
Lordship, not only this, many of the advocates were not given the SMS at that time. There was some computer section problem was going on. We
3 days.
Sorry?
3 days.
3 dates. Yes, that is what I am fetching.
But nobody has filed an order.
Previously,
Nobody has filed
one Mr. Chandrasekhar was prosecuting the case. The SMS was going to him.
We'll
Last
recall
time I have
we will
actually-
recall the order on some condition. We will not recall this order just like that. And no more arguments. If you're ready to pay any amount, you tell the court, I'll
A
recall
meager
the
amount, yeah, because already he has a health condition problem, Your Honor.
Then let him pay the 10,000.
He is regularly paying before the trial court. He is obliging the court order
I said, if you pay some amount, then only we'll recall.
on around
What is that
2,000, Your
amount? You can
Lordship,
tell the
because he is not in a position to pay the amount.
How much is the amount?
2,000 at least.
To the total.
I will deposit before the court.
This court by order dated 24 September 2024 had dismissed the RPFC, observing that on 27/2024, 1/8/2024, and 2/9/2024, there was no representation on behalf of the parties. And even in the matter is posted under the caption for dismissal, then also there was no representation. Hence it is dismissed. An order that is passed on 24 September 2024, a recall petition is filed to recall the said order on when there is a delay.
Already
Delay.
the continuation of delay application has been allowed. 2 years has been allowed. Continuation of delay for 28 days it was. That was allowed.
That was filed with the delay of 28 days. Considering the reasons stated, the order dated so and so is
24/9.
recalled on the condition that the petitioner shall pay an amount of rupees 2,000 to the High Court Advocates Association. Yes.
And more fully, Your Honor,
Yes.
she. Much
Yes.
up.
Sale number 42, Rohan Kotari.
Let's just matter after vacation.
Much up in
Yes,
this.
42.
42,
The report of the child protection officer is placed on record. The respondents have not been available at their residence, and they filed a memo saying that they've gone to Delhi.
They wanted?
They've gone to Delhi
been
as
to
of the
Delhi,
date
madam.
of the order.
What? They went to Delhi.
Yes. I was informed that they had been in Delhi. Yesterday, I called to confirm the availability.
Then I will issue a warrant to produce them by Friday. Wherever they are.
My lord, I can't say anything in this. I
First
understand.
of all, you shouldn't appear. You shouldn't be representing a client who is not, who you and the client have no communication. You are not aware what is happening. Then why are you representing?
No.
What is a wakalat?
So far as Saturday, Monday.
When the court has passed an order, is it not your duty to bring to the notice of the court when you have communicated? Is it not your duty?
I brought it to the notice yesterday, my lord.
Not notice. When an order is passed in the court,
Yes.
will you not communicate it to the client? Don't you call the client?
I did communicate.
When did you call her?
Late in the evening, Saturday night. The order copy we received in the evening. And I've communicated, I've sent the order copy also to the party, and I've told that since the order was for Saturday and for Monday, it is already late on Saturday. So Monday you be available.
Are you fulfilling your obligation as an officer of the court, Mr. Counsel?
My lord, 100%. That's the reason why, my lord, when it says that I have nothing to state, I understand
Then you should give up the wakalat with this kind of crimes and with this kind of, won't it reflect on you?
That is my major concern. And I have expressed
It would
that as well.
reflect, it would reflect on you, but
I
you are
have
not
expressed-
bothered about it.
No, I have expressed that as well. I have
You're still continuing. You're still continuing for a client who is disobeying the orders of the court. And you still are coming and submitting to the court that she is in Delhi. We will issue the warrants and we will secure her presence. And court knows. It is not that, when the court is helpless.
I understand. I'm not objecting. I'm not stating anything on that.
Yes. Where is that memo? Who filed the memo?
I filed.
On what instructions? Where from your client has called? Where is she?
I have stated, including the boarding pass I have submitted.
Where is that?
I've sought all of it actually.
At what time she left?
According to the boarding pass, it is on Saturday, 6 in the morning, my lord.
Saturday?
6 in the morning.
When was the order passed to this court?
Afternoon, ma'am.
Huh?
Afternoon.
Saturday, 6 in the morning. And you are not aware, you are coming to the court and there is an order by the court and your client, she will not even inform you that she is leaving.
No, I was not. Yes.
And Monday, you will not take any efforts to mention this matter before the court and bring to the notice of the court that your client is not available. And still you are representing the client before the court. Shall I record all this?
No.
Shall I record all this?
So far as Monday.
No, please tell the court. Shall I record all this? And what is this? What is this conduct?
If I may, my lord, insofar as the Saturday's incident is concerned, I was not aware of it.
When
As
you
soon
are
as
not
the
aware
order
of
has
the
been
court,
brought,
being an officer of the court, when such an order is passed, is it not, if you are still representing her, do you have an obligation towards the court or not?
that is why I'm not objecting anything, my
Not
lord. is stating
objecting.
anything. I have
You're
no-
still representing her and filing memos before the court.
Lord, I have brought it to the attention of the court. I understand what my lord is stating, my lord. What I am stating is that on Monday, when it was brought to my attention, I have submitted it to the court. Insofar as by way of memo that it is not possible, she is not available, including the boarding pass, because I was not aware. On Saturday, what has happened, I
I'm
was not
asking
aware.
you,
Insofar
if
as
you're
evening,
representing the client, you're representing the client, is it not your duty to inform to the court
yes, ma'am.
that on Monday, when the matter, and by moving the court, saying that this is what has happened?
It is, my lord. I should have moved it in the afternoon, my lord. I should have moved it in the afternoon. That I agree, my lord. It should-
And again, you're still representing her.
As of now, yes, my lord.
Yes. So this is all like, what is going on, I can also understand to some extent.
Lord, to be honest, it was it may be recorded,
Please
my lord.
understand,
It may be
being
recorded, my lord.
being
that-
an young advocate, you have a bright future.
Lord, it may
You
be
have to understand that it's not about the client.
If I may,
You are
my
an
lord.
officer of the court.
If I may, my lord. In fact, when this order was passed on Saturday, my lord, that an officer may be appointed in order to evaluate the mental status of the child or the condition of the child. In fact, I proposed it, my lord. If I was personally aware that she was not available, I would not have proposed it. In fact, from day one, I objected a lot of things. If I was personally aware on Saturday that she was
is
not,
one, that I can understand what you're submitting.
yes,
When this is the conduct of a client, why you are appearing before for her till now is a question.
my lord,
Then
insofar as
I have
today's,
to, then the inference is that on your advice, she is doing all this? Will any advocate represent like this before the court?
insofar as
Not even once, not even once. Even you, with all this, you compel the other bench also to issue warrants. Warrants means he has given it's observed in the order
My
that the
lord.
court will be compelled to pass orders.
my lord knows, my lord, that on 21st,
Yes,
I was personally there.
we'll issue warrants and ensure that
Read
she's
that.
present before the court on Friday.
So far as-
This is matter on Friday at 10:30.
This one submission.
We'll pass orders.
My lord,
Yes.
insofar as 21st, I was personally there to make
I
sure
will
that it was
also, Mr.
complied
Counsel,
by.
I'm making it very clear. I will record, I think you were there when Justice Arur has passed the order.
No,
With
I was
regard,
not.
that time you were there.
I was not there. I started representing on 21st and I made it a point that
Yes,
on
I'll say
21st,
that day a senior counsel appears before the court, assisted by the advocate on record. And that day, and when both of them have said that they do not know the whereabouts of the client, then he has indicated that the warrants will be issued in spite of, then both of them are representing and they say that the matter is like my client is before the Supreme Court. And now you enter appearance, and what has all transpired after your appearance before the court, and what is your submission before the court today? I will take note of all the facts and then we'll pass the order.
let it be
Yes.
noted, my lord, that on 21st, I have made it sure that I personally made sure that the child and mother has appeared. On 22nd also, I have done the same.
I will record everything.
Only one submission. The memo states that the respondent has left Bangalore on 26th morning. In fact, they were supposed to deliver custody on the 26th. That's why
That
the
I
matter
know. We'll secure her presence on Friday morning by 10:30. Yes.
For 43, N. Gautam Raghunath, for petitioner.
43 is not,
My lords, there is an interim arrangement by virtue.
There's an interim arrangement where the mother gets to see the children in the park between 12 and 4, Your Lordship. It's all been going on smoothly. There's no difficulty. Now she's taking up a house also very close to the husband's house where she was supposed to purchase as per their terms. Your Lordship, all we're seeking is now that things have settled down. During vacation period, some amount of time exclusively for the mother could be given, Your Lordship. Reason being, Your Lordship, this I understand completely. We'll have to take
let me
responsibility on
understand the
this matter.
facts. Where is the order?
Your Lordship,
Yes, my lords. May
this is the
kindly-
matter wherein, Your Lordship, the lady had left her 7-year-old son in the hotel and gone because she had breathing difficulty. And then the second son, she called the husband through the other police station, asked him to come and take the children because she was not able to manage them when
I
she
have
was
not
under.
heard this matter.
No, my lords, it was heard by the previous bench.
I have not heard this matter.
Yes, my lord.
Where is
Previous
the
bench.
order? Let me
Please, Your Lordship. His
read the
the
order so that,
previous order, Your Lordship.
Page 16, my lords.
No,
The
no.
previous
Page-
order,
Page 16 is the.
Dated.
21/2/2025, my lords, was the order where this honorable court had summoned both the parties as well as the children.
21/2/2025.
No, with whom the custody is?
Custody now has been shifted to the father. What happened was they'd separated
By the court?
by the court. The reason being, Your Lordship, what happened was the husband agreed to give her complete custody.
No,
She took
no, before that.
bef-
Like when they are separated?
Your Lordship, they were separated in 2022 itself,
2022.
and she had complete
And the
custody.
custody is,
It shifted, Your Lordship. This was in this December 2024,
so December 2024.
and now they're with
No,
exclusively.
one minute. What is the age of the children?
Age one is 7 and one is 4.
So till December
boys.
2024, the custody is with the mother.
Mother only.
Where are they residing, both of them?
Both of them are in Bangalore only, please.
Yes, one
Your
minute.
Lordship, what happened here is,
1 minute. What is the impugned order?
My
Your
lords,
Lordship,
at
impugned
page
order
16.
is,
Please wait. They are for the petitioner. They'll argue. Yes, page number.
16 onwards, Your Lordship. The
Page number?
operative portion, Your Lordship, would be from 30, Your Lordship, page 50. Internal page 35.
Yes. In view of my so-and-so,
Please, Your Lordship.
denied to have custody of the second, the petitioner is entitled to have continued interim custody of the minor child, Ahmed Ali, and so-and-so. Who is the petitioner?
The petitioner here is the mother.
There, in the G&WC.
In the G&WC, it's the father. Your Lordship, very briefly, what had happened was both had parted ways. He gave custody to the mother, gave her an alimony, told her that she has to buy a house over here. All of this was done. Later, she took them to Dubai. She went to Mecca, Medina, everything, and returned. Once she returned, all of a sudden, she was not even able to breathe. She had taken a hotel. The husband blocks her and doesn't take her calls. She wants him to take care of the children so that she could go for treatment. He's not taking her calls. The mistake she has made, which is unpardonable, is she left that 7-year-old in the hotel room thinking he will watch TV and took the younger one with her, searching for a doctor. Sunday, nobody was available. Her situation got worse. She called her friend. They told her to go to a place which is very far off. And at that point of time, when condition worsened, she went to the nearest police station and said, please call my husband, ask him to come and take my son because I have to go get treated. Meanwhile, they get a call stating in Chickpet, this other boy, the hotel called the police, and police came and took this boy and then called the father, and father then came and took now the father basically felt that she was very irresponsible, that she left both the children like this, and therefore took the children. Once she recovered, She requested the children back and he said, no, you could not have left the son like that in the middle, because he seems to have left the hotel and come out on the road. Even I find it unpardonable, but your lordship, she has made a terrible mistake. But to take complete custody away from her, now she's suffering. Now this honorable court met with them. He also gave her a mouthful stating, how could you do all of this? But then when he spoke to the children, children definitely liked her and wanted to be with her. And the older son also said, I want both. So what he said was, let the mother meet the children in the park from 12 to 4 and spend time. And then you could seek modification later, is what this honorable court
So
felt.
after the mother did all this, he filed the G&WC.
He filed the G&WC, and therefore the court rightly said, let the father have interim custody, because even the court couldn't understand how you could leave a 7-year-old child in Chickpet somewhere and go away to a place which was very far away. She was not able to correctly explain that she even thought that she would die any minute, because her breathing became very, very difficult, because after they landed from the flight, it worsened. On a Sunday, there's no doctor, she's gone. Even these questions I kept asking, because I was not able to understand how
When
she
she
could.
can take one child, she can also take the other one.
She could have taken the other.
Other one is the younger one or the elder one?
No, the older one. Older one, she said he's quite responsible. He's by himself. He will watch TV. I've given him the phone also. All the belongings are in the hotel. She did not think that he would step outside the hotel. When the child has done all of that, the reception has called the jurisdictional police. Police have come and they've called the father.
So now the order of the court is?
The order of the court now is for the mother to meet with the children between 12 and 4 in the park. Now, all we're saying now is things have all been restored. Her health is also fine. She's made a mistake. She's extremely regretful of it. But your lordship, to at least give during vacation some time. And the most important aspect here, your lordship, is he's remarried. That lady wants nothing to do with the children. So the children are technically with his parents on a floor below. He and his wife are residing above. They are not, their children don't go there because that stepmother doesn't like them. Grandparents are taking care of the children. Now we have no objection. The grandparents are loving everything, but the time that she has to have with an interaction online with the children every day, grandfather doesn't like it. He interrupts all of that. So many issues are happening, but we don't want to separate right now. Since she's made this mistake, she has to take effort to mend ways. But to take away entirely from her and to visit only in the park for a few hours, your lordship, children are also longing for her. They're scared to say because the father punishes them. Stepmother doesn't like them. Only grandparents, they want the love and affection of the mother. All I request is during vacation, if your lordship could put whatever conditions on her, she can take the children to her house or somewhere out. But constantly, probably every hour, the children will call the father, inform they're okay, because their apprehension is that since she's been negligent once, they don't want her to be negligent again. That is probably the main
order of
reason.
the court is on Saturday, or what is that?
Your lordship, the visitation in the park. 4 hours
Every
on?
day phone call and meet.
Every Saturday between 12 and 4 in the park. Every day is only online.
What do you say?
Yes, my lords. My lords, what had transpired was there was a settlement agreement entered into between the parties, compromise agreement, pursuant to which in 2022 she was given a sum of rupees 2 crores and 150 grams of gold, and she had undertaken that she will be giving visitation right to the father without informing. In 2023 she has taken the children to Dubai. They are not schooling. They are not going to school from past 1 year. Then, my lords, one fine day on 7th of November at midnight, 2 o'clock, I get a call from a random number, my lords. I could not, because I was sleeping at 2 a.m. midnight. Morning when I woke up, I see the phone, I see a voice note saying that please arrange my ticket from Saudi Arabia to India. Otherwise, I will take the children and go to Pakistan. We have the voice note, my lords. We have produced it before the court. Thereafter, my lords, on 10th, to my utter shock and surprise, I get a call from the Chickpet police station, lords, stating that my 7-year-old son is roaming around on the road with a bag full of gold and some money. Then, my lords, I was shocked. I rushed there, and then when I reached there, I came to understand that she has checked into that hotel at night 3 a.m. in a very objectionable location, my lords. And then when I spoke to my son told that they have reached India on 8th, and on 8th they have come in bus to Bangalore, and then 3 a.m. they have reached. She knows my house location. She knows my phone number. All she could have done, if she had some difficulty, all she could have done to pick up a phone call and tell me, please take my son. Nothing of that sort is done, my lords. Thereafter, my lords, I pick up the elder son who's 7-year-old. And when I spoke to him, he said from past 1 year, he has not gone to school. I had, in the meanwhile, in 2023, January itself, when my all attempts of compromise conditions are not complied, she was not letting me see the children. I had filed an execution petition in 2023. When notices were served, it is said addressee left, and I have no contact with my son. Thereafter, my lords, when I left from the Chickpeck police station around 4 o'clock, I get a call from another police station which is 35 kilometers from this station. And there that police inspector tells me, your younger son who's 4 years old is sitting in this with mother, please come and take the children, the younger son. Then I went there, and when I went there, I was in a state of shock because at 4 o'clock I picked up the 7-year-old from the one police station. When I went there, I told, what is this happening? She said, no, I can't take care of the child, you take. And then what we did is we immediately called up her father, asking that, what is happening? Then he did not respond. We sent a message to the father, no response. I took the custody of the child, the younger son. She has only handed over the son to me, and then we left. Then, my lords, I get a call, and thereafter, on second day, I get a call saying that she demanded me return me the child, otherwise I will commit suicide. I was forced to file a complaint before the Ashok Nagar police station, informing that these are the threat calls that I am getting. Thereafter, she files a habeas corpus petition before this honorable court. This honorable court was pleased to dismiss that habeas corpus because there are records, and her own statement before the court is that she has voluntarily handed over the children in the Hoskote police station. Thereafter, my lords, I have filed a G&WC petition before the family court. That thereafter, my lords, both the children were got. My parents, they were also brought. There was discussions, deliberations, and the honorable court have heard us. And thereafter, my lords, there was this order which has been passed. My lords, a detailed order capturing all the averments and statements taken by both the parties. Thereafter, my lords, they have filed this petition before this honorable court. Here also, the children were brought, my lords, and they were heard. And we ourselves voluntarily said that she is not in a great mental state, my lords. At this point of time, it is not advisable to, because from 2022 till 2024 December, I had no idea where is the children. And her own averment, she has gone to Mecca, Medina without giving the children a education, no school.
For 3 years.
For 2 years, my lords, no school. Then, my lords, we have got them admitted in January. There also, my lords, after this order, she has gone and created ruckus in that school. School authority has written us a complaint. All these things were brought before the honorable court, and this honorable court called upon the children, and they were heard. And thereafter, this order has been passed.
What the children are saying?
Children are saying, my lords, they want to live with the father because when we
saw, what is their feelings about the mother?
Mother, my lords, every day they are talking to the mother. They are scared of the mother because mother did not let them meet the father for 2 years. 2 years they were deprived from the parents, deprived from schooling, basic. My lords, imagine a child coming from Delhi to Bangalore in bus. 2 children, 7 years old, 4 years old. They were made to do pilgrimage at the age of 7 and 4. Instead of going to school, they are doing pilgrimage, my lord. That is their own statement before the court. Thereafter, my lords, which court will allow them to stay with the mother, my lords? And court have directed us to speak for 20 minutes. We uninterrupted because we don't want the child to suffer. We want the child to have both the parents' love and affection. So we make them talk. And every 12 to 4, religiously, my lords, we have been taking the children. Not a single day we have missed. But at the same time, my lords, considering the history and my lords, I will not trouble my lords to read the messages which I have produced already. There are abusive words which has been used and told the children that, don't listen to your grandparents, don't eat what they have given. I am not bringing all this before this honorable court at this stage, my lords. But at the same time, this is the application what they have filed seeking for custody. which this is an order in their favor, my lords, whereby this court have granted them the visitation right, which rightly my senior counsel have stated that there is no objection to that. I have not objected to their talking to the mother, meeting her 12 to 4. I religiously take them there and bring them. This arrangement is working fine, my lords, as of now. My lords, if my lords want to hear the matter, we will argue the matter on merits. But as of now, this is the arrangement, and we don't want to indulge more because of the simple reason that they are very small and volatile, and we don't know what all will happen. Because my lords, there are history and all these things. Considering all these things, the trial court have not even considered to give visitation right, because the condition was so severe, my lords. 2 years. They were spoken 1-to-1 by the principal family court as well as the children. They clearly said they did not get good food. And there is nobody, my lords. Where is she working? What is she doing? Nothing. We don't know. Where is she living? That also we don't know. There is no permanent address.
She's 4
My
minutes
lords,
away
and
from
we
his
have
house.
given in 2022 2 crores and 150 grams of gold. Nothing. No accountability. Nothing, my lords. At this stage, my lords, when I am giving the children, they are going. My lords, I have produced the school records. From January 2024, 2025, we have put them in school. Not a single day they have missed school. She has gone to the school and created problem. She has come to home outside the house. She makes noise. That also I have produced. My lords, from the first day itself, my contention is we don't want the children to be deprived of the mother. That's why we agreed for all the conditions, whatever. I myself volunteered, my lord, saying that let the children be talking to the mother every day. Every day, my lords, they are talking. And they are meeting also 12 to 4. There is not a single day we have missed that. Therefore, my lords, more than this indulgence, I don't think so. And their interim application is give us visitation twice a week, my lords. This honorable court have considered it, and then this arrangement was come forward. And thereafter, the matter was taken up 4 times. And 4 times, this honorable court have extended the same family arrangement which has been arrived, which is going good. At this point of time, my lords, they are going to school, they are having a normal life. I don't want that to be disturbed at this stage, my lords. That is my only contention, my lords.
Your Lordship, I completely understand from the father's side. A lot of things that they've said is untrue, but that the point is you're looking at the interest.
Something is not,
something
not right
was
with her.
It was
Right with her.
It was
and,
not.
What is the fate of the children in her hands? If they're even given an interim custody for even for a brief period, is also something to be evaluated.
Your
now.
Lordship, interim custody.
How can a children of that age, tender age, for 2 years they've
No,
not even been sent to
not
the
2 years.
sent to the
No,
school?
no, not 2. Your Lordship, they have gone to Baldwin School. That is incorrect. And in fact, now
Where she stays?
Please, Your Lordship, exactly 4 minutes away from his house. Therefore, there is no difficulty.
What she does?
There is a clothing brand in which she's working in.
Hmm.
Your Lordship, in fact, she has even a diploma in child psychiatry and all of that, Your Lordship. But
that's how she has been doing.
No. Your Lordship, there's no excuse at all. I cannot even condone it.
No,
but Your Lordship,
it is not like it's a wild nightmare to the children. What is that? Anybody, any prudent person will do anything in spite of you tell 100 things, but nobody will do it.
Nobody
unless and until something is thoroughly
something
wrong with
extremely. What was happening is that she's gone.
But she can take one child. Why not two?
Your Lordship, she felt that this older one would need to.
However old he is not old enough to take care of himself.
I'm not able to
and
even.
You're gone out of the hotel.
Yes.
You're not even bothered for hours together. What's happening to the child?
No, in fact, she has tried to contact him. Your Lordship, she's the one who's handed over custody. She's made the police station call the husband because he's blocked her. He's not taking her calls. So she's the one who says, I'm not able to handle 2 to 3 days. Please manage them.
For parents and all.
They were. Your Lordship, they live elsewhere and mother is not keeping good health also. Your Lordship, she just wanted the father to take the children for some time till she gets better. And that was the arrangement. But what he does is he goes and gets an ex parte order.
Records to show that she is so bad as you're placing before the court?
Your Lordship, I'm told that the records were all placed.
What is her problem?
Your Lordship, that breathing became a very difficult thing till they had to give some antibiotics and all of that to subside for her to even breathe. She could not breathe. She was worried what will happen to the small one. That's why she asked the police to call him and come and take before something happens to her. Because the small one then will not even be able to call, older one's able to call the father. Your lordship, might I just take your lordship towards, just for a minute, this order that was passed after meeting. The lordship says court interacted with the minor children. They are very attentive and smart and they like both the parents.
I read that order.
The older boy expressed he'd like to spend time with both father and mother. Your lordship, they love her immensely.
With all the trauma and with all,
No,
all that
there's-
experience,
Your
let
lordship,
them come out of it. Let them come out of it. Let them feel secure. Let them also meet the mother.
That is why I gave
Let
it
the
some
mother
time
not,
before we
mother
moved, your
not
lordship.
spoil their, again, let them not have those bad memories again.
Might I then make one request, your lordship? I
Yes.
understand it would be the last day on 2nd. Your lordship, just meet the children for 10 minutes. If your lordship is convinced, then I would leave it to your
We'll meet the
lordship.
children on, list this matter.
On 2nd.
On Friday.
Please, please.
And 2 o'clock in the chambers.
Please, oblige your lordship.
Cell number 44.
And on the interaction, depending upon the children's reaction, court will be
I vote
passing
on
an
my lords.
order.
I am before you, my lords.
Yes,
My lord, I'm
yes.
appearing for the petitioner. My lord,
What
in
is
this
this
case,
modification of the order dated?
my lord, in this case,
21 to 1?
on 28/1/25, my lord, the learned family court has passed visitation order to the father. Subsequently, on 21/2/25, against that order, I had approached this honorable court seeking for modification, challenging that order. This honorable court was pleased to modify, stating that on every Sunday and public holidays, the mother will hand over the child to the father between 10 a.m. to 4 p.m. After that, my lord, I have filed another IA with respect to the subsequent events
First,
that have
let me
taken
look at
place.
the order passed. Order
Yes,
is
my lord.
dated?
My lord, the order dated 28/1/25 is available.
Are you referring
actual
to the impugned order?
My lord, the impugned order is 28/1/25. The modification that I am seeking for is the order of 21/2/25.
Yes, it is there. Let us see what is the order.
Yes, my lord.
You are for the?
I am for the mother.
You are the petitioner
Petitioner
in this
mother.
case.
Yes, my lord.
Read it. Which part needs to be modified?
My lord, in view of the above, the court deems it appropriate to modify the impugned order in the following terms. The respondent father is entitled for interim custody of the minor son by name so and so on every Sunday and public or school holidays from 10 a.m. to 4 p.m. On the day of the visitation rights, my lord, I am seeking for the suspension of this order. The modification that I'm seeking for is for the suspension of this order for the time being.
You are seeking a review of the order or
Yes, my lord.
modification. It is passed on 21/2/2025.
Yes, my lord.
What are you doing till now?
After that, my lord, after that, twice I have sent the child. After that, the Sunday that has come forthwith, I have sent the child. On 9th, what so happened, my lord? 9/3, the child was taken and then some food from outside. The child is not used to non-vegetarian food. The food was given to the child and the child was unable to digest it. Therefore, the child had a viral infection. Subsequently, what has happened after that, during the Shivratri and Holi, the father asked me that, since the Sunday you have not sent the child, go ahead and send the child for 2 days before me. But in this entire process, whenever the father has taken the child, the reason I had approached the court is because the child is not comfortable with the father alone, and that in the presence of the mother, if the visitation could take place. However, my lord, on 21/2/25, that did not come forth in the order, and therefore the mother could not stay with the child. I mean, they did not allow the mother to stay with the child during the visitation. It so happened that the father used to take the child from Cubbon Park here and go to one of his friends' place, take him home, go to one of his friends' place to watch the match together. And subsequently, apart from food, drinks, and match, nothing really would happen. And on the very next Sunday when the child was taken, there were a lot of probing questions with respect to what the mother is doing and what has happened. Subsequently, the child in the first place was never comfortable to go. If my lord could kindly look at Annexure D that I have given along with the...
Till what are you doing from March to April?
My lord, I have filed this on 25th March. This application has been filed
Or
on
the
20
learned
and on the
judge-
last two
learned judge has
occasions.
passed an order interacting with the kid or whatever it is. No, at this point of
My
time.
lord, I have passed this on the grounds of, if your lordship may kindly look at, for a moment, look at Annexure E1. Annexure E1, which is the recommendation from a child counselor, my lord, and I'll read that particular one paragraph here. Given these concerns, it is strongly recommended that visitations be temporarily suspended for a period of 6 months to allow comprehensive psychological and cognitive assessment to evaluate the impact of trauma on his development. Additionally, it is advised that he undergo psychotherapy for a minimum of 6 months to address these challenges in a structured and supportive manner. My lord, this is dated 5/3/25. Subsequently, on 17/3, I have taken him for the counseling, which is at Annexure E2, page 16.
Where is the other side?
My lord, from the last three occasions, they are not coming before this honorable court.
No representation for the respondent. Is this matter on Friday?
My lord, I am unable to send the child also because the psychotherapy is going on. There is an order that is
Don't
against
send the
me.
child, we'll see on Friday.
Very well, well.
Cell number 45, Joseph Anthony.
Respondent by
For the petitioner, your lordship.
Final hearing is going on. 10 times, 10 days he has argued in respect of a custody matter. There was a direction by your lordship, it should be disposed of. And my lord, 32 my lord dates. He takes my lord adjournments after adjournments, then 10 dates he has. Today also it is there, final hearing. Some visit, my lord, again some.
Where is MC?
Just one small clarification, your lordship. On a number of these dates, what has happened is that the family court has adjourned the matter for for want of time.
Why you are before this court? What is the relief that is sought?
Amendment.
Your lordship, the petitioner.
Sorry, please go ahead. Sorry, my apologies.
Your lordship, the petitioner is the father before the family court in the G&WC proceedings. He has two daughters aged 7 years and 5 years. This specific proceeding is challenging a common order dated, common order on IA number 46, 47 and 48 dated February 15, 2025, your lordship. What has happened is over the course of parallel proceedings such as MC proceedings, the father has come to know that the mother has secondary employments, in fact tertiary, multiple employments, which completely takes away from her ability to devote time and attention to the children. And that has been her primary argument, that the father is employed in an IT job which doesn't give him time to spend with the children. But through her bank statements and other affidavits, other documents which have come on record,
All that, please come to the impugned order, which is questioned. So let the court understand what is that you are aggrieved.
Lordship, we are aggrieved by the rejection of IA 46, 47 and 48.
IA 46,
47 and 48, your lordship.
46 and 48 is filed. G&WC is of the year 2022.
Yes, your
At
lordship.
what stage you filed this application?
Your lordship, final arguments, during the stage of final arguments.
How is it relevant?
Your lordship, it is relevant because it has a direct bearing and impact upon the final outcome of the custody proceedings, in as much as if the mother is working multiple jobs.
No, when was PW1 cross-examined? And when did you file this application?
Your lordship, yes.
And what is the direction of this court?
Your lordship, I can explain the reason for filing this application at that stage in
Come
time.
to the IA affidavit. What is that you have stated? Page number?
51, your lordship.
Let's see that.
48 and 51, your lordship.
This is something with regard to purchasing of the properties.
Yes, your lordship. That is IA number 46, your lordship.
Yes. Let the court dispose of the matter. This IA is not required to be allowed. Court had rightly dismissed it. Please come.
Page 51.
No, we are dismissing the writ petition, Mr. Counsel. The agreed with orders passed in. IA number 46 to 48 in G&WC number 2 of 2022, dated 15 to 2025. The father is before this court. G&WC number 2 of 22 is filed seeking custody of the children. You have filed G&WC.
Yes, Your Lordship.
Custody of the children. There are two daughters. When the matter is posted for final arguments, at that point of time, these IA number 46 to 48 or 46 to 48 are filed.
Your Lordship, if I may make a small submission, Your Lordship. Your Lordship, the MC proceedings, the evidence stage of the MC proceedings is when we got to know about these documents, about the fact that she has multiple employments, that she has been engaging in sale transactions of property, immovable property with her uncle, who is also her advocate.
To have an impact on her, on the G&WC.
Yes, Your Lordship. I beg
What
your
is the
pardon.
impact of it in the G&WC?
Your Lordship, the mother's primary contention is that she can devote more time to her children because she has a more relaxed job in Father Mueller's hospital.
People, however busy they are, they have their own way of taking care of the children. It won't be a decisive factor for the
True, Your
court to
Lordship,
decide.
but,
And it is just to drag on the proceedings. A petition is filed. Final hearing at that point of time, an application is filed under Order 18 Rule 17 to recall the witness petitioner for leading further evidence and pass other orders as the court deems it fit and proper. In support of the application, it is stated about that the mother is trying to win over the witnesses, and during the pendency of the proceedings, he found that the wife and her maternal uncle have jointly purchased properties, and the same has been hidden before the court of law. And he also wants to produce certain documents pertaining to the properties, the bank statements, and also it is stated that availability of a parent is vital for any determination of custody, particularly in the light of the fact that the wife has no concern for the welfare of the children. Earlier, these are the documents which he wants to produce, and for the purpose of which is sought for the recall, he couldn't place them before the court. Hence, and for the limited purpose, hence the evidence may be recalled. You may be recalled for the further evidence for the limited purpose of summoning the records and production of the revenue records, which is under process of obtaining. The said application came to be dismissed by order impugned, wherein the family court had observed that page number, which page number is
43, my lord, 43 onwards.
Yes.
43 to 45, my lords.
has dismissed the application.
Page 44 onwards, my lords, at the bottom.
After considering the facts of the case, prima facie there is some substance in the argument of the respondent. Even if I number 48 is allowed and CDR is secured, it contains the date, time and duration of the call and nothing else. From the document, it is not possible to prove the respondent has the wife had attempted to influence and try to win over the witnesses. The court felt that the applications are abuse of process of law. The doctors and hospital authorities referred in the application, with whom the mother alleged to have made phone contacts to win over them, are not examined as witnesses in the present case. In addition, the mother submitted that the relief sought by the father in the application violates a fundamental right and right to privacy as guaranteed under Article 21 of the Constitution. The court comes to the conclusion that the husband is deliberately trying to protract the proceedings by filing repeated interlocutory applications and hence dismiss the application. Then counsel appearing for the father submits that in the case of custody of the children, the availability of the schedule of the mother and her availability and her occupation to take care of the children plays a dominant role. And in this case, she is indulged in several activities and she is not having enough time to spend with the children. And these factors are necessary to determine the custody of the children. And the court, without considering all these, dismissed the application. The Lenacinia counsel appearing for the respondent submits that in spite of the petitioner is trying to delay the proceedings and is coming up with this kind of applications and is not proceeding with the main case, and it is submitted that even today the matter is listed for arguments before the family court.
10 days, my lord, yes, argued.
And it is submitted that submitted that the trial court had rightly dismissed the applications filed by the petitioner further, and there are no grounds to interfere. Next, for having heard the counsel for the petition, the learned senior counsel for the respondent, peruse entire material on record. This is an MC of 2022. Admittedly, the matter is posted for arguments, and already 10 days.
10 days, my lord, he has argued.
10 days, the matter was argued, and at that time, these applications came to be filed. And even to consider those applications, the purpose for which he wants to recall and to produce a record has no relevancy to determine the issue between the parties. The submission that if the wife is busy with activities or she is indulged in business, it will have an impact on the custody of the child. That submission this court is not able to appreciate. The family court had rightly dismissed the applications. The petitioner shall proceed with the case, and the family court shall dispose of the matter as expeditiously as possible. This next. This next. This goes through. Next.
Cell number 46. In rebut for petitioner.
I'm on caveat, my lords, for respondent husband. Already, my lords, the mediation is going on. There is likely for reunion. That mediator has sought to extend the mediation, and a marriage counselor has also been appointed. So that I leave it to
my lord, in this case, the impute order has passed. Annexure number A, 18 to 38.
What do you say about his submission?
No, yes, it is. The mediation is going on. Even today, the respondent supposed to go for the marriage counseling 12 o'clock, but he is present here, and the wife is waiting in the family court, and even now
Is required here.
she is waiting there even now.
Presence is required here. He should be there before the marriage
No,
counselor.
we have informed there, my lords. 1:30 we have taken the appointment there. Our colleagues,
1:30.
he'll go, my lords. He is little anxious and depressed
my
with
lord,
respect. My lords,
In you, 1 minute.
My lord, this anxious, I want to take it from there. This anxious itself, my lord, the petitioner is worried about giving the baby.
What is the impute order?
My lord, in this.
it is on my application for visitation rights, my lords. Annexure B.
1 minute. Let him submit and
Please, my lords.
My lord, that's, if you permit,
come to the operative portion of the order.
The page number 36, my lord.
Yes.
The husband father is entitled for the visitation right of the kids, so and so, on every Sunday from 10 a.m. to 6 p.m. with permission to take the kids for the house of the wife, from the house of the wife or mother at 10 a.m. on every Sunday, and return the kids to the house of the wife or mother 6 p.m.
What happened?
My lord, after that,
Order is passed.
It's going on, madam.
my lord, it is going on. It's going on. The mother is accompanying the children, and the husband is taking the children to his own home, or when he objected that he's taking the children somewhere else for the resort, morning 10 o'clock to till evening 6 o'clock. Then the kids are coming back, and kids are completely tired, and the next day morning they're not going to the school. That's what is the now current situation. Kids are 4 years now.
Nowadays, no, the holidays for them.
They,
if the only objection of yours is that they're getting tired, let them be holidays.
My lord,
let them enjoy.
my humble, that's what my humble request is. Let the order be, but mother will be accompanied with them, and within the city area, maybe mall or something. We are okay with the order, but only accompanying the mother and with the city area, not to take faraway places like 40 kilometers or 50 kilometers. Recently, last Sunday, he has taken somewhere else in Anekal, somewhere else far away from Anekal. Kids are enjoying. Everything is okay. But mother is also accompanying along with them and coming back, and he'll take to his own home. And then 7 o'clock or 8 o'clock, they'll go back to the electronic city. Kids will be, my lord, 4.5 years, 5 years kid, my lord.
You don't get tired. They will take care. You don't go with them.
No, my lord, if I don't go, that's what my application here. There has an anxiety issue is there. He's very anxiety. My lord, if you permit me, where is that? He's having his own medical issues and he'll get very quickly angry. Even in this visit, my lord, he started telling that if you don't withdraw the case, I will make sure that I'll teach a lesson to you within the process. That's what he's warning her, because he don't know what he talk when he get anxiety. When he is there in a pressure, he don't know what we say that. But after that, he may be a cool. In the same way, he tortured the kids also when mother is not there, because 4 to 5 years of kid. If the mother, one is female, one is a male, twin kids.
So how are you suggesting to
So
spend time between 10 to 6 p.m. in a mall?
My lord, I'm saying that in different place we may make that 10 to 6 o'clock. Kids enjoy the mall. Kids enjoy the mall. Let it be
Every Saturday, 10 to 6.
every Sunday, my lord. Only Sundays. 3 hours they may be in a play place, and followed by next 3 hours they may be roaming around. Now what they are doing in the resort, what they are doing? Same thing they are doing.
In mall,
Same
they'll
thing,
get
morning to
more
evening,
tired.
they're spending traveling at 2 hours or 3 hours, come back again 2 hours or 3 hours. It's a very tired, my lord.
No, like
And
it appears that no interference.
My
at
lord,
all
my
is-
lord, humble pray, my lord. Humble pray in this case.
I'm grateful.
My lord, kindly modify in such a way that let the mother also accompany that word would be there, not in the house of the respondent. He's taking the baby to his own house.
What happens?
My lord, I can't leave the baby, alone with him. I cannot leave.
Who stays in his house?
His mother and his
So,
father.
What happens?
My lord, this is not good. It's not good, the development of the kids. My lord, the boy.
What is good for you, not good for your client is as well not,
What, when
not
the
good for the children. Let it
My
continue.
lord,
Part of it.
my lord,
Yes.
my lord, my humble request is the everyday video call is there. Every day 1 hour of video call. My lord, 4 years, 5 years of kid, if you give away every day 5 hours of video call, is really impacting on their growth
only
and
one.
psychological, my lord. And kids are not having any, and mother is also practicing a medical practitioner, and she's a doctor in profession. She has to go. Kindly modify that. Maybe weekly 2 days the video call, and the mother will be accompany the
continuously
kind,
it's
my
being
lord,
said-
my lord.
it's
I'm
being
not
said that-
objecting. See, I'm not a my lord. We are not objecting the
Photos
order.
may be perused, my
My lord, we are not
Photos, they're
objecting the order.
enjoying.
We are not objecting the order.
I'm grateful.
My lord.
So what to do? No. No. This court is not an executing court. Please understand. If somebody is not complying with the orders of the court, there is a procedure. Court will not take up matters again and again and pass orders.
My lord, in this case,
No.
the humble prayer, my lord. Just that the video calling may be reduced to weekly 3 days, my lord. Humble prayer. It is really impacting on 5 years of
No, it is not some ego tussle that something
Please.
or the other court should pass an order. No, court should be convinced to pass an order.
It's 47 also, it's the same. my lords.
Yes, both the matters.
I'm
after
grateful.
revision.
ಮೇಡಮ್ ಅದು ಹೆಂಗೆ ನೀವು ಮೇಕಪ್ ಬರೀ ನಾವು ಅವತ್ತು ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿ ಹೇಳಿ
ಪಾಸ್ ಓವರ್ ಒಂದೇ ಒಂದಿದೆ ಇದ್ರೆ
42, madam. Hello.
Court officer? Court officer? Court officer? Court officer? Court officer? Court officer?
ಏನ್ ಹೇಳಿ ಸರ್?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಕೇವೇಟರ್ ಯಾರು ಹಾಕಿರೋದು ಕೇವೇಟ್ ಅಂತ ಸ್ವಲ್ಪ ಹೇಳಕ್ಕೆ ಫೋನ್ ನಂಬರ್ ಏನೋ ಸಿಗುತ್ತಾ? ಬಿ ಶರತ್ ಕುಮಾರ್ ಅಂತ ನೋಡಿ.
18 ಅಲ್ಲಿ
ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಕೇವೇಟ್ ಹಾಕಿದ್ದಾರೆ, ಅವ್ರದ್ದೇನೋ ಫೋನ್ ನಂಬರ್ ಸಿಗುತ್ತಾ ಅಂತ.
ಅವ್ರದ್ದು ಫೋನ್ ನಂಬರ್
ಫೋನ್ ನಂಬರ್ ಫೈಲ್ ಅಲ್ಲಿ
ನಮ್ಮ
ಇರುತ್ತೆ.
ಫೈಲ್ ಇಲ್ಲ ಸರ್, ಫೈಲ್ ಹೊಟ್ಟೋಯ್ತು.
ಫೈಲ್ ಹೊರಟಾಯ್ತಾ? ಓಕೆ ಮೇಡಮ್,
ಯಾವ್ದಾ ಮೇಡಮ್? ಇದು ದೊಡ್ಡದು
ಏನ್ ಸೀರಿಯಲ್ ನಂಬರ್?
ಸೀರಿಯಲ್
ಅಲ್ಲಿ
42 42
42 ಅಲ್ಲೇ ಇಟ್ಟಿ.
ರೀಚ್ ಆಗಿಲ್ಲ.
ಅದು ರೀಚ್ ಆಗಿದೆ, ಅದು ಏನ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಅಂತ.
ಯಾವ್ದೀಗ ವಿಚಾರಿಸಿದ್ರೆ ಅದಾ
ವಾರಂಟ್ ಆಗ್ಬೇಕು ಅಂತ. ಇದು ತೊಳಿ, ಇದು
49 ಇನ್ನೂ ಆಗಿಲ್ಲ.
ನಂಬರ್ 13 ಅಲ್ಲಿ 13 ಅದು ಎಂಆರ್ ಆಯ್ತಲ್ವಾ? ಮತ್ತೆ ನನಗೆ ನೋಟು ಅದು ಹಂಗೆ ಆಗಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ. ನಿನ್ನೆ ಬಂದು 28 ಕಳಿಸ್ಬಿಟ್ಟಿರ್ತೀರಾ ಮತ್ತೆ ರಿಟರ್ನ್ ತರಿಸ್ತೀನಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಪಾಸ್ವರ್ಡ್ ಈಗ ಹಾಕವ್ರೆ ಇಲ್ಲಿ ಹಾಕ
ಅಲ್ಲ
ಅದ್ಯಾವ 230 ಇದೆ ಅಂತಲ್ಲ, ಯಾವ
ಇಂಚಮ್ 25
ಇಲ್ಲೇ ಇದೆ.
26
Hello, court officer.
25 ಸೀರಿಯಲ್ ಎಲ್ಲಿದೆ?
365 ತಗೊಂಡೋದ್ರೇನೋ ಅವರು
ಮೇಡಮ್
ತಗೊಂಡೋದ್ರೇನೋ.
ಹಾಗಾದ್ರೆ ಚೇಂಬರ್ಗೆ ಕರೀತೀನಿ.
Madam, second list ತಗೋತಾರಾ?
ಇವಾಗ ಹೋಗ್ತಲ್ಲ ಮಾಡಿ.
Madam, second list ತಗೋತಾರಾ? Madam, second list ತಗೋತಾರಾ?
ತಗೋತಾರೆ ಸರ್, ತಗೋತಾರೆ. ಹೋಗ್ಬೇಕು. ಅದನ್ನ ಕೇಳ್ಬೇಕು. ಆರ್ಟಿಫಿಷಿಯಲ್ ಮಾಡೋದು ಕೇಳಿದ್ರು
ಗೊತ್ತಿಲ್ಲ ಸರ್ ಸಾಯ್ಮಾಡಿ ಫೈಲೆಲ್ಲ ಹೊರಟಾಯ್ತು ಸರ್ ಸೆಕೆಂಡ್ ಇಷ್ಟ ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ ತಗೊಂತೀರಾ ಲಿಸ್ಟ್ ತಗೋತೀರಾ ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಇನ್ನೂ ಮುಗಿದಿಲ್ಲ ಆದರೆ ಲಿಸ್ಟ್ ತಗೊಂತಾರಂತೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಎಲ್ಲರಿಗೂ ವೇಟ್ ಮಾಡಬೇಕು ಬೆಳೆ ಎಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ 51 ತನಕ ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್
ಅದಕ್ಕೆ ಬಂದಿದೆ ಇಲ್ಲ ಎಲ್ಲರೂ ಮೊಬೈಲ್ ಬಿಡ್ತಾ ಇದ್ದಾರೆ ಅನ್ನೋ ಯಾರೋ ಬಿಟ್ಬಿಟ್ಟು
ಅದೇ ಅವಳು ಇವಳಿಗಾಯ್ತಲ್ಲ ಇದು ಫೈಲ್ ಕಳಿಸ್ಬೇಕಂತೆ ಚೇಂಬರ್ ಡಿಪ್ರೆಷನ್ ಇದೊಂದು ಫೈಲ್ ಮೇಡಮ್ ಡಿಪ್ರೆಷನ್ ಅವರು ಪ್ಯೂನ್ ಯಾರೋ ಹೋಗಿದ್ರು ಅವ್ರ ನಂಬರ್ ಫೈಲ್ ಬೇಕು எல்லா கேஸும் அலோவ் பண்ணுவோம் எல்லா கேஸும் அலோவ் பண்ணுவோம் ಎಲ್ಲ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲವೇ ಮೇಡಮ್ ಹೇಳ್ತಿದ್ದಾರೆ why all are in non compliance, why she has posted like that ಅಂತ ನೀವು ಅಟ್ಲೀಸ್ಟ್ ಹೇಳ್ಬೇಕಲ್ವಾ ಮೇಡಮ್ ಎಲ್ಲ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಅದು ಮನೋಮೋ ಮಾಡಿರೋದು ಅಂತ ಅಲ್ಲ ಈಗ ಹೇಳಿ ಕೇಳ್ತೀನಿ ಕೇಳಿ ಮೇಡಮ್ ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ ಒಂದ್ಸತಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಈಗನೇ ಈಗ ನಮ್ಮ ರೋಸ್ಟರಲ್ಲೇ ಪೋಸ್ಟ್ ಆಗಿ ತಿರ್ಗಾ ಮೆಮೋ ಮಾಡಿದ್ರೆ ಈ ತರ ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡ್ದಲೇ ಇದ್ರೆ ಅನ್ಲೆಸ್ ಅಲ್ಲಿ ಏನ್ ಗೊತ್ತಾ ಈ ಲೆಫ್ಟ್ ಕಾರ್ನರ್ ಅಲ್ಲಿ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಸ್ಟೇಟ್ ಮಾಡಿದ್ರೆ ಅದು ಡೇಟ್ ಬರ್ತಿತ್ತು ನಿಮ್ಗೆ ಲೆಫ್ಟ್ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ ನೋಡಿ ನಿಮ್ಗೆ ಅಂತದಿಲ್ಲ ಅಂದ್ರೆ ಪದೇ ಪದೇ ರಿಪೀಟೆಡ್ಲಿ ಮೂವಿದ್ರೆ ಹಾಕ್ಬೇಡಿ ಒಂದೇ ದಿನ ಇರೋದು ಆಸ್ಕಲ್ ಟು ನಾಟ್ ಟು ಪೋಸ್ಟ್ ಇಫ್ ದೇರ್ ಇಸ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಎಲ್ಲ ಇವತ್ತು ಏನ್ ಗೊತ್ತಾ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ ವಿಶ್ವದಲ್ಲಿ ಅದಕ್ಕೇನೆ why even then they are not complying the office applications, why they are moved before the court and again and again once again after compliance also they will be for memo is the madam ಹೇಳಿದ್ದು ನಾನು ಹೇಳಿದೆ ಓಕೆ ನೋಡ್ಕೊಳ್ಳಿ ಪದೇ ಪದೇ ಮತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ಮತ್ತೆ ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿ ಏನಾದ್ರು ಆಗಿದ್ರೆ ಮತ್ತೆ ಅದನ್ನ ಮೂವ್ ಮಾಡಿದ್ರೆ ಅದೆಲ್ಲ ಹಾಕುವಾಗ ಸ್ವಲ್ಪ ನನ್ನ ಗಮನಕ್ಕೆ ತಂದ್ಬಿಡಿ ಸುಮ್ಮನೆ ನೀವೇ ಟೊಮೊಟೊ ಹಾಕ್ಬೇಡಿ ಎಷ್ಟಿದೆ ಇಲ್ಲ ಜಾಸ್ತಿ ಏನಿಲ್ಲ ಇದ್ರೆ ಒಂದು 8 ಇರ್ಬೋದು ಅಷ್ಟೇ ಜಾಸ್ತಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಕೇಳ್ಕೊಂಡಿದ್ದು ನಮಗೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಗೊತ್ತಿಲ್ಲ ಬೇಕಾದ್ರೆ ಕೇಳ್ಕೊಂಬಿಡಿ ಇವ್ರದ್ದು ರೋಸ್ಟರ್ ಇದು ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ದು ಎಷ್ಟಿದೆ ಎಲ್ಲ ಸೇರ ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ದು ಸೇರಿ ಕೇಳ್ಕೊಂಬಿಡಿ ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಬೇಕು ಅಂತ ಈಗ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಜಾಸ್ತಿ ಇಲ್ಲ ಅಂದ್ರೆ ಪ್ರಾವಿಷನ್ ಕೋರ್ಟ್ದು ಮತ್ತೆ ನಮ್ದು ಸೇರಿ ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಬೇಕು ಮೇಡಮ್ ಫ್ರೈಡೆಗೆ ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ ಅಂತ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್ ಫೋನ್ ಮಾಡಿಬಿಟ್ಟು ಕೇಳ್ಕೊಂಡ್ಬಿಡಿ ಇವಾಗಲೇ ಕೇಳ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ ಅದೇ ಕಡಿಮೆ ಇದೆಯಲ್ಲ ಇನ್ನು ಪಾಸ್ ಓವರ್ ಬೇರೆ ಇದೆಯಲ್ಲ ಎಷ್ಟು ಇದು ನೆಕ್ಸ್ಟ್ ಒನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 12 5252525 ಇದು ಬಿಫೋರ್ ಲೋಕದ ಫೈಲ್ ಇದೆಯಲ್ಲ ಅಲ್ಲ ಅವು ಬಿಫೋರ್ ಲೋಕದ ಎಲ್ಲ ನೆನಪಿಲ್ಲ ಇದು
ಬರ್ದಿರ್ತೀನಿ ಬಿಡು. ಅವಾಗ
ಅದು ಎಮ್.ಎಸ್.ಎ. ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಇವ್ರನ್ನ ದೇಶಕ್ಕೆ ನೋಡ್ಕೊಂಡು ಲೋಕದಾಗ ಮುಂದೆ ಲಿಸ್ಟ್ ಮಾಡಬೇಕು. ಎರಡು ನೈಟ್ ಟೋಟಲ್ ನಂಬರ್ 24 ಗೊತ್ತಿಲ್ವಾ? ಎಮ್.ಎಸ್.ಎ. 24 ಟೋಟಲ್ 25. ಅದು ಲೋಕದಾಗ ಮುಂದೆ ಲಿಸ್ಟ್ ಮಾಡಬೇಕು. ಮ್ಯಾಟರ್ಸ್ ಲೋಕದಾಗ ಹೌದು. ಬುಕ್ಕಿಗೆ ಇದೆಯಲ್ಲ ಬರೀ ಅವನೇ ಬರ್ತಾರೆ. ಶ್ರೀರಾಮ್ ಜನರಲ್ ಒನ್ನು ಆಮೇಲೆ ಬರ್ದಿಲ್ಲ ರೆಕಾರ್ಡು ಈಗ ಎರಡು ಮ್ಯಾಟ್ರು ಅಲ್ಲಿ ಹೋಗಿ ಅದಕ್ಕೆ ಬಂದು ಅದಕ್ಕೆ ಎರಡು ಮ್ಯಾಟ್ರು ಆಗ್ತಿದೆ.
ಇದ್ರೆ ಹಂಗೆ ಹಂಗೆ ಕಟ್ಕೊಬರ್ತೀನಿ ಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಮಾಡಿಸ್ಬಿಟ್ಟು ತಗೊಳ್ತೀನಿ ಸರಿನಾ
ಅವರತ್ರ ಅದೇ ಅದು ಇನ್ಶಿಯಲ್ ಡಿಸ್ಕಷನ್ ಡಿಸ್ಕಸ್ ಇನ್ ದ ಚೇಂಬರ್ ಅಂತ ಸೈಟ್ ಕರ್ಕೊಂಡು ಹೋಗೋದು. ಅದೇ 358 ಬೆಳಗ್ಗೆ ಒಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಲ್ಲ ಎಲ್ಲಿ ಇದು ಲಿಸ್ಟ್ ಕೊಡಿ ಅಂತ ಇವರು ಇಸ್ಕೊಂಡ್ರು ನೋಡಿ. ಅಲ್ಲ ನಮ್ಗೆ ಲಿಸ್ಟ್ ಎಕ್ಸ್ಟ್ರಾ ಇದೆಲ್ಲ ವಾಪಸ್ಸೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೇ ಕೊಡಿ ಅಷ್ಟೇ. ಹಂಗೆ ಅಲ್ಲಿ ಲೈಬ್ರರಿ ಕಡೆ ಸಂತಿ ನೋಡೋಕೆ ಅಲ್ಲೆರಡು ಅದೇ ಅವರು ಶೆಟ್ಟಿನೋ ಯಾರು ಅಲ್ಲಿ
ಆಫ್ ಮಾಡಿ ಅದನ್ನ.
ಹಲೋ ಮೇಡಮ್, ಇವರು ಸುಗುಣ ರೆಡ್ಡಿ ಆಫೀಸ್.
ಯಾರು ಅಲ್ಲಿ? They should give some there.
ಯಾರ ಆಫೀಸ್?
ಏನೋ ಕುಡಿತಾರೆ, ಬೇರೆ ಏನೋ ಕುಡಿದ್ರೆ
ಈಗ ವಿಡಿಯೋ ಆನ್ ಮಾಡಿದಲ್ಲ.
ನೋಡಿ ಇಲ್ಲಿ ತಿರ್ಗಾ ಮತ್ತೆ ಬರ್ತಾ ಇದೆ.
ಹಲೋ ಮೇಡಮ್, ಹಾ ಅವ್ರ ಆಫೀಸ್ ಅನ್ಸುತ್ತೆ. ಅಲ್ಲ ಏನ್ ಗೊತ್ತಾ ನೋಡಿ, ನಾವ್ ಅದಕ್ಕೆ ವಿಡಿಯೋ. ಹಲೋ ಮೇಡಮ್, ಯಾರ ಆಫೀಸ್ ಅಪ್ಪ ನೀವು?
ಅಲ್ಲ ಆ ಪಾಕೆಟ್ ಇಟ್ಕೊಂಡು ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ ಇದು ಲೈವ್ ಕೋರ್ಟು, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕು ನಾವೇನ್ ಹೇಳೋದು. ನಾನೇ ಅನ್ಕೊಂಡೆ ಬಟ್ ಕಾನ್ಸೆಪ್ಚುಯಲ್ ಅನ್ಕೊಳ್ಳಿ.
Okay, charge நம்ம எடுத்துட்டு வந்திருப்பா. சரி, அங்கேயே நம்ம படிக்கலாம்.
Lordship, kind permission. Your Lordship, this honorable court passed the order. In spite.
I think you already made a mention and I
Yes,
said
my
so.
lord, but it is not executable order. I went there in family court in order to file execution petition.
For the contempt of the court's order, you can. What else the remedy is?
My
No,
lord,
no, one order is there. How do you expect the court to pass another order to
I
implement
take
the
chance,
other
my
order?
lord, because 1 month order is there. Your Lordship.
I'm sorry. I'm sorry. Yes, next, call the passwords.
Passover matters. Case number 1, serial number 12.
Yes. This matter,
Yes,
there was a calculation.
yes,
Have you seen that?
I've seen the calculation, my lord.
Are you okay with that?
My lord, only two submissions, my lord. This is a case of femur fracture and right forearm fracture, my lord. And there is a permanent disability. Under the head of loss of amenities, my lord, only 5,000 my lord has enhanced.
No, 30,000.
No, 30,000 apart from the tribunal's amount, my lord.
It is 30,000.
30,000 because
It is
tribunal.
like, this amount is
25,000
over and above the, I mean, against the.
Against the amount awarded by the tribunal.
Tribunal awarded 7,87,000.
Yes.
This court is saying that it is 11,05,000.
My lord, what I would pray is, my lord, because in view of the injuries suffered, my lord, serious femur fracture, he's undergone surgery, permanent disability is there, he's a manual laborer, mason. So, my lord, amenities, more enhancement.
How more it is?
My lord, what I would, my lord has granted 30,000. I would ask for 70.
Oh, 50,000 is only 30,000.
Yes, my lord, I would ask for another 50,000.
Your disability is how much?
Disability is 12 point. What I would.
12.5%.
My lord, functional.
12.5%
Yes, my lord,
disability.
functional disability.
No,
In this
no.
case.
If this court starts doing for 12.5, 50,000.
Yes.
Then what about the other cases?
My lord, what I am submitting is, this is a case of permanent disability. Functional disability. I would.
What do you say? Maximum, can it be enhanced by another 10, 20, 20,000? Huh? 20,000 will grant.
My lord.
So it will come to
25,000.
25,000.
Please.
My lord, even under the head of pain and suffering, my lord.
This is
60 is given.
60 is given, another 25,000, at least 75,000.
There is a
My lord,
pattern. There is a
because my
pattern.
lord,
What I'll do is I'll pass orders on the merits of it if you don't like it.
my lord, what I'm submitting is, my lord, functional disability ought to have been awarded in this
You
case,
know,
my
you
lord.
regularly appear, how
Yes,
the
sir.
court grants.
Please.
No exception to this case.
Yes.
So file a joint memo in the unit. 11,25,000. Learn counsel appearing for the insurance.
With interest is separate.
The learn counsel appearing for the insurance company. So they're ready to pay an amount of rupees 11,25,000 against the awarded amount of 7,87,626, and the interest is at 6%, and they'll file a joint memo to this effect. Yes.
My lord,
Today evening at
57.
5:30. Huh?
Please, my lord, I will do that. 57, my lord, serial number
Calculation is
57. That is, I have agreed to the
Calculated.
calculation.
57. What is the calculation 57?
The 98,000 and odd.
4,89,000.
It is submitted that the insurance company is ready to pay an amount of this 4,89,000
As
against the award of 3,90,750, interest at 6%, and they'll file a joint memo before the Lokadar.
Interest is separate, my lord.
You already said so.
Yes.
Yes.
Fast. Next to.
Yes.
Case number 2 continues. Till number 48.
Yes.
48 Syed Khalil Pasha.
47, what happened?
47 after vacation, ma'am. Same.
48.
Yes, filed an application before the trial court with regard to the cross-examination of PW1.
Let's see the order impugned.
Page number 24, my lord. 23. My lord, what happened, my lord?
The MC of 2020.
Filed.
An application is filed to recall PW1 for further exam. Who filed the MC?
My husband is filed. I'm the wife, my lord.
Please come to the affidavit filed in support of the IA.
My lord, page number 29, my lord.
Page number,
29, my lord.
please read the application. What is the reason for this application?
My lord, I further submit that effectively conduct the case on merit. It is very much essential for reopen. After cross-examination, my lord, page number 29. Earlier counsel appointed by me, my lord, is not conducted the case, my lord, my brother colleague.
Such a ground is available.
I appointed new
For
counsel.
example, every time a new advocate is appointed, you get a right to.
No,
further cross-examine.
my lord, no, my lord. Opportunities to
You
be-
should say, what is that not being done? With all these vague allegations, cases cannot be reopened. What says, I have, above matter is posted for further evidence. And since today, I have changed my advocate and filed NOC wakalat. But when new counsel needs to cross the petitioner, hence above the application.
Yes, my lord. Some,
Not the ground.
my brother.
At least you could have told, you could have said in this application that this is my case. This is not, so and so, no, not has been, or something. Not just changing the counsel cannot be a reason. And if these kind of applications are allowed, the trials will never come to an end. Please come.
My lord, next week, my lord, after occasion, my lord, I'll take chance. Please, my lord.
Why? I heard you. I
No,
would
my lord,
not find a reason in this.
No, my lord. Next
Why to
week.
keep it pending?
No, my lord. The matter will going to go for, no, my lord. Next week, I'll take after occasion, please.
Why to keep it pending?
No,
When
my
the
lord.
matter is before the court and the court is not convinced, why should we keep the writ petition pending? We'll pass orders.
No, my lord. I'll file necessary application with
What
regard.
application?
I'll take chance, my lord. Next week, my lord. After occasion, I'll take chance. Please, my lord.
Does this matter tomorrow, on Friday? No further adjournments, whatever you want to say it on Friday. Yes, 49?
Still number 49. Sumangalaya Swami.
No representation, this after vacation.
Still number 50.
No, yes.
I'm for the husband, my lords, petitioner.
Kumaram.
What is the order?
My lords, in this, the marriage was solemnized on 11.
What is the impugned order?
Not the impugned order, my lords.
Huh?
Speedy disposal.
Speedy disposal. Which year is the MC?
2000. MC is on
Of 2020
my lords.
Bangalore.
Yes, my lords. The wife.
Why it should be disposed of expeditiously?
My lords, because it's of 2020, my lords. And
you know, Bangalore, there are more matters.
yes, my lords. My lords. The thing is, in the mediation, it was referred, my lords. 12 sessions was.
Which is done in every case.
Yes, my lords. The husband and wife, they sign for the agreement, my lords. Later, the wife, she cancelled the agreement, my lords, filing an application.
No, that cannot be. There are all the disputes between you and the respondent.
Yes, ma'am.
But that's not the ground for this court to say to expeditiously dispose of
Yes, my lords.
pending the old matters. This is more
lords,
important because somebody has come to High Court.
My
This
lords.
is an MC. The present petition is filed. Seeking
lords, it may
disposal
be
of this
adjourned.
expeditious disposal of MC, which
Lords,
is
it
of
may
the
be
year
adjourned.
20.
Adjourned, my lords. Senior will argue on this.
Huh?
It may be adjourned. Senior will argue on this matter.
Why it should be adjourned? Let your senior come Friday. Yes, next. 51.
Still number 51.
I appear for the
Nagaraja.
petitioner. My lords, the petitioner is the impugned order, my lords, is at page 27. Yes. And if my lords can just see, the operative portion is at page 42.
Yes.
The operative portion, the order, in fact, this is for visitation. The from 42.
Who has filed a G&WC?
G&WC was filed by the father. I'm sorry, mother. Now, my lords, kindly see the
Children are in
operative.
the custody of the father.
The daughter is with the mother. And now, my lords, there is little bit of history. Now, what the operative portion itself is very long because the weekend, vacation, all those are ordered. Now, because we are here today before the vacations, my only concern is the vacations. What vacation orders are given? If my lords can just see at page 42 in the operative portion of the order, the third para, respondent shall have interim custody of the child during summer vacations from 10 a.m. on 29th, that is from today, to
4 p.m. till 21st. That is the entire month the child is asked to be handed over. Now, my lords, there is a little bit of history. My lords, initially, there was a joint directions. My lords may just see for a moment at page 228. Initially, there were some early visitation orders. A contempt petition was filed. And in the contempt directions at page 230, 230 at para 6 and 7, parties, the lawyers had agreed that the father can have the child from Saturday morning to Sunday 12 o'clock and video calls. My lords, page 230, para 6 and 7. My lords found that?
It doesn't say about the time.
No. Saturday morning to Sunday before noon, 12 o'clock. And 1 minute. Then, so this was initially agreed along with video calls. Thereafter, that was being done. Then my lords may just see the next page, page 232. Thereafter, in the G&WC, parties filed a very detailed joint memo. In the joint memo at page 232, kindly see, my lords, in the first para, regular visitation, that he will pick up the child from Saturday 9:30 a.m. and drop her back at 12 noon. And then the next para is audio video calls for the father. And then, my lord, summer vacation. This was last year. This was filed in April 24. And then summer vacation, what was agreed by them, next page, just on top.
Yes.
2 separate weeks.
Yes.
1 week, May 4th to May 9th, about 4 days. Then a gap. And May 21st to May 26th, 3 days. These three days were agreed with overnight. This was agreed. And at that time, they had, they had agreed at page 236 that over and above this, in the last para of this joint memo, that parties pray that to accept this joint memo and dispose of IA-9 with liberty to the respondent to file any other application for the next summer vacation. This was going on. When this was going on, in fact, the mother has been sending the daughter what was agreed, every weekend, and even the summer vacation, 3 days. What was happening, my lords, and video calls were being done. What was happening, my lords, may just for a moment see, it has become such a form of harassment. Kindly just 307, page 307. Video calls under the, we said yes, video calls are fine. But then video calls became 307, my lords. Annexure L, video calls with all his family members. Kindly see at 307 with his mother, 2 hours video call. My lords can see the time, 2 hours on 31st Jan 25. Next page, 26 Feb, 1 hour, 1 hour 7 minutes. On the next page, 28 Feb. Next page, my lords, 4th March, 47 minutes. 13th March, 51 minutes. My lords, not a single call. These are just some of the printouts. Every day, about 1 hour video call. Then, my lords, when he comes to pick her up, 1 minute. He comes to pick her up at page 285 on every Saturday, Sunday. I want to just show the mentality of the father and how these visitations have become a form of harassment. Page 285. Page 285. Yes, these are the emails. Kindly see, my lords, the second para. However, she writes to him, however, I will have my legal counsel talk to yours regarding this because this is harassment where you mention 3-minute and 10-minute delays. You are continuing to take pictures of me and I want this communication on record to stop. You're taking pictures of me, is making me uncomfortable. What he does, even if the child is dropped off or is given 3 minutes late, he takes a picture of the mother, of me. And then he replies at the bottom of the page. Every minute adds up and now it stands at 1 hour 20 minutes. I have to be compensated completely and every minute hereforth that you delay handover of Kia to me. I have already told you I'm taking pictures of you handing over Kia to me for my own proof and for legal reasons. As you are a born liar, you can do what you want. And on the next page, at page 286, he makes a detail of all the delays of handing over. Kindly see, my lords, 3 minutes, 12 minutes, 7 minutes, 10 minutes. He's an obsessive person who goes to this extent. So every weekend, this kind of harassment goes on, where even if there is a 10-minute delay, if the daughter is getting ready, 8-year-old girl is just getting ready with her things, he takes a photo of me. Not a single pie of, and thereafter, when the arguments on IA-12 is filed for these vacations. When the arguments of IA-12 is filed, when the counsel is arguing, my lords, kindly see at page 328, he comes to attack the counsel, the respondent, and a memo is filed to that effect. This is the memo. The memo starts at page 327. On 19th, at page 327 is the memo that was filed after the arguments were done. May I refer to para 8 at page 328. She has filed a memo in the court at para 8. On 8/4/25, the above matter was set down for hearing on behalf of petitioner on IA-12 filed by the respondent. During the hearing, counsel for petitioner commenced arguments in the matter. However, almost immediately, the respondent began interrupting the submission, raising his voice in a disrespectful tone and interfering with the proceedings of the court. Upon being cautioned by his counsel to maintain decorum and restraint, the respondent's conduct remained temporarily subdued. Then kindly come to para 10. Upon hearing this submission, when the counsel made some submission about him, respondent once again lost control and began shouting and raising his voice in the courtroom. In a sudden and shocking escalation, the respondent aggressively advanced towards the counsel for the petitioner in a threatening manner, baring his chest and flexing his muscles in a hostile and intimidating posture. He did this to the counsel, and then kindly see the next page, para 13. Even more gravely, while the proceedings were still ongoing, the respondent deliberately approached the petitioner and in a threatening and menacing tone told her, "I will deal with you outside the court." This statement was made in the court. So this kind of threats were made, physical aggressions to the counsel and to the mother in the court. She files this memo, and in the same memo, the last page, what she says, at page 330, she says she gives a proposed visitation. She says that respondent must undergo anger management therapy or counseling session with a recognized medical professional or a court-approved mental health practitioner with periodical reports, and respondent must be required to be accompanied by his parents during visitation, pickups and drops. In fact, when the IA was filed, initially she had given in her objections, she had agreed to some visitation during the summer vacation in an attempt that it is amicable and we are not fighting and that was initially at page 251. She herself had given this. These are the objections to the IA. 251, there's a table given, my lords. Proposed visitation schedule. Keeping the child's physical, mental and emotional stability. Respondent may be permitted, my lords found that table. Respondent may be permitted to take the child to his residence once a month for an overnight stay during weekend. Once a month, he will take the child, petitioner will hand over the child at 10 a.m. Saturday and Sunday 5 p.m. So she wanted this once a month and not every weekend, which was becoming too harassing for the child. And she does not get a single weekend with the child. Then pick up and drop shall be the responsibility of the respondent at a neutral location, because he was coming to her house and doing this. And then summer vacation, what she had suggested is 10 consecutive days of custody in the first month and another 10 consecutive days in the second month. And in fact, in her objections, she had specifically stated that this kind of aggressiveness, in fact, at para 16 and 17, she has stated that this kind of aggressiveness that he is showing both towards her and in fact even to the child is not in the child's welfare. Now, my lords, and this was before all the incidents took place even in the courtroom. In fact, she is quite shaken because he has come out of the court and said, "I will see to it. I'll see what you'll see what I'll do with you." Now, inside the courtroom. Now, the learned family court judge has in fact referred to that. In the order at page 36, learned family judge has referred to it, but absolutely has had no impact. At page 36, para 7. on 19/4/25, the petitioner filed a memo which is in the form of additional objections to this application. In the said memo, it is stated that respondent has shown his erratic and aggressive behavior in the past before the open court during the proceedings. Respondent's long-standing issues with uncontrolled anger, violent outbursts, particularly road rage, rash driving, and hence he must be required to be accompanied by his parents during visitation, pickups of the child to ensure supervision. In her objections and aforesaid memo, petitioner has proposed visitation schedule. Yes, I had initially proposed. Thereafter, this incident also happened, and I have submitted the memo thereafter. And merely what the learned family court judge has done is merely because I have agreed. The reasoning is that petitioner has agreed. In fact, at page 41, at para 19, that is the only basis that I have agreed. Para 19, page 41, that on perusal of the entire objections of the petitioner, it is clear that she is not denying to allow the respondent to have overnight custody.
No, she has
No.
some difficulties with how he's doing. Then we have to look for the means to come out of it and still fix her visitation.
Correct.
But
Now-
but because she is having difficulty, it
I
can't
am
be once in a month.
no, I'm not completely denying. Now, what my request, my lords, just at least for the vacation, other visitation we can postpone and have it immediately after vacation, just for the vacation period. Now, my lords, there is 1 month left. School is reopening. In fact, she's
As
also
per this order, how it will go?
as per this order, 29th, that is today. I'm supposed to hand over to 21st of May. So it is almost 4 weeks. This is the order given.
When the till what day is the vacation?
I'm sorry, when the vacation started?
No, no.
No,
When
no.
it ends?
2nd June or 4th June? 2nd June. So in fact, entire month of May. Now, my lords, I just have one submission for the vacations. She also wants to take the child. Her relatives stay in Dubai. She wants to take the child for vacations for 2 weeks or 10, 12 days to Dubai. She has not booked her tickets because she can't do it unless there is an order, because she can't violate the order. Now, my lords, earlier when the joint memo last year was filed, she herself had given 3-4 days with the gap. Let him take the father take the child for 1 week. Let the father take the child for 1 week. On next 1 week, some dates can be fixed. Thereafter, she can take the child at least for a holiday. Every weekend, my lords, this has been happening. At least, and then we'll come back to my lords. We'll come back to my lords. We are not saying not to take it all.
Holidays are for 4 weeks. So how the 4 weeks are going to be?
2 months.
She will.
No, 1 month is over.
28th of March vacation started.
Correct. 1 month is over. April, May were the 2
What she
weeks.
was doing from March?
No, nothing. They were here. This Saturday, Sunday, weekends were going on. No. 1 minute. When did the vacation start? Sorry, where is she? When did the vacation start? Yeah, my friend is right. 1 month is over. During this time, the Saturday, Sunday was going on.
What the court said, because 28th March to 20.
No, I agree. That I agree. That is the
Between you had the visitation.
Only weekend visitation. One day.
weekend. No, it's not 1 day. It's 1.5 days.
Sunday or only one?
No, Saturday to Sunday afternoon. Saturday morning to Sunday afternoon. Overnight was happening.
Sunday also.
So, like 4 days, around 4 days.
Not 4
4 days.
not 4 days.
In the month.
No. It is 1 and 4 weekends. She goes on Saturday morning and comes back Sunday afternoon.
8 days.
Yes, that was happening. That we are. And even I believe one festival day also in between, she has gone. The Vishu or some festival was there. So in fact, their previous year's joint memo had detailed agreements. This festival, that festival she will send. So she has complied with that. There is no non-compliance. School reopens 2nd.
2nd of?
June. Not a single school fee is paid. And my lords, this kind of not a single weekend she gets. At least let the mother take the child for a holiday. And even what was agreed by us in the past was 3-4 days and thereafter 3-4 days. Even this 1 month was never agreed last year. When last year we have agreed and had a detailed joint memo, shouldn't something like that be followed, my lords? That was agreed by the parties. Yes, they may always, any party may file an application for visitation, but to jump from 3-4 days to, she has not even stayed for more than 1 night with the father. To jump to 1 whole month,
Yes, Mr.
Lord, I think the senior advocate has not been instructed correctly on facts. I've been having this visitation joint memo filed last year was on the last day I closed for vacation. Court directed both parties arrival an arrangement for this year. Next year, the court will consider. We were discussing settlement of the entire dispute when we are hit with an application before the family court where the mother wants to change her residence and the child school of the child. That would not constrain the father to file an application for regular visitation and vacation custody. 1 month of the vacation is over already. It is not their case. The child is not comfortable, my lord. The submission so far has been all about his behavior, her behavior, the interpersonal disputes that they have. There is not one submission that the father is not treating the child properly. The child is not comfortable with the father. The child is extremely comfortable. My lord, and what is awarded is right now 20 days, only 3 weeks of vacation out of 10 weeks. And for that, I don't think, and she herself has proposed before the family court on 5th of April. 20 days let the father take the child for vacations.
Sure, nothing. What is the date?
No, what happens is even for to go on vacation anywhere,
yes,
every weekend there is an order for exercising the visitation.
My suggestion was this. Last time I said I'll come and pick up the child on Saturday, this Saturday, 3 days ago. The mother writes me an email and tells me, you cannot pick up because vacation, I'm dropping her off on Tuesday to you. Therefore, vacation custody you will have fully. During vacation, there's no weekend visitation. She writes an email. That's her understanding of the order and comes before your lordship and claims the contrary. The last page, your lordship may kindly see. When I say I'll come and pick up on Saturday, copy is there. The last page, at the foot of the page, if your lordship goes, 25th April, the last line, for this weekend's custody, as per orders passed on 23/4, please drop Kia at Regency Place at 10 a.m.
Yes.
She says, stating the order, respondent shall have interim custody of the child during summer vacations from 10 a.m. on 29/4 till 4 p.m. on 21/5. So he says, kindly read the part of the order. Your lordship may go to the first line on page 90. I have read every word. Summer vacation arrangement is different, which is why it is specifically mentioned. Please find it.
Are you reading that?
Page number 90, first line. When I asked for weekend visitation,
I've read every word.
I've read every word.
Yes.
Summer vacation arrangement is different, which is why it is specifically mentioned. She says you don't have weekend visitation during summer. You have vacation custody from 29th of April till 21st of May.
So from 29th to 24, I mean, whatever visitation she had, at that point of time, you were never exercising the weekend.
No, they were exercising.
Last year during vacations, he had when he had vacation.
According to you,
yes,
for her the vacation started from 28th March.
Yes.
So from 28th March,
I've had weekends. But whenever we had a vacation arrangement earlier, as per the joint memo, when I have vacation custody of my daughter.
No, this vacation from 28th March.
Yes.
Yes, till now, you were having the weekend visitation.
One day I had, yes.
So there was no time for her to skip the weekend vacation. So what this court is proposing is, both of you let her have 2 continuous weeks without a weekend, and what remaining time let your client have. How many days it will be? Now today we are on 29th.
Yes.
How many days?
29th, 30th, 31. So about 34 days of vacation.
About 34 days.
34 days of vacation.
From now on.
Yes.
So in that, let her have 12 days. Remaining days you have.
Very good.
That will also compensate.
What are my lords proposing? Can my lords just clarify? Yes.
You say that she wants to take the child out of country.
Yes.
So let her go for 12 days.
No application is filed before the family
No,
court.
doesn't matter. I can put it on record and
absolutely not.
No, the court can record my dates.
Section 26 of the Guardian and Wards Act bars a person
if
from
this is the
traveling out.
attitude
Not
every
my
weekend.
attitude. Not my attitude. It is the attitude of the mother. She's assuming that she can travel anywhere in the world she wants without court's permission.
May I just, because my lord suggested, what she is suggesting, if my lords can consider, is that the second half of May, that is from say 16th onwards, she does not mind, instead of breaking it, let it not be broken till the first half, till about 14th, 15th.
Let them have.
Yes.
So
and then 16th onwards.
No, let it be.
Then she can plan so that she can go for a longish period.
Let it be from tomorrow.
Today.
Today. It has to be. It is supposed to be today.
tomorrow, because she has to go back to Whitefield. It's a long way. Tomorrow morning.
I
Yeah,
know, we'll
she'll
just
pack it up. Tomorrow the child's packing.
Tomorrow is
30th.
tomorrow is 30th. Huh.
Till for 2 weeks.
No.
Till
34 days.
2 weeks. 2 weeks.
34 days left.
No.
For you 12 days. Already you had 1 month continuous.
My lords, my lords, litigation was going on. My lords, I'm with great respect. Mother is, in fact, despite not wanting this also, she's being extremely fair to say, let him take till about 14th, 15th May. I'm only asking my lords to consider. Then 16th onwards, which is a Friday, she can then plan her travel.
How many days then?
No, I will get 14 days and she gets 20 days.
1, 2, 3, 4, 5, 6, 7, 8, 11, 12. No, not 14. He gets not 12 days. 30th if we start from tomorrow. 1, 2, 3, 4.
15 days. 14 is 15 days.
10, 11, 12, 13, 14, 15, 16 days. And already in the last month, he has taken for about 12 days. Where is the
12
difficulty?
days. I don't know why this submission.
No, but he's getting 16 days. My lords, what is
submissions.
1 or 2 days? Are we going to fight like cats and dogs,
He has
my
some
lords?
responsibility when you make
This
submissions.
is a
12
child
days.
is not child is a human being. We are not going to count 1 or 2 days to
Lord,
a calculation.
I'm sorry, my lord.
Till
My lord,
15th, let my friend take the child. Let the father have the child. 15th evening, I'm trying to request, my lords. Then 15th evening, if he drops her back, he gets her for 15, 16 days, half the month. And then 16th onwards, she can plan her Dubai trip with
They want to
holiday.
18th. I'll drop. I
No,
don't want-
why is
I
he
don't want-
denying the
My lord,
weekend?
My lord, if I can make this submission, at every step of the way, the mother has violated court orders. Contempt court has passed an order. Domestic violence court
Contempt was last year, my lords.
Domestic violence court has passed an order against her.
She is going to have an order which was never granted by the family court. So let her not bargain more.
No, I'm only saying the weekend for
she's
travel
already-
is
she's
useful.
already getting an order which was not granted
No,
by
no,
the
I
family.
agree, I agree.
What we do
are
is,
only
as-
saying let the
as
weekend.
Mr. Arvind Govindraj is suggesting, 18 days for the mother, for the father, and 18 days that is still
From tomorrow, 18th morning, I will drop her back.
18th morning.
She has 14 days. She has 2 weeks after that. 14 days is what the learned senior advocate mentioned.
He has, she has 14, he has about 18 days.
She's had
And
she had already 1 month.
And but in the 1 month, all the weekends he takes. She
even
is
if-
working. She
even
does
if
not get to
weekends
do
or
anything
even
with
if
the child.
weekends or weekend also.
At least
if you
let
deducted,
the only reason, my lords, the only reason I was asking
tell
for
her
16,
that
17.
already court is extending.
I'm in my lord's hands.
18th
18th morning.
Now tomorrow morning is who will pick up?
She has to drop and I have to drop the child
Tomorrow morning she'll be she will drop the child.
Let him pick up the child with the parents. They will keep the child with the pack
Lord, she
things
says
ready.
every time I go over there, she sends emails. You're taking my photo, you're doing. Let her drop. The order is that she should drop one way, I have to drop
Let
back
her
one
drop. Let her, and again when you have to drop,
I will
you
drop back. Yes.
18th morning he'll drop, and she'll be till this arrangement of whatever now the court is making is till 2nd June.
Yes.
After that, they will be.
Yes.
Now
Let it be till 2nd, my lords may list it. Yes.
From tomorrow, that is first to 18th morning.
30th.
Huh?
30th.
For 30th. From 30th to 18th morning. 30th morning at what time?
10 o'clock is there.
10
10
o'clock.
o'clock.
And 18th morning also let him drop by 10 o'clock.
Mother will drop, and on 18th morning 10 o'clock, father will drop, and till 2nd of June, the custody will be exclusively with the mother, no weekend custody. And she is permitted to take the child to Dubai. Then the remaining after vacation will
My
post
lords may list
and
it on
till-
4th itself.
till the matter reaches, whatever is the order of the court with regard to the weekend visitation, that will go on.
Very well.
But for consideration. Let my lords list it on 4th or 5th itself, so that other factors can thereafter be taken into account. And could my lords just for consideration, when for 2 weeks when I'm taking the child, when she's dropped back, let him undergo some counseling, and we'll make an application to that.
Whatever it is, let
We'll
it be
make an
done.
application
Now
for
we
that.
will, the scope of this petition is only to this extent. The agreed with orders passed. And
Yes. And then my lords may list it on 4th or 5th, my lords, thereafter.
why there is no other matter for
My
the
lords,
court
no, my lords.
except this matter?
No, no, no. On any date, on any date. I'm not insisting on a date, just a request. On any date, the
Orders
convenience.
passed in I number 12 in G&WC number 12 of 2024, dated 23rd April 2025. The mother is before this court questioning the order of visitation granted by the family court. The learned senior counsel appearing for the for the mother, and the learned counsel appearing the mother have advanced their arguments. And as this is concerning the vacation, at this juncture, this court is not inclined to go into any of the submissions that are made before this court. And this court is passing the order for the visitation during the visitation oblique custody during the vacation, as per the order, as per the following order. One, on 30th morning, 10 a.m., the mother shall drop the child at father's place, and the father shall drop back the child at the mother's place on 18th morning at 10 a.m. Number 2, what about mother's calls or anything or that during visitation?
Both have
During
video
custody.
calls. Both have video.
But let the video calls be little reasonable. It can't be 2 hours, 1 hour, my lords. 15-20 minutes. It can't be.
15 minutes per day for both parties.
Yes, both.
When father has custody,
both.
15 minutes. When mother has
What happens
Certainly.
is, whenever she has a custody, if you start calling her and talking to
child
us,
Yes,
talks. Child talks. The child misses the father.
during the custody, the other parent, when the child in custody of one of the parent, the other parent can have a video call, oblique the audio call for a period of 15 minutes, and it should not exceed.
But the
Next.
child wants to talk.
My lords, all this we know.
For next.
Then your lordship may make it half an hour.
No, no.
Child
What
talks,
is,
the
my
child
lords,
talks.
after 2 weeks, he's keeping the child. 18
I'm
days,
not
my
talking about-
friend
I'm not
is
talking about
keeping
during
the child.
vacation. I'm talking about regular video.
No.
No.
It's only vacation.
Correct.
Your lordship may
this is
kind
for
of specify during vacation.
Yes, it is during vacation.
During the vacation.
Absolutely.
During the vacation, when the custody is there.
Yes, obliged.
Then from 18th to 2nd, the mother will have the exclusive custody, and between 18th and 2nd, mother is at liberty to take the child anywhere, including abroad, for spending the holidays. Next, after 2nd, the earlier order with regard to the weekend visitation and the video call and whatever the arrangement that is made by the court will come into effect. Next, 4.
Till further.
With regard to the legality or otherwise of the order passed by the family court, the arguments will be heard after vacation.
Grateful. Any date, my
This
lords. make it.
matter after vacation on 25th of June.
My lords, some date earlier, mid-June at least.
Because already you have both of you have your orders. Yes.
Grateful.
Yes.
Cell number 52 for admission matters. Cell number 52, Karnataka.
My lordship, I am appearing for petitioners in this matter. my lordship.
She has
I am
completed.
seeking for adjournment, my lordship.
What is this?
These are seeking for adjournment.
No. Is it anything like any calculation is done?
1,700 some delays. There's no proper reasons they have given even for Ravi Saprati
After
also filed
vacation.
objections.
After
also.
vacation. Anything nobody is ready for settlement, will go after vacation. Yes,
Cell
53.
number 53,
Yes, Pradeep.
Pradeep B.
This is a matter, yes. We'll hear it. What is the calculation? Any amount arrived at?
I have given offer, my lord.
1 minute, let him say how much you said.
I have given offer, including interest and all 40 lakhs, my lord. I have calculated entire medical bills and whatever the handwritten bills and
No.
provisional bills and all.
Till today with interest, whatever amount that is granted comes to how much?
46 lakhs.
46 lakhs.
46 lakhs. At the rate of 6%.
No, what happens is in some of the cases where the disability is 100%
But
or whatever, that because he's confined to the wheelchair.
please, my lord, but
But we are looking at the attendant charges from the notional income And that's how we, by applying the multiplier we are granting. If in that manner it is granted, it would be much, much more.
7,58,000 has already awarded, my lord.
So just leave it, which year is the accident?
2013, my lord.
2013. What is the notional income of that?
8,000 as considered, my lord.
8,000. So 8,000 into 12 into what is the multiplier?
14, my lord.
Huh?
14.
14. How much it would be? It comes to 13,44,000.
80% considered, my lord, before MSCT. 10,75,200 has been awarded. Here, my lord, the Niman's
No,
hospital.
I'm telling this 13,44,000 is for his attendant, because somebody has to take care throughout his life.
But they
That's
themselves
how the
have,
Supreme Court
they
has,
themselves have examined PW3.
No, that is the amount for what they have spent. Now, according to you, they are not supported by any other evidence. So let us not consider it. If once we are considering his disability and the requirement of some attendant to take care of him throughout his life.
Please, my lord,
if you
difficulty is
calculate
in the
that way-
particular case, the disability, the main ground itself is in disability. Here, my lord, they have taken treatment in Visitation and Niman's hospital. They have not examined the doctor, my lord. He has taken a certificate from the disability center, my lord, district disabled welfare center.
We have seen that person.
Please, my lord,
Now
has
again,
us
no,
on
no, I'm
that person.
saying-
The accident
No,
occurred in the
again-
year of
no, no.
2013, my lord.
We send him for the assessment of the disability. What we get is the same report, I think.
The accident occurred 2013, my lord. They have filed claim petition in 2016. And my lord, several breakups are there. Elaborately, I have seen that, all the documents. Everything, my lord, they have put it in handwriting, in bills and all seals, everything.
Bills you forget.
Provisional bills.
No, bills you forget.
Please, my lord, that
No,
itself is an
start
18
to-
lakhs.
No, the bills you forget. If just let us do the calculation, come to that only on disability, and generally how we grant, we'll say how much the amount comes.
10,75,200 awarded, my lord. 80% disability certificate.
Come to that. So, injury and pain and suffering, it needs to be more.
Please, that I have recalculated, my lord.
No, I'll calculate. Then medical expenses, what do you say? That is 18 lakhs.
18 lakhs 50,000.
So what is your objection on medical expenses?
Medical expenses, my lord, I myself as well calculated for 14 lakhs, my lord. 14 lakhs 46.
It appears to be 18,50,393.
Has been granted. I have
But
calculated
according
and
to
each
you,
means
as per your calculation, it comes
14
to
lakhs.
14 lakhs. Yes, let us take 14 lakhs.
In that, my lord, in the BGS Baptist Hospital provision bills, they have not produced that original bills, my lord. Only provision bills they have produced.
Excluding, no? You are excluding that and telling
No,
it
my
14
lord.
lakhs.
Apart from that, internal page 13, my lord.
How many days he was in hospital?
They said, my lord, 244 days.
So attendant, nourishment. So 244 days means if the same calculation what we do, it comes to 2 lakhs. 2 lakhs 42,000. Then loss of future earning. This is correctly calculated.
10 lakhs 75,000.
Correctly calculated. I don't think so. We have to look
Future
at
prospectus.
now 8,000. What is his age?
42 years.
40?
2 years.
He's entitled for 10% or
25%.
25% future prospects. It is 2,000. It comes to 10,000. 10,000 into 12 into multiplier you said is?
14.
14 into 80% is a disability. 80 by 100. It's coming to 13 lakhs 44,000.
In my well, appeal will not survive for consideration. If recalculated in all the heads.
No, that's what we're recalculating. So we'll calculate. So loss of amenities, how much? In a disability of 80%,
30,000 as given.
generally, how it should be?
1,50,000.
1,50,000. Then this attendant charges?
7,88,200.
No, not from that. I'm saying we are calculating. So in these kind of disability, how we are calculating attendant charges?
Lord, the loss of future attendance charges, my lord, normally, my lord, 5 lakh or 6 lakhs like my lordship.
In those cases, Supreme Court, I have also granted in several cases where it is like 80 or 100
Paraplegia cases.
complete. No, he is restricted to the wheelchair. So it has to be 13,000, 8,000 into 12 into multiplier. That's how the same amount as it comes will come for that also.
Then my appeal may be
So
dismissed.
that if your appeal goes, that's fine.
My appeal may be dismissed. If I don't want to oppress anything.
Agreed with the award passed in MVC number 7371 of 2016, dated 1st October 2022. The insurance company is before this court. The claim petition is filed seeking compensation of an amount of rupees 50 lakhs for the injuries sustained by the claimant. The case of the claimant is that on 28/12/2013 at about 8:30 a.m., the claimant was traveling in Tata Indica car when he reached Kengeri Mysore Road, Brigade at Nice Road at the time. The driver of the lorry lorry drove the same in a high speed in a rash and negligent manner and dashed against the car, due to which his car was turtled and fell down and sustained traumatic brain injury. Immediately he was shifted to the BGS Global Hospital and then shifted to various hospitals wherein he took treatment as an inpatient. He spent 20 lakhs towards medicines, treatment, conveyance, nourishment and other incidental charges. According to him, he was doing contract works, earning an amount of 50,000 per month, and he has suffered permanent disability because of these injuries. The tribunal has held that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle and granted the compensation as per the table given below. Where is the table?
Internal page 28.
Paragraph number 13 is the table, and granted an amount of rupees 38,23,793. Learned counsel appearing for the insurance company. Where are your grounds? Learned counsel
number
appearing
1,
for the
2, 3 and
insurance company submits that the tribunal committed an error in considering the whole body disability of the respondent at 80% in the absence of cogent and convincing evidence. And in fact, the claimant has not examined the qualified medical practitioner to assess the disability and only produced a disability certificate marked as Exhibit P11. As such, who issued Exhibit P11?
welfare district disabled welfare office.
That's it's a competent board. Is it
No, my
not?
lord, it's not a medical board, my lord. Disability welfare office, my lord. If the disabled person was submitted to the photos and all, my lord, for submitting the forums,
But I'm
only
telling
there.
you one thing, Pradeep. If you're very particular on that aspect, we will send him for examination, and making that we will pass. Because again, if your insurance company wants to file an appeal on that,
No, my lord.
they will clock for another several years in the courts, and they will not get the compensation.
No, my lord, we will not going to file. I will give the opinion. My lordship may pass an.
The disability, don't write this ground. It is submitted by the Land Council that the court, without considering without there being any evidence, has granted an amount of rupees 18,50,393 as medical bills and 7,88,200 towards the food and extra nourishment and medical and attendant charges. Further, towards few, eh, and those amounts are on the higher side, and granting compensation of an amount of rupees 38,000, 23,793 is without any basis and contrary to the material on record. Then counsel appearing for the claimant submits that the claimant had sustained 80% disability from the date of accident. Is not able to speak.
Not able to speak. Not able to
He
speak.
is not able to speak and he is completely confined to the wheelchair. It is submitted that the court on all the heads has rightly granted the compensation, and he completely requires a person to take care of his day-to-day needs. And in fact, the compensation that is awarded by the tribunal is on the lower side. And there are no grounds for to interfere with the order passed by the award passed by the tribunal. Next, having heard the counsels on either side, there is a material on record. Then counsel for the insurance company submissions are that the medical expenses are given, some of the bills are on the white papers, and for the food and extra nourishment, and for the days they are in the hospital, an amount of rupees 7,88,200 is granted. This court has perused the entire record. This is a case where the claimant had sustained 80% disability. In fact, this is a case where, as he requires a constant attendant, in the light of the law laid down by the apex court in several cases, where the disability is 100%, or the case where they're confined to the wheelchair and they require somebody's assistance, taking the notional income multiplier, and by granting the multiplier, court has been granting, the apex court has granted the attendant charges. If the same attendant charges are granted, it would be much more than what has been granted by the tribunal. And he was there in the hospital for a period of 247 days. 44 days. Even on that count also, another head, he would be entitled for the amount, looking at from any angle. Even if the entire amount is reassessed, it would be much more than what has been granted by the tribunal and what has been what has been granted by the tribunal. In that view of the matter, considering the injuries and the disability, this court is not inclined to interfere with the award passed by the tribunal. Accordingly, the insurance company's appeal is dismissed and amount in deposit shall be forthwith transferred to the court.
After deposit, my lordship may direct the fixed deposit in the name of the
And
injured
as
man.
per the
Periodical interest they may withdraw, my lord. Otherwise, my lord, 10,50,000 already withdrawn.
the withdrawal of the amount, there will be a clause in that, in every order, that as directed by the withdrawal and other things will be apportionment withdrawal
No,
as
my
per
lord,
the.
this particular case is concerned, if he is a person who is a disabled person, my lord. If
The amount, the amount shall be,
Actually, the income some financial.
the amount shall be
Some
in
percentage
the
amount will be
fixed deposit, and only they're entitled for the interest for a fixed deposit for a period of 10 years, and the claimant is entitled for the interest from the same.
The percentage of amount. Some percentage.
they have already taken 10,50,000.
10 lakhs you've already taken. Who will
10,50,000.
who will take care of him for the entire for his life? Let it be. Yes.
Cell number 54, Ganesha R. You ready for respondent?
Yes.
Yes, calculated.
4,85,282. We'll pass an order. He was not there on the last occasion.
No, yes, he was there, my lord. I took an adjournment. I have to file the wakala.
They
Reliance
were,
company.
So joint memo can be filed,
No,
they
no.
were, okay. From
From
Agreed
Lok
by the-
Adalat, madam, the Reliance.
Agreed by the order passed in MAC number 387 of 2020, dated 30th January 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal had granted compensation as per the table given below at para number 27 and held that no, there is no, only one insurance company is there.
Only one insurance that has been tied up with the Hinduja. I want 15 days time to file out. That's what.
And granted an amount of rupees so and so. Land counsel appearing for the appellant submits that the tribunal had not granted the compensation. And it is submitted that the compensation that is awarded by the tribunal is not just and reasonable. Land counsel appearing for the respondent submits that there are no reasons to interfere with the award. Next, how many are the injuries? Pradeep, look at it and injuries. You have the file?
No.
I'll look into.
Send it to company for interest payment.
From fracture of lower tibia, segmental fracture of tibia, considering the two grievous injuries, this court is granting an amount of rupees 60,000 towards medical expenses. Court had granted 1,682, and this court is not interfering with the same. For the future medical expenses, court had granted 40,000 and no interference is called for. Towards conveyance also, court had granted a reasonable amount, no interference is called for. When it comes to the loss of future income, the court had taken the income the notional income of 11,000, considering the fact that this accident had taken place in the year 2004, 2019. This court is taking the income at 14,000. The court had rightly taken the disability at 10%. 14,000 into 12 into 17 into 10 by 100 is 2,85,600. Towards the loss of amenities, considering the disability of 10%, this court is granting 30,000. Coming to the loss of income during the later period for 3 months, 14,000 into 3, 42,000. And in the light of the law laid down in so and so, towards legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 4,98,282. Accordingly, the appeal is partly allowed, enhancing from 3,30,000 to 4,95,282. Yes, next.
Cell number 55 disposed. Cell number 56. Syed Abdul Sabur.
Yes.
This is Penegora.
Facial injuries. We have settled the matter, satisfied the award.
You are settled? How much?
No. We have satisfied the award.
You are satisfied. Yes, let's do the
Date of
calculation.
accident 1421. Multiple facial injury. For the multiple facial injury, doctor
Where is he?
assessed he has not appeared morning also.
There are other matters also of this certificate.
This is the only. So, the 33% the facial disability was assessed by the doctor.
We'll have it on Friday.
Please.
Otherwise,
Please.
no representation for the appellant. This matter as part heard on Friday. Next 58.
Cell number 57 disposed. 58. And Lok Adalat.
My lord, I am for the appellant, my lord.
58.
Well, this appeal is by the BMTC challenging the negligence and quantum of compensation. Well, the deceased tried to get into the moving bus and fell down. She is a student. My lord, Tribunal has awarded my lord 39,61,000. I am ready to deposit 50% of the award.
No, you're on what ground?
My lord, the deceased tried to get into the moving bus. When the doors are closed, she was not able to get in and she fell down. Because of her negligence, the accident has taken.
So, it's a contributory negligence.
Yes, my lord.
So contributory negligence, the court had granted 37 lakhs 80,000.
39 lakh 61,000.
39 lakhs
61,000.
61,000. How much you have deposited?
Madam, I am ready to deposit 50% of the award amount.
Why 50%?
Tribunal has
Even if
taken
the
the
court,
income.
court comes to the conclusion, contributory negligence will not be 50%.
Malad, the income is taken at 25,000 rupees per month. That is also on higher side.
How much
Quite
is
reasonable amount. Malad, even if it is
Let us see the award. Where is that amount?
Malad, para 27, Malad. Sorry, para 20. Yes. Para 27, Malad.
That is not.
Internal
Where
page
is the
21.
compensation? Where is the income?
25,000 is taken, Malad.
The appellant, there shall be stay of all further proceedings. The appellant is before this court questioning the contributory negligence as well as the quantum. There shall be stay of all further proceedings on the condition that the appellant shall deposit an amount of rupees 20 lakhs 20 lakhs within 6 weeks, and
Yes,
on such deposit, the claimants are at liberty to 1 minute. As per the
Withdraw.
what is this? And
Parents.
next, the tribunal, as apportioned by the tribunal and as ordered, as apportioned and as ordered, and as per the as ordered that the 25% of the amount shall be kept in fixed deposit within the same lines. The awarded amount can be withdrawn.
Cell number 59.
Malad, this appeal is by the BMTC, Malad, challenging again negligence and quantum of compensation. Malad, two minors are riding the motorcycle. They came from behind while overtaking the
It's a case
BMTC.
of death. This is also case of death.
Yes.
How much is the amount?
Malad, 25 lakh 29,000. Death of a minor, 17-year-old boy. He was riding the motorcycle.
50 lakhs. Like in the earlier order, 50 lakhs to be deposited, even as per the order, as per the apportionment. Yes.
Cell number 60.
Yes.
Malad's appeal of the insurance company, Malad's challenging quantum. Malad's age of the deceased is assumed at 60 without there being any evidence on record.
60.
60. The post-mortem report says that he was 65 years of age. The claimants on purpose withhold his government identity cards. However, they filed their identity cards.
So now the dispute is with regard to that.
Age.
So if it is taken as 60, how much would be the compensation?
That's 12,77,000 is what is awarded.
Yes. No, what is his age? Oh, no, I mean,
It is assumed at
income,
60.
Income. Which year is the accident?
2022.
2000?
22.
Income is taken
15,500
as per the table?
as per the table.
2021.
That is not in dispute.
15,000. So 15,000, no future prospects.
Future prospects is added.
65 is entitled for future prospects.
No, at 60 he is entitled, at 65 he is not.
So let's forget about future prospects. 15,000 into 12 into multiplier is 5.
5.
5. It comes to 9 lakhs. How many are the claimants?
Because wife and daughter.
Wife and daughter.
2 daughters.
So
Both of them are major.
3 into 44. 1,32,000. And 36,000 towards funeral expenses.
Manoj,
Court has not granted. Ultimately, when your appeal is heard, if the other things we are interfering with, that's what it is. I'm calculating all this for you to deposit the amount, nothing else. I'm not
Yes.
passing any order. It comes to 10 lakhs 68,000.
That's a
What is
deposit,
awarded?
8 lakhs, and 8 lakhs may be released in their favor also.
Why 8 lakhs? You deposit 10 lakh 60, 10 lakh 50,000 you deposit. You have to deposit that. As per your own calculation, without any future prospects, as you say. So why to keep that money? It is land council appearing for the appellant insurance company submits that though the age of the deceased is 65, it is taken as 60 without any evidence, and the court had granted the future prospects and granted the compensation at 12,77,600, which is on the higher side. This court has perused the order. Considering the submissions, the insurance company shall deposit an amount of rupees 10,50,000 within 6 weeks, and as ordered by the court with regard to the fixed deposit and other things in the same manner, the amount can be withdrawn.
Claim number 61.
That's appeal of the insurance company, challenging liability on the ground that the offending vehicle did not have permit at all.
Did not have the
Permit. And the claimant is his younger brother. He was a bachelor, age 62. His younger brother is 60. He's not an economic dependent, there's an award.
No, it's a case of death.
Case of death,
60 years, no, 94 years person is,
the father, he's no more.
but he's entitled.
No, he's no more. Father is also no more.
As on that day.
As on the date of accident, he was alive.
He was alive. That's what we count. That's what we calculate while calculating the. So, what is and again for that also your pay and recover will apply.
Pay and recovery will apply.
So 9,45,000 is the amount granted. The insurance company, it is submitted that they're questioning the liability as the vehicle was not having a valid permit, and also it is submitted that the brother who is age 60 years is shown as a dependent and court had deducted 1/3.
1/3.
Deducted 1/3. 1/3. It is submitted that the 1/3, considering the submissions of the legal counsel for the insurance company, this court deems it appropriate to direct there shall be a stay of all further proceedings on the condition that they shall deposit an amount of rupees. They shall deposit an amount of rupees 7 lakhs within a period of 8 weeks, and the claimants are entitled to withdraw, but as per the conditions laid down by the tribunal.
Number 62.
In all these cases, stay notice.
62, my lord, in this case challenging the liability, my lord. The unauthorized passenger was traveling in a crane, my lord. There is no seating capacity to a crane, only except driver, my lord, no person should carry.
Crane.
Crane.
It is submitted that the insurance company is questioning the liability as it's a case of the death. The deceased was traveling. It was traveling in a crane. Considering the submission, there shall be stay of all further proceedings on condition of 50% of the deposit within 8 weeks.
Fixed deposit.
And fixed deposit. In all the cases where there is no withdrawal, remaining amount on fixed deposit. Yes. 63.
My lord, the accident between auto rickshaw and the motorcycle, appeal by the insurance company challenging the liability and also quantum of compensation. My lord, the
Liability
auto,
on what ground? Liability on
auto-
what ground?
Liability, my lord, the said auto is not having the permit to play at the place of accident.
So
In the charge
quantum
sheet,
is-
my lord, quantum, my lord, tribunal has awarded, it's a case of injury. 7,61,588 is awarded. He is a security guard in a company. My lord, he himself has produced the salary certificate and he has received the salary after 6 months. And he is continuing his service and getting regular income. There is no loss of income.
The
It's
council
only
apparently
metatarsal bone.
company submits that.
7,10,000 is awarded.
As also on the liability. Liability is that the vehicle is not having a valid permit. Coming to the quantum, it is submitted that even after the accident is continuing with the job, considering the submissions, there shall be stay of all further proceedings. In this, 5 lakhs to be deposited. In the
My lord, award itself 7 lakh, my lord. 7,10,000 is awarded towards future loss of income. Make it 50% at least.
Claimants are permitted to withdraw.
My lord,
As
50%, my lord.
As ordered by the tribunal.
Serial number 64.
My lord, this
Yes,
appeal is connected with serial number 19, my lord, where your lordship has granted stay today.
Same, whatever is granted in that serial number?
19, my lord.
19. Yes, next.
Serial number 65.
This case, my lord, challenging negligence as well as quantum. Negligence is concerned, my lord.
Just no, 64 is over. 64 is over. That is connected with 19. Yes.
65.
The injured himself is my lord, radar of the motorcycle was dashed against an ongoing vehicle, my lord. It's a goods auto rickshaw. He himself is negligent in causing the accident, my lord.
You are saying contributory negligence.
7,75,600 has been awarded.
In the 5 lakhs, same, there on the negligence, contributory negligence on the part of the claimant. They shall deposit an amount of rupees 5 lakhs, same as the withdrawal as per like in the earlier orders. Yes, next.
Serial number 66. Mohan Kumar.
This matter has been settlement has been reported on Saturday for 1 lakh rupees. The file was not because some other bench.
It was there.
1 lakh rupees.
1 lakh rupees. You will file a joint memo today.
I think
It's already recorded before the other
it's
court.
recorded before the other court. The file was before this honorable court on the day, but it was reported before the some other bench. In fact, Ravishan Prati told me that your case is bring Mohan Kumar, but his the appellant advocate reported the matter before the other bench. For 1 lakh rupees it is settled.
So what is some joint memo somewhere to be filed?
No, joint memo was not signed. It was reported. The file was not.
Where is this? Where is the advocate? Today there is.
Raghu was here. He told he's agreeable. Another matter was also settled on that.
No. Ask him to come in the evening. Today we can file a joint memo before
just call him.
Lok Adalat. It is submitted that the insurance company is ready to pay 1 lakh.
1 lakh rupees is settled.
1 lakh lump sum. In addition.
1 lakh.
1 lakh global compensation, and they'll file a joint memo before the Lok Adalat. Keep this.
Serial number.
Yes.
Lordship, negligence and quantum, Lordship, I am ready to deposit 50%. That 30% liability fixing offending vehicle and my vehicle was liability fix 70%, my Lordship.
You are representing which case?
306.
Janardhan Reddy. 67.
67, my Lordship.
67.
Yes. My insured vehicle is.
This is reported matter. Yes. This is the case of?
Negligence, my Lordship. My insured vehicle, ongoing vehicle, the offending vehicle came from my backside and dashed into my tempo, my Lordship. The tribunal, without considering the negligence aspect, 30% fixed against the car and 70% liability fixed against our company, my Lordship.
Compensation.
7,43,000, my Lordship. The total 4 cases are there, my Lordship.
32,49,000.
No, my Lordship. This is arising out of MBC number 4271, my Lordship.
Two lakh 59,800. 50% of the amount to be deposited within 6 weeks, and the claimant is at liberty to withdraw.
Before MAC, my Lordship.
Serial number 8.
My lord, this appeal is by the insurance company, my lord, challenging the involvement of the vehicle and also the liability and quantum of compensation. The accident between the scooter and the swift car.
So all the grounds available are there.
Yes, my lord. Here, my lord, complaint was given after 2 days of the very same village. It is a collusion, direct collusion. I am ready to deposit 50% of the award amount.
Yes, 50% of the amount, no,
Much
no withdrawal permission.
Much obliged.
Serial number
50% of the amount to be kept in fixed deposit, no withdrawal permission.
Serial number
Yes.
69. Serial number 69.
No representation after vacation. Yes, next.
Serial number 70.
It's for the appellant in this case. It's insurer appeal on the ground of quantum.
How much is granted?
That's 43 lakhs 50,000 is granted.
43 lakhs?
50,000.
Case of death?
Yes, ma'am.
Huh. According to you, how much it should be?
It should be 33 lakhs,
33?
33 lakhs 82,000 approximately.
Should be 33 lakhs 82,000. So you deposit 33 lakhs 50,000. It is the insurance company is before this court questioning the quantum, and it is submitted that the what is that taken more, the income?
The income is taken more, as well as the future prospects is added at 50%.
Income is taken more instead of 40%, 50% future prospects are awarded. Considering the same, there should be stay of all further proceedings on the condition that insurance company deposit an amount of rupees 33 lakh 50,000, and the amount the as per the order passed by the tribunal, it shall be apportioned and withdrawn.
Serial number 71.
Yes, 71. After vacation, next 72.
72.
After vacation, 73.
73. Anup Sitaram Rao.
Appeal of the insurance company, challenging negligence finding as well as quantum. Negligence, this is a unique case. 3 vehicles are involved. Trial court comes to the conclusion it is because of all 3 vehicles the accident occurs, but holds me alone liable to pay the compensation, but then gives me liberty to recover it from the other 2 insurance companies when they are already on record. That is one aspect. Second aspect,
Grant. How much is the amount?
Award is 9 lakh 85,000, 9 lakh 15,000.
50% of the amount?
Please, Manoj.
50% of the amount to be deposited within 6 weeks, and 25% of the amount to be withdrawn.
Another ground which would disentitle them from taking the money. Out of the 9 lakh 15,000, 5 lakh 90,000 is medical bills. He was working as a head constable. The amount would have been paid by the.
To deposit in the 50% of the amount, and the same shall be kept in fixed deposit. Yes, notice.
Serial number 70.
Yes, 70.
T. Vijay Kumar.
My lord, this appeal is by the insurance company, my lord, challenging the liability, and my lord, particularly, my lord, the claim petition itself is not maintainable because it is filed beyond 6 months. Kindly see, my lord, the date of accident is 21/2/2023.
What is liability? Liability on what you're saying? You are on liability.
Liability, my lord, it's a case of self-fall, my lord. The vehicle has been
50% fixed deposit, no permission to withdraw. The insurance company on the ground of liability. Next, 75.
75.
Much.
Prasanna Kumar.
But the wife's petition under section 125, Lord, wife and daughter's petition, 35,000 rupees maintenance has been awarded by the lower court, my lord.
How much to the wife? How much to the daughter?
To the daughter, 10,000 rupees. I don't have any dispute insofar as that is concerned, Lord.
25 to the wife.
25 to the wife. She is also an engineering graduate and she is also working, Lord. Under those circumstances.
Finding of the court.
Finding, Lord, the husband is earning 1 lakh and odd of rupees per month. On that ground, my lord.
No, finding with regard to her income.
Her income, there is no proof produced by the husband, is the finding, Lord.
So, how much you will pay? There is any stay in this?
No, my lord. I am asking for stay now, my lord.
On condition of what condition?
As far as the daughter, my lord, I don't have any.
Daughter you have
yes,
to pay.
Please.
I am asking in 25,000.
10,000 rupees to the wife also, my lord.
The tribunal has granted an amount, the family court has granted an amount of rupees 10,000 to the daughter and 25,000 to the wife. And counsel submits that as far as 10,000 to the wife, daughter is concerned, he has no objection to pay. And as far as 25,000 that is award that is granted to the wife concerned, he submits that she is also an engineering graduate and she has a means to maintain herself. Considering the submissions, they shall be stay of all further proceedings on the condition that he shall deposit, he shall continue to pay 10,000 to the wife. And as far as the wife is concerned, he shall pay 10,000 by 5th of every succeeding month, and the arrears also at 10,000 shall be paid within a period of 6 weeks. Either of it, the stay granted by this court stands vacated. Next.
Oblige.
Vishwanath K.
Petitioner. This is the petition, husband petition. The trial court has awarded 3,000 per month, my lord. She is not the legal wedded wife of the petitioner, my lord. She is married one Sonnappa. She is residing in the Dalsnur in Srinivaspur Taluk. Whereas
All that we will decide in the RPFC. 3,000 is not an issue. Pay. Notice.
She is subject to deposit
What
of,
subject?
from the date of petition, my lord. He is aged about 75 years, my lord.
He's 75 years now.
75 years.
So how much you will deposit?
50%.
It is submitted that 50% of arrears and 3,000 continue to. 50% of the arrears will be deposited. There shall be stay of all further proceedings on the condition that you shall deposit 50% of the arrears and continue to pay 3,000 by 5th of every succeeding month. Notice to the respondent. Yes, 77?
77.
Husband petition, my lord. Wife and 2 children, my lord. 2 daughters.
How much is
5,000 each to the daughter, 15,000 to the wife. In fact,
It is 1525.
please, my lord, from the date of petition, 22 petition, 2022 petition. In fact, I have paid 19 lakhs. As per the trial court order, I would
What
pay.
is your income?
No, I was running a factory. Now it is closed, and I am staying with my father and mother.
You have closed it when
Because of the harassment,
No,
there are more than 10 petitions.
While the matter is pending before the court or after you have filed the matter here, when is it closed?
No, earlier in the 2007-8 itself, she has left and she
There
came
must
back.
have been some material for the court to
Please,
pass an order.
Please, my lord.
That's why I'm asking. When
No.
did you close the business?
Actually, I have paid more than 19 lakhs, madam. I made a statement. She has also admitted in para 13, my lord. Everything she has admitted.
No, all that we will see once the notice is received. There will be a stay only on condition. What is that you're going to deposit? Or else we'll issue notice.
No.
Once they come, we can hear.
From today, I will pay 5,000 each. Continued.
1,000 you will pay.
Continually pay because I have paid more amount I have paid already paid.
So according, you will continue to pay you are only seeking stay on arrears.
Please, yes, please.
The land council submits that is ready to pay 15,000. It is not 15,000, it is 25,000.
25,000 for wife. I will pay deposit 5,000.
The court had granted 5,000 each to the children and 25,000 to the wife.
15,000.
15,000 to the wife, and he has already spent huge amounts, running
Please.
into 19 crores and 19 lakhs and not. He submits that he has winded off the business and not in a position to pay the arrears. Considering the same, they shall be stay of all further proceedings on the condition that he shall continue to pay an amount of rupees 5,000 each to the child, 5,000 each to all the petitioners.
Please.
Petitioner by 5th of every succeeding month. And as far as the arrears, no, the arrears I'm not mentioning, so there are
Please.
nothing to say. So the notice, yes, if he fail, default order also, if he fails to pay.
From this month, I will continue.
Huh?
From this month, I will continue to pay.
That's what I said.
Please.
Cell number 78, GJ Simpapur.
Petitioner, my lord. Petitioner with the husband, my lord, challenging the order.
The urgency to hear now. Finally, it has to be heard
Please, my
after
lord.
vacation.
Interim order can be extended, my lord.
Interim order earlier granted is extended. No representation for the respondents. Yes.
Cell number 79.
Lord, in this case, maybe have it on
Appear
Friday
for the
night.
appellant, my lord.
We have taken paperwork, it is published. I need to produce, my lord, they have sent through.
After vacation.
No, my lord, Friday only.
Friday.
I placed that paper.
Friday. Yes, 18.
Cell number 80.
My lord,
May I please, my lord? My lord, questioning the liability, my lord. My lord, there are two appeals are listed. Appeal number 7602 of 2023. The third party to the appellant has filed a appeal. As far as another appeal, 483 of
This is
24.
matter on Friday. The counsel appearing online is not audible. Yes, next.
Permitted to withdraw the amounts.
I have to hear him for that. You can see what is happening
Date may be given, Your Lordship.
after vacation.
After vacation, after vacation,
After vacation on 18th of June.
much of
As per
Yes.
18th of June.
Yes.
The list number 2 for arbitration matter, serial number 1.
Yes.
Malada, exhibit, I have review petition exhibit P2 Malad is the charge sheet. Pain recovery agbeko. In addition to that, Malad did some quantum also.
Yes.
P2 may kindly be seen, Malad. Exhibit P2 with the review petition is the charge sheet.
Exhibit P2 is a copy of the complaint. We are concerned with the.
Malad, I'm referring to the review petition. Review petition.
Show it to him. Give the review petition to him. LCR as received.
May I pass on, Malad? I have a copy with me.
Please read the order in the review petition.
Malad, what they say is, Malad, I have not established that the owner has allowed the driver to, with the knowledge of not knowing the DL, that is.
They said in the charge sheet, it is not under the rule 3 of the MV rules. It is not, the crime is not registered.
Malad, I have got a copy of the charge sheet. I shall forward it. This is the copy of charge sheet. See the exhibit P3.
Was it filed before the court?
Yes, Malad, it's exhibit P.
Why I want to look at that review, give him the PCR.
P3, Malad, it is exhibit P3 marked. I'm sorry, Malad, I am not keeping well and I.
Yes, take this. When is the accident? Which year is the accident?
Malad, it is 2014, Malad. 27.
What is the age of the deceased?
73 years.
70?
3 years.
Mm.
But the claimant is only the wife. 50% had to have been deducted. And Malad, no future prospects could have been awarded. 30% is awarded.
Where do you get the age?
Malad, in the claim petition itself and the tribunal, Malad, page. Malad,
No, in the consideration of the court.
Yes, Malad, I'll page. Malad,
It
page.
says 72 years.
Yes. Future prospects could not have been awarded. Malad. The tribunal, Malad, considering the age factor, the income is assessed is. I'll leave it to Malad. 73 years, man. 50% may have to be, only wife is the claimant.
Still, it will be more than what is granted.
Well,
Still, it will be more than what is granted. It will be another 10,000 more than what is granted by the tribunal. Heard the learned counsel?
interest,
Learned counsel, how
interest
much it is granted?
8%.
Heard the learned counsel for the appellant, no
Pay and recover.
representation for the claimant. Lisa's matter as partnered on that day I'll pass orders in her presence. Lisa's matter on Friday.
Melada, I may not be able to.
You may not be present.
I'll
not
be great.
necessary.
I'll be great. And
Yes, next. What is this for being spoken to?
Melada, may I know what is the income assessed? What is the income taken?
Income as it is, as per the chart.
73
4,000.
years. 73 years, Melada.
Future prospects are not taken.
Oh, I'll leave it. That is why I said I'll leave.
I am not taken. Yes,
Please.
next. Two. What is this for being spoken?
This case, claimant has prepared the appeal, 7195 of 17. In which Malad insurance company has admitted the liability, though claim petition on dismissed secretary insurance company. We have admitted the liability and satisfied the award. Therefore, the appeal by the owner of the vehicle, it may be allowed and refunded the amount what he has deposited.
No, why has it come as for being spoken to?
Last time I am
The order passed by this court.
already put up case.
Huh?
Before the tribunal, claim petition was dismissed against the insurance company.
That I understand.
No,
It
this
is
the
listed
new
under
case.
the
It
caption.
was not posted on that day, Malad. New case. There is no calculation for this.
1 minute. Why it is for being spoken? What is this? Above matter was allowed on 17/4/2020.
1770 that insurance company advocate had informed to me the liability picks on the pay and recovery order has been put. That's why.
No, in this matter, where is the order passed on 17/4/2025? And you want it for being spoken to?
Yes.
To clarify that, huh? They can find out all are corrected. 1 minute, 1 minute.
Claim petition, earlier claim petition was dismissed. He has prepared the appeal before this court.
All that I don't want. What I want to know is whether a final order is passed in this case.
Dismissed for default. That was he has filed the application, restored the.
No, he has not filed for a restoration.
No, the case is posted on 17/4/25, my lordship. On that time, I am in out of station, and the other side council has informed me the pay and recovery.
Look at it. Look at it. No, to file file this application, there should be some order, is it not? You should see that order.
No, my lordship. Other side advocate has informed to me.
Will it be a basis? You have to see the order.
I have not seen that.
Let them pass over, get that order. Yes, next.
Number 3. 20,000. 20,000.
Simple injuries, my lord. 7,000 is ordered.
3.
Awarded.
3. Yes. Give that. How much?
20,000.
Globally.
Yes, global.
I'm asking 25,000, madam. Madam is telling.
Why you are not, when he's asking only 5,000 more, why are you not giving?
5,000.
It is submitted that the instance, the RTC is ready to pay an amount of rupees 20,000 globally for filing a joint memo. This is matter today before the Lok Adalat. Yes, 4.
Number 4.
What about this?
Claimant's file is liability. Claimant set on liability, my lord.
Dismissed.
Yes, my lord.
After vacation, list,
Call for TCR.
delete from part third, call for the DCR. Yes, next 5.
Serial number 5.
Sir, file my objections to the application filed by my learned.
Delay. After vacation, no urgency for this. Delete from part third. Yes, next 6.
Serial number 6.
Negligence is question.
Negligence is in question. It can be admit post for final hearing, call for the DCR. Next 7.
Serial number 7.
Respond number 1. Plus it was easier.
Go for the
Respond. Victim.
Who appears?
Injured. Yesterday there was a confusion with regard to calculation under ECA. This code calculated and the amount was coming more than what the
Who
award
was the counsel appearing?
I appear for the appellant, my lords. My lords, what I argued, my lords, regarding the calculation.
That's what calculation.
My lords, 60% as per section 4B, 60%, then 70% is the disability, my lords. 70% of 60% and then the factor, my lords.
Please calculate and tell the court.
My lords, that would come to 7,39,032 rupees, my lords.
7,39,032. No, let's calculate how it has to be calculated. What
my
is
lords, 8,000, my lords.
8,000.
60% of 8,000 is 4,800, my lords. 70% of 4,800 into factor, my lords, that is 219.95. If it is 100% disability, my lords, percent of wages, then relevant factor, my lords. Because it is 70%, my lords.
If it is disability, you have to deduct the amount from the disability. What is that calculation?
60% of the amount, my lords,
Where is Mr. Pradeep? Yes, what is this calculation? 8,000 is as per the notification, the wages are 8,000. 70% is the disability. So what is the calculation now?
50% of the income must.
So that is 4,800 is the income. Then
Into factor.
into factor. Then what about the disability?
70% that has to be. 70 by 100. 70% disability means 70.
70 is the disability.
Please. That has to be divided by the 100.
No, 8,000 as per the notification. 60% will come to 4,800.
Into 219.95 into 70%. 9.75.
2195.
219.95 is the relevant factor, my lords. Into
95 or 75?
95.
219.95.
7,38,360.
7 lakh?
38,360.
So what you did now in 8,000, 60% is 4,800.
Please.
Into
relevant factor.
Factor into factor.
Into 70 divided by 100.
We'll do that.
7,38,360.
Coming to 7,39,032.
Please, Mr. For which, my lords, the medical expenses is, my lords, 4,80,000, my lords.
There is a total amputation of the hand below 28.2 centimeter. Complainant injuries. No, just said.
But the disability
But the
is-
factor will become 80%.
Look at it. If it becomes
Scheduling.
80%, we'll take it.
I don't dispute.
Look at it, we'll take it.
Amputation below me or
It will be above 20 centimeter. 80%. Schedule injury 80%.
It's 80%.
The arm is just 10 centimeters.
Then we will calculate like that. So 4,800 into 12 into
Not 12,
12.
Mela.
No, 4,800 into 219.95 into 80 divided by 100. It comes to 8,44,608.
One second. One more correction. It is not 219, it's 221 because it was 22 years age.
20?
As per the schedule. As per the schedule, at schedule 4, age
It
factor.
is age 23 years, my lord, wound certificate.
22.
P7, my lord.
Where from you get
Their own document.
I get it from age at para number 37, my lord.
Para number?
22 years. Judgment page number 20.
In this case, PW1 has produced exhibit P12. Exhibit P12 clearly reveals that the age of PW1 is 22 years.
Driving license.
No, it is then 22 years only.
22 years.
Then what is the
Then
factor?
multiply, the factor will be changed.
What is the factor? Look at it.
Factor at 20 is 221.
221.37.
221.37. Now we will calculate. 4,800 into 221.37 into 80 divided by 100.
8,50,660.
It's coming to 8,50,000. 060. Yes.
221.5.
So even that calculation also it has to be reduced.
There is a medical bill.
Medical bills.
How much?
4,80,000.
What are the medical bills?
4,80,000.
8,50,06.
4,80,000 that has to be added.
80,000.
1330.
So,
Plus.
ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
It's coming to 13,30,000.
Therefore,
3,000
more.
Huh?
3,000 more, madam.
Appeal has to be.
Yes, please come. Agreed with orders passed in ECA number 3 of 2016 dated 9 July 2020. The insurance company is before this court. Land counsel appearing for the insurance company submits that the court had taken the income at
12,000.
Income at 12,000 and as per the notification, the income is 8,000. As such,
Our defense was that it has calculated the compensation and as if it is a motor vehicle.
And the compensation was awarded as if it is a calculation as per the Motor Vehicles Act. This court has perused the order passed by the tribunal. Tribunal has granted 13,27,200 and has rightly submitted with the land counsel appearing for the insurance company. The calculation is made as if it is a compensation under the Motor Vehicles Act, but not under the Workmen Compensation Act. Hence, this court is calculating the same as per the Workmen Compensation Act. This accident had taken place in the year 2013. 13 and as per the notification, the minimum wages have to be taken at 8,000 and 60% comes to 4,800 and as he is aged about 22 years, the relevant factor would be 221.37. Hence 4,800 into 221.37 into 70 by 100 is 7,38,360 and medical expenses comes to 4,08,000 and the total amount comes to 13,30,060. So what is to be done now?
At the rate of 80%, it becomes 8 lakhs and after adding 4 lakhs, it becomes 13,80,000. So that was the calculation we arrived at last. Before that, the calculating factor, disability factor was taken at 70,000 and I showed the act which said it was 80%. So by calculating with 80%, it comes to 13,80,000. Otherwise, it's
13,30,000.
13,30,000.
And as per the table, the disability is 80%. Hence, it comes to 30,30,060. The tribunal has awarded 13,27,200 and there are no, hence the court finds no reason to, hence the compensation is awarded at 30 lakh, 20, 30, what is it?
27,200.
30,000. Hence, the
27,000.
compensation that is awarded by the tribunal at is confirmed.
Amount in deposit made.
Amount in deposit shall be forthwith transferred. Yes, next part.
Obligation.
Cell number 8.
Yes. What about this?
Clarification.
Well, yesterday it was heard, my lord. It was pointed out that as per Exhibit P13, my lord, the salary that they have claimed is 9,000, my lord, inclusive of overtime wages. Since he had not come, my lord, yesterday the case was posted.
For 380 work club along with that.
We'll have it after vacation. Yes, after vacation.
Club the MFA number 380 bar 2000.
Post along with so and so.
80 bar.
Yes, 9.
Well, 9 is 20,000, my lord, lump sum.
It is agreed that it is submitted that RTC is ready to pay an amount of rupees 20,000 global compensation.
Yes, lump sum. my lord.
Lump sum in addition to what has been awarded, and for a joint memo today in the Lok Adalat. Next 10.
Cell number 10.
Note I appear in this matter for the respondent mother. My lords, this was when NIMHANS referral was made. Now, my lords, the NIMHANS report still is stating that for the.
Yes, what about the visitation?
Now, my lords, visitation, I'm sorry, I would like to just state on record, twice a week, they are taking, the mother is taking the child. Now, more than this, my lords, further beyond this also to take.
So then twice a week if she's staying, and that twice a week after the session, he will spend some time with her.
Yes, he can go. He's not coming also. He can definitely spend time in the
Yes.
in the hands.
Now the child has the court, school vacations. May I request?
Please don't tell the court about like how it is in every case.
But
You
may I
know
request
the
for-
facts of the present case.
I understand the concern
So
of the court.
don't, let's not go into any of it.
Can
May I
spend
request
time
my
in
lord,
Stay.
NIMHANS.
After that, whatever time you want, you spend there in the hospital.
But that is not happening. Lord. That was the
He
reason why I
himself is
moved the
not
matter.
coming.
Lord,
Last
now-
2 sessions, he has not come. Father is
I
not
said
come.
after the sessions, I'll pass a specific order now.
Yes.
Lord, I may not get substantial
Uh,
time.
Then,
Lord.
then let it continue
Lord,
as
I
it
leave
is.
it to the, I leave it to the wisdom of the
It is
court.
submitted that. What is the wisdom of the court?
Lord, your lordships may have.
No, I didn't
fixed
understand
visitation.
that. What is the wisdom of the court?
Lord, my request was to have.
No, you
visitation.
can throw some light on that.
I leave it to the court. That is what I meant. Well, Lord, my request was to have visitation at my house. Well, Lord, for 3 days a
This
week.
matter
because-
after vacation.
Well, Lord, your lordships may pass orders. My lord, subsequent to the evaluation at the Nimans, the visitation.
If your client is not understanding, Mr. Counsel, I
But
can't
I
help
understand,
it.
Lord,
Neither
please.
the counsel nor the client are
Lordships may have,
understanding.
your lordships may fix visitation subsequent to the evaluation at Nimans.
As per the report placed before the court by the NIMHANS, the girl requires some more sessions. It is a grievance of the father that it is a grievance of the father that is not able to spend time with the girl. As already whenever the girl, as per the NIMHANS, comes for the counseling oblique evaluation, at that time, the father can, after the evaluation, he can spend time with the girl for a period of 2 hours.
Not 2 hours, my lords, about an hour. 2 hours will be too much because already the session goes on for.
Yes, next part.
Can it be an hour, my lords?
11.
But
Yes,
would I be permitted to take the child out?
yes,
Number 11. Arun Govind Raj.
yes.
Lord, settlement, Lord, I don't think, Lord,
It's possible.
because, Lord, they're not offering anything, they want me to give money.
Have after vacation.
Lord, I have one request, Lord. Lord, on the 3rd of this month, Lord, the DV court is considering, Lord, her maintenance application, Lord. Lord, your lordship may direct the court, Lord, to consider the application for maintenance. I don't want to trouble this court, Lord. Let them consider, Lord. Because what happens is, Lord, they'll say that the matter is pending here, and then they will, Lord. All right. I'm only saying, Lord, your lordship may direct that the Lord within whatever time, Lord, with a month or so, let the DV court consider the maintenance.
25, 1,50,000 has been awarded. after that, my lord has directed me to pay 1,75,000 rupees a month apart from children's educational expenses, which I'm continuing to pay. And the DV court has directed the respondent to place on record her bank statement, which she has still not complied with. There's
It's all there on record. It's all on record. It's all on record.
Two applications are pending for documents.
Correct. That's what I'm saying.
Now, for the vacation, I don't want to trouble your lordship. For the vacation, some arrangement needs to be made.
No.
15 days.
Lord, he has not taken the children to Lord the counseling. He has not even taken appointment.
I'm sorry.
And my lord, he has left them overnight, my lord.
Lord,
we have enough proof of that.
An email was sent to the mother saying that he has to travel outside and therefore kindly, I'm really drop the child at your place. She says, you're letting me know 2 days in advance. I'm outside somewhere, some death has happened. Therefore, you cannot travel and you cannot leave the children with me. But we will not trouble your lordship for the vacation. I'm seeking some arrangement to be made. I want to take the children to Singapore. Passports are in the mother's custody.
Lord, Lord, she has a problem with the passports. Lord, we have already made our arguments on this. Lord, I am only saying, Lord, your lordship may call this after vacation. Meanwhile, my lord, DV court may consider her maintenance.
If the children spend some good time in Singapore, what is the mother's difficulty?
No, my lord, the main reason is they want the passport.
I will take them on a holiday.
Given back.
No, my lord, what the idea is.
No, once they come back, they have to give it back. Yes. Is it your apprehension that they won't come back?
They may not. They may not. They may not.
I'll file an affidavit on Friday.
They may not. That is the problem. I'm sorry.
He's working here.
He's working here, my lord, but his work is in US also. It's a US based company. He can shift to US with the children. I can be left high and dry, my lord.
No, if not in Singapore, somewhere in India they can take the
India, my lord, I have no problem. I will also, my lord, I will advise my client.
Singapore has so many places of interest for the children, my lord.
It's very hot in Singapore in summer.
No, Singapore doesn't have any summer, my lord. Summer throughout the year. Where all 12 months it's the same weather. It doesn't change.
No, my lord, this interest, my lord, does not seem to be genuine because when the children are with him, he leaves them overnight and goes away, my lord, to Bombay for 3 nights.
I'm sorry, my lord. I don't understand why allegations are being made.
He has not taken them for, my lord, the counseling.
What is this submission with regard to counseling?
Not counseling. The counselor has given a report saying that the child needs to be taken once a month. The mother wants a child to go every week.
I can show the report, my lord. The reports are here, my lord.
Once a month.
Recommendation.
This is the Manamandira report. And he's not missed a single counseling session, he says. Not a single session he has missed.
No session. Please see the recommendation.
So one copy.
We've served it on. We've served it
on email.
Where do you get that it is every week? No, where it is mentioned that it's every week?
Sorry, Mala?
Where it is mentioned that it is every week she has to take session.
No, I'll just.
Feedback about the test so and so. You don't get any, it is not mentioned there that it is every week.
So prior to the report, the doctor said it has to be twice every week.
No, I think it's an oral advice, I'm told now. But that's okay, my lord.
My request for vacation.
So know how it is going on, vacation.
Very well, my lord. Children are extremely happy. I don't think there's any.
No, the daughter has some thing.
So what we do
no, I don't mind. Let that continue.
Whatever is happening.
Let it continue.
As per the arrangement, let it go
Let
on.
it continue.
And if the father wants to take the children anywhere in India, in the weekend, during this vacation, that he's at liberty.
15 days, anyway, he has custody. He may take it during that time.
No, even if vacation is another 2 days with that,
that's
3
okay,
days is also fine. What I'll clarify is, like during the vacation, father can, apart from the 3 days, if they're taking him out of Bangalore, another 3 days he can take.
15 days.
15 days.
We have 15 days.
15 days now. They
so that 15 is fine. More than that, you won't be. Only that I'll clarify that during that 15 days, he can take the children out of Bangalore.
I need at least the Aadhaar card photocopies to take them on a flight. I don't even have the Aadhaar card copy.
I'll give Aadhaar card photocopies.
I think.
I will give photocopy.
No, with Aadhaar card, you will not go to.
I know.
The.
Lord, they don't have Aadhaar cards. Some other
Whatever ID
identity
proofs
card will
should
be
there.
Yes.
The land council appearing for the mother submits that,
One
father
piece.
submits that, father wants to take the children out of country, which is for the land council, for the respondent, the senior council.
I'm sorry, my lord, that may not, because I filed an application, my lord, for permission. Because this should not become a bar, my
It
lord.
is submitted that the father, if the children, if the father wants to take the children out of Bangalore during the holidays, considering the submission of the land council for the father, in the, already the custody of the children is in the vacation 15 days with the father. And if he wants to take them out of Bangalore, and for another 3-4 days is required, on intimation to the mother, he can take the children. And why is it
Itinerary
pending?
may be shared.
I think, why is it pending now still here?
Lord, really, Lord.
I think it should go back.
The shade, both
I'm
parties.
wondering in some of the cases, 21, it will come in October, it will come in summer. Again, 22nd, it will come in Dasra vacation, and again summer vacation. Like that every year, on a pending G&WC, writ petition will be here only.
Correct.
Both parties have filed a shared parenting arrangement. Only the final order needs to be passed on post vacation. Your lordship may fix any date.
Pending
Yes.
disposal. Let it come after vacation.
Yes, ma'am.
This is matter.
Aadhaar card, Aadhaar card copy.
The Aadhaar card, oblique, any identity proof of the children shall be handed over. A copy of it shall be handed over to the father.
Lord, my request, Lord. The DV court may consider the maintenance.
The pending application before the, what is the case number?
CMS 170 of 2023, my lord. 170.
Criminal miscellaneous.
Criminal miscellaneous 170 of 2023, my lord. Pending before the
Write it on
first
a
amendment.
paper and give. Criminal miscellaneous so and so pending on the file of the so and so. The court shall dispose of the application as expeditiously as possible.
Applications. I have also fought for
No,
documents.
Everything.
The court has passed an order, but maintenance application will not be considered. without that.
Provided the orders passed by the court and all the documents are placed by
Obliged.
both the parties on the
Obliged.
court.
Grateful.
Serial number 12, for
Might I just make one mention on the previous matter, Lordship? Serial number 10, where Ms. Kothari has also appeared on the other side.
No, he
Lordship-
says he will leave it to my wisdom.
Your Lordship.
No, he was saying it.
No, that
I
is
will leave
true.
it to your wisdom.
We always do, Your Lordship. Only slight tweaking we are asking, Your Lordship. That atmosphere is not a great place. Can he be allowed to just take somewhere?
This is a case where if he wants anything, he's buying one more trouble. It's better not ask
I
for it.
understand. But maybe a public place like a mall or something, because the child is already in that.
Because,
Lordship, from where he
if
started
it is
to
another
where
6,
he is.
another 6 weeks it happens. I have seen the child. I had a lot of interaction with her. Right from the beginning till now, this father is not understanding what is the complexity of the situation.
I understand. But Your Lordship may kindly see, despite Your Lordship's order specifically stating who is doing and all of that, Your Lordship saw
Once
the
no,
one
no,
bald
once the
again,
report,
one report.
once the report, let your client have the patience for another the 6 sessions. Let that report come. Then we will decide what is to be
Lordship,
done.
actually nothing's happening there, Your Lordship. And in fact, he was pulled up. Why did you go and submit that? Do you know these girls are all postgraduates? Why did you go and complain? So in fact, they've gone against him for that fact that we
The
mentioned.
father has no other option but to go to NIMHANS. Because there is, even for every, I mean, it's a submission of everyone that that's the best institute in the city.
Your Lordship, might I at least ask if Your Lordship mentions that exclusive time alone without the mother's, because the mother doesn't allow.
That's what
Your
it is.
Lordship. Your Lordship,
She
that
can-
might.
But the girl has to stay with the father without the mother.
Your Lordship, she is worried every 2 minutes. She's checking, Your Lordship, and she takes her to a corner and fills her ear and then sends. Even for the sessions, she's doing that. Lordship, please.
What all the things the father wants, which the court cannot do.
No, I understand.
So further, what happens is court has to be there to monitor all
No,
that.
no. All I'm saying
Otherwise,
is,
how will it happen?
Your Lordship, he'll keep his mother present, Your Lordship. He'll keep his mother with him, Your Lordship. Then Your Lordship, they cannot make any. I understand where Your Lordship's coming from. Your Lordship's trying to protect his interest that further allegations don't come in. I'll ask him to keep his mother there with him, Your Lordship. Only all time alone, so that's all.
The father shall have. Where is she?
Your Lordship,
What about the respondent is not
I
there?
will inform Ms. Kothari, Your Lordship. We were trying to get in touch with her. I just entered in late. I'm really sorry, Your Lordship.
No, the order without their presence, it may not be right.
Please.
Friday.
Friday,
This
please.
is matter on Friday.
Obliged, deeply obliged.
Yes, next.
Friday.
Serial number 12.
Yes.
For the respondent husband.
Who appears for the petitioner? No representation on the last occasion.
Your lordships had listed this matter under the caption dismissal.
And there is no representation. It's already 5:27.
I'm at the hands of this court.
Friday.
Very well.
Under the same caption on Friday.
Immensely great.
For orders matter, serial number 13.
Lord, again for the petition, Lord. Lord, the objections by the officers that not have to deposit, make a statement of depositing up-to-date trends. Lord, my specific case is.
24 matter is moved now.
Now they have filed execution for, Lord, executing the order of.
So till execution is moved, no.
No, in fact, we moved it. We had actually, my lord, the objections complied with. Now, my lord, the office objection is that.
We will no time at 5:27.
I just sorry to, my lord. I'm
on Friday.
Friday, my lord.
14, yes.
Please.
14.
Friday.
We have calculated the amount. Pay and recovery order has to be, court order has to be.
Request to release the matter on Friday, my lord. So like we have managed to
What is that order? That in a case of death, calculation is made.
Calculation is
I will
already
pass
made.
orders. No, this.
Only pay and recovery order has to be.
That I'll do. Where is your appeal for pay and recovery?
No, liability fixed against the owner of the vehicle in that manner. Now it has.
He needs to pay and recovery.
Liability to be fixed on the insurance, my lords.
That's
Yes.
Friendly.
He's saying something in your favor. There is no pay and recover. Now, 1 and 2 are jointly and severally liable.
The exonerated tribunal has exonerated the liability against the insurance company.
Where is that? 1 and 2 are who?
Driver and owner of the vehicle. Third respondent is the insurance company. It is exonerated.
The petition again is respondent number 2. 3 is hereby dismissed. On what ground?
There is no permit. Deal. There is no deal.
DL is not there. Yes, please come. Agreed with the order passed in MVC number 7, award passed in MVC number 76 of 2013, dated 18 January 2017. The claimant is before this court seeking enhancement of the compensation and also questioning the liability fixed on the owner by exonerating the insurance company. Land counsel submits that the tribunal had exonerated the insurance company on the ground that the driver of the offending vehicle is not having a valid driving license to drive the vehicle. It is submitted that in the light of the law laid down in Saran Singh's case, even though there is no valid driving license, still the insurance company is liable to pay the compensation. Hence, in view of the same, the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, which year is this accident?
2013.
Accident has taken place in the year 2013,
my lords.
And the tribunal had granted the compensation as per the table given below. Extract the table at page 25. The accident
6,000 is taken.
Court had taken 6,000, and considering that this accident is of the year 2013, this court is taking 8,000. Considering the age of 34, future prospects comes to 3,200. That is 11,200. As how much has to be?
1/4 has to be.
As there are how many?
5.
5 claimants. 1/4 has to be deducted towards the personal expenses. That is 3,733, and his contribution to the family would be 7,467 into 12 into 16. Loss of dependency would come at 14,33,664. As there are 5 claimants and the head of, now it is 44, no?
Please.
5 lakh for 5 to 44. 2,20,000 towards consortium
33.
and 36,000 towards funeral expenses. And in the light of the law laid down in so and so, 10,000 towards legal expenses. Altogether, it comes to 16,99,664. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 10 lakhs
10 lakh,
39,000
lakh
to
49,000.
16 lakhs 99,664. The enhanced amount shall carry 6% interest. And the insurance company shall pay the compensation and record the same from the owner of the vehicle. Yes, Mr. Prasad, why you are not giving your this thing to 2-3 times? It has come up in the.
Yes, my lord.
Lok
Sorry,
Adalat.
my lord, because just now he joined, that's it. So 1
Yes,
month
next.
Cell number 15.
No, the specially listed matters will be taken up tomorrow.
15.
List number 3.
Okay.
List number 3 tomorrow. Yes, call the list. Tomorrow is Friday. Yes, next.
15.
We will see on that day because they are listed for a purpose. Yes, 14.
Serial number 21, Lord.
No, it will be called.
Cell number
And they have
15.
it after vacation.
List is called, only I'm referring to third list because only 3 matters are there in that I'm not taking up. So 14,
Cell number 14 completed.
oh, 15,
Memo is filed, paper application for R1, my lord.
memo for acceptance, accepted, notice
Please.
to so-and-so held sufficient after vacation. 16,
Records
My lord, I am for the respondent, my lord.
call for the TCR.
First respondent. My lord, court has received the report from Registrar of Allahabad High Court. Kindly see.
We'll have it after vacation. After vacation, 17.
Serial number 17. 17 KL Srinivas, non-furnishing
To
of
do the
process.
needful, a week's time is granted. Next,
Serial number 18.
After vacation.
memo is for checking dispensation of notice to R1 dispensed with. IA number 1 of 22 is filed to condone the delay of 596 days in filing. Condone on condition. Yes. 19. Admit post for final hearing TCR.
Number 19.
Yes.
19. Sanat Kumar KM, furnishing of process and cover for first time.
After vacation. And for steps to the owner, a week's time. Default order. Next, 20.
I appear for the petitioner in 20, my lords. File this petition seeking letter of administration in respect of the will. It's an undisputed will, my lords. The office has raised objection saying that the signature on the will does not appear to be that of the testatrix. My lords, the witnesses who have witnessed the signing of the will have
We'll
filed.
see it after vacation.
My
After
lords.
vacation. Next,
A date
21.
may kindly be assigned, my lords. A date may kindly be
A
assigned.
date on 19th of June. Yes, 21.
Much
Number
obliged.
21.
I filed my lord's application for recalling of the order, which is dismissed for non-prosecution.
482, 85 days delay.
Yes, ma'am.
After vacation, 22.
Serial number 22. Siddhappa BM.
Given IA for a withdrawal of the amount deposited by the owner, your lordship. For a withdrawal of this was the
Transfer of amount filed by advocate for appellant. What is this?
the matter got disposed on 13/9/24.
Oh, amount is in.
Amount is here.
This court had disposed of the, where is that order?
39.
This court has disposed of, the coordinate bench of this court has disposed of the appeal on 13th September 2024. It is filed by the owner of the vehicle. Owner of the vehicle. However, the order, in the order, it is not, the order portion is silent with regard to transfer of the amount. Hence, this application is filed. Accordingly, this IA is allowed and the registry is directed to transfer the amount to the tribunal. Yes.
Serial
Next.
number 23.
Deposited here, your lordship.
Here only, from here to tribunal it will go.
Serial number 23.
Or you want to withdraw here only?
Here only.
If for that, what is that application that you are seeking? Let go to the tribunal. Yes.
Serial number
23.
23. IA for substituted service.
Look at it. IA number 125.
My lord, I'm appealing for the appellant, my lord.
And so. Mentioning the date of, tell him the date.
26 June. 26 June for
Obliged, my
hearing.
lord.
Yes, next.
Serial number 20.
24 after vacation.
Seeking interim order. I'm filing application for interim order, please, ma'am.
Huh?
I'm seeking application for interim order. The execution petition has been filed, please, ma'am. Notice have been served.
This is an MFA of 2020. What interim order now?
Now they have served a notice in execution petition, please. That's why I'm
Now
telling.
we can't, no, what is, how can,
Yesterday I was
how
filed
can I stay for a 2020 matter now?
reasonable deposit kindly be ordered.
What are you doing from all through?
Please.
Without depositing any amount, without obtaining any stay order? Now you
25
want stay.
25,000 already deposited, please, madam.
What is the amount?
1,50,000, please, madam. Notice have been served, please, in execution. Please. Yesterday I was filed an IFR interim order, please, madam. Covered by the
Even the stay, IA for stay is also not there.
yes. IA is there, please, madam. Yesterday I was filed, please.
You filed in 2025 for a 2022 matter for stay.
Execution petition.
That's not the way. That's
Sorry.
not the way. When you file an appeal, you should seek stay.
Any reasonable condition.
Huh?
Any reasonable condition.
You deposit 1 lakh, then we'll grant stay.
25,000 already deposit, please.
Post after vacation. On the IA number so and so, on the condition that you should deposit 50,000
Oh, bless.
within a week.
4 weeks, ma'am, kindly.
No, already you had enough time. Deposit within week.
2
or
weeks.
No,
Kindly,
stay.
2 weeks, please.
Huh?
2 weeks, maybe.
50,000 within 2 weeks, or else the stay granted by this court shall stand vacated. Next 25.
25.
Yes.
Gautam Raghunath.
Your Lordship had permitted the mother to travel to Jaipur earlier for 3 days. Now the lower court has passed an order saying they don't have the jurisdiction, since Your Lordship is the one who's passed the order that we must come before Your Lordship to seek more time. This whole of May, if she's permitted to travel to Jaipur, her aged parents live there. The matter wherein even the husband stays in the same apartment, and I've already given the father's
order.
Please, Your Lordship.
The order so and so, the child comes down to the play area, the father can serve with him, and on that day no video call is permitted. Come down to the play, then on the day
Last
can
one.
have on every Sunday. Is not feeling well, the mother can take the child to Jaipur. She shall leave Bangalore on 1:10 and come back by 12:10.
Please.
Yes.
And the clause 6, Your Lordship. Whenever she wants to take the child out of Bangalore, that's maximum 3 days. It should be intimated to father in advance. Should intimate the father with those days to be compensated. Even during those days, he shall have video calls between so and so, so and so.
So what's the difficulty
Your
now?
Lordship, now she wants to travel to Jaipur. She's already.
Where is the application?
Your Lordship, yes. The trial court, we have filed it in the trial court. Trial court says I should see.
That order of the trial court.
Trial court doesn't release the order, though it was in March, but we have given an online copy, Your Lordship. Lordship, may kindly see page 19 and 20. Your Lordship. 20 is the main portion, the rest is the narration. Page 20, even during those days also, he shall have video calls between 7:30 8:30. Leaving the city shall not be on a regular basis. Above order, petitioner.
But court said three days, it is 4 weeks.
Please,
That
Your
was
Lordship.
agreed on that day. Now you wanted to go for 4 weeks.
At that.
No, even that point also.
No, no, that
she
was
said
without
She'll
application.
be going to Jaipur only for 3
That
days.
was, yes, that was when her
Whenever
parents.
she's going, that's what is the order.
Please, Your Lordship, that was when her father is bedridden, therefore she had sought. Now it is during this vacation period, she's already given the father morning to evening, entire March 31st to 14th of May. 15 days completed. Even these 15 days, in fact, she's allowed him to have the whole. So,
For the respondent.
Your Lordship, we've served already the other side.
So some HG Muniswamy Gowda.
We've served him also, Your Lordship.
We'll have it on
Friday, Your Lordship.
Friday.
Obliged.
This is matter on Friday.
Obliged.
Yes, next.
Serial number 26. Geeta Devi MP.
Here for the respondent, my lords, have filed an application. My lords. There are 2 applications, my lord. The first application, which is for modification, probably.
This also Friday.
My lords.
This also Friday.
Please,
Yes,
my lords,
next.
please.
Serial number.
Yes, 27.
Matters. Serial number 27.
This
Yes.
is a transfer petition, madam.
Filed
May be directed to serve the copy up to the other side council. Both suits are pending in. One suit is pending for 7th Additional Senior Civil Judge, Bangalore Rural District.
This also we have to hear Friday.
Now, it may be directed to serve the copy to the council who appear in the trial court.
Yes, the petition is permitted.
As well as issue notice to
hand
the-
summons, no, hand summons on the council appearing before the trial court.
Trial court.
And the registry is also directed to issue notice. Yes, next, 20.
The time may be fixed. Both suits are posted on second week of June.
This is matter
June
on
10th and 10th.
17th of June, next 28.
Before that, your 10th or 12th matters are posted before the trial
This
court.
matter on 6th of June.
Much.
Yes, 28.
Serial number
My lord,
28.
appearing for the petitioner in this matter, my lord. Petitioner is the wife, my lord. Transfer petition filed by the wife, my lord. She is
From where to
suffering
where?
health. Anekal is the place where the presently the matter is going on, my lord. But both the parties, my lord, are staying in Bangalore, my lord.
I think you should call the computer people when things are not working out. Not only that it's not working, they should be here. Tell them to be in the court.
Yes, my lord. May I continue, my lord?
Yes.
Yes, my lord. My lord, the wife is suffering from serious health ailments, my lord. She recently underwent surgery for both her eyes, my lords, and she
This is
has other.
MC of 2022. Now we will not transfer. Please
My
take
lord,
hands
my
up.
lord, no, my lords, even the matter has not even reached the evidence stage, my lords. The reason is that, my lords, she is not unable to go there, my lords, and even the legal aid counsel who is assisting her in Anekal is
Notice to
not.
the respondents, petition is permitted to take out hand summons on the
My lord,
counsel appearing for the respondents. If the notice, the memo is filed, list this matter on 4th of June. Yes,
Stay, my lord.
29.
Stay, my
29.
lord.
29. Preeti G.
Milords,
This is
I'm for the petitioner in this case, Milords.
Yes. Yes.
Milords, yes, Milords. Milords, the petitioner has filed for a transfer of MC petition from Bengaluru to Chikmagaluru, Milords.
What is the distance?
Milords, it's up to 250 to 270 kilometers, Milords.
Which is MC?
Milords?
The present petition is filed seeking transfer of MC number so and so. MC number 3258 of 2024 pending on the file of the first edition Principal Judge Bangalore to Principal Judge at Chikmagalur. There is submitted the distance between both the places is 25 kilometers and difficult for the wife to travel. There shall be stay of all further proceedings. Hand summons on the council. And
Milords, seeking stay in MC proceedings, Milords.
15th of July, if it is filed, list this matter on 16th, or else the stay granted by this court stands vacated. 30.
Serial number 30.
Petitioner is the wife, my lord. She is seeking transfer from Mysore to Bangalore, my lord.
Mysore to?
Mysore to Bangalore, my lord.
Which year is the MC?
2025, my lord.
Yes, Mysore to Bangalore, more than 100 kilometers. Same dates.
And also she is having a child, my lord, 1 year child.
Yes.
31.
Stay.
Stay, I to Serial
Yes,
number
next.
31.
Whatever petition in this case, it's also council petition. The council petition, Mysore to Bangalore, my lord.
Mysore to Bangalore. Yes, same. Well, which year is the MC?
24 minutes. I received notice on.
Yes, same order.
Serial
Next
number
32. 32. After vacation.
Serial number
33.
33.
I am appearing for the respondent, my lord. Climate appeal for enhancement, my lord. Case of injury, my lordship.
Case of?
Case of injury, my lord.
After vacation. Next
Please.
34.
Serial number 34. Radha.
After
JMC.
vacation. This
Serial number
35.
35. 35. K. Suresh.
After vacation.
Serial number 36.
For the appellant, my lord.
Second respondent. J. Kumar.
Lordship has already coming to the conclusion, my lord. In first case, my lord, 20,000 with 6%.
30?
36, my lord. There are two connected matters, my lord. We have already arrived the calculation, my lord. There is a 80% against the Reliance General Inspection, 20% against the Sriram General Inspection.
We need to pass orders.
Pass now.
A part heard on Friday.
Please.
Yes, next. On Friday, we'll pass orders. Yes, 37.
After vacation, my lord, kindly detailed consideration is required, madam, in this. Kindly please after vacation, my lord. Because bunch of matters are, 8 matters are there.
It has been heard. It has been heard.
Friday, we don't have much matters. We'll hear on Friday.
Hello, kindly peruse, my lord. Because, why? Because.
No, we'll hear it. It can happen on Friday. Why not? We should feel
I
happy.
will not be in session. I have some other rearrangements are there.
After vacation.
Please, much of
The request of non-counsel, the respondent. Yes, 38.
Serial number 39. 38.
38, my lord, we are offering that in addition to 4,01,850
28. We are offering 10,36,118.
It is submitted. This what we do is I'll have it
Friday, madam.
Friday before the court, and if they I mean once they appear, we'll have it in the local adalat in the evening itself. So it is submitted that the insurance the RTC is ready to pay an amount of rupees
10,36,118, madam.
10,36,118 in addition to what has been awarded at 6% interest. Interest
Inclusive
is
of
there?
interest.
Inclusive. 10 lakhs is 36,118 lump sum. The list is marked up on as part third on Friday. Next 39.
Cell number 39.
At 39 also we have an option.
N. Kumar.
Two options, my lord, 5,95,000 plus 6%. If they don't agree, my lord, 20% negligence, my lord, come to 4,96,000.
5,96,000.
5,95,000 plus 6%, my lord.
So this also part third. It is submitted that they're ready to pay an amount of rupees 5,96,000 with 6% in addition to what has been granted, or
4,96,000.
86,000.
4,96,000.
96,000. What is that? That is without interest. That is with interest or without?
Plus 6%.
Plus interest. Yes.
Cell number 40.
Yes, 40.
As part third.
Well, provided
40.
negligence is taken at 80%, my lord, because the 20% has to be on them.
And if the negligence is taken at 80% in a matter. Yes, 40.
Cell number 40.
After vacation, my lord.
After vacation. 41.
41. Cell number 41. K. Shashikant Prasad.
Yes, Mr. Sivanagoda. 41 is your matter.
V. Shivanya Gowda.
Friday, 41. Yes, 42.
42.
My lord, I am for the respondent, my lord. My lord, it requires enhancement of compensation under the only, my lord, conventional head, my lord, kindly.
What was any amount?
My lord, total amount, my lord, is 6,11,400.
No, your office is here in the court, I'm
Yes,
asking.
yes, my lord. Yes.
Yes. After vacation. Yes, 43.
Cell number 43.
After vacation.
43 after this. 44 Jen. 40. 44 again.
They have challenged the negligence part.
40? Huh.
They have challenged the negligence part.
Oh, contributory negligence is it. So 44 after vacation. So we'll ask him to come. Look at this then. No?
One submission, my lordship. Second list, second is pass over.
Let it come on Friday. Let it come on Friday. I'll come in 10 minutes. Till that matter on Friday.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Serial number second list serial number 34 reach ಆಯ್ತಾ?
ಎಲ್ಲ ರೀಚ್ ಆಗಿದೆ ಹೇಳಿ ಸರ್ ಏನ್ ಬೇಕು.
Serial number 34 ಏನಾಯ್ತು ಮೇಡಮ್?
ಸರ್ ನಾವೆಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ, ನೀವು ನೋಡ್ಕೊಳ್ಳಿ. ನನಗೆ ಇವಾಗ ಲೋಕ್ ಅದಾಲತ್ ಸಿಟ್ಟಿಂಗ್ ಇದೆ. 34 ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗಿದೆ.
Okay, okay madam, thank you.
Court officer. Court officer. Court officer. Court officer. Madam. Madam.